Aruna said mentioning.
Lord, I'm here, Lord. I'll start. No, Lord, I'm not mentioning, Lord. I'm here, Lord, to apologize, Lord, for a matter, Lord, I mentioned yesterday, Lord, not knowing that it was already in the list, Lord. My juniors did not tell me, Lord, I mentioned as it an unlisted as a matter. Lord, I apologize, Lord. I have not cautioned my juniors, Lord, that, Lord, your Lordship's officers have been informed, Lord. Lord, I apologize, Lord.
Thank you.
I should not have mentioned, Lord.
My Lord, this is a matter which I had mentioned on 9th of September. It's a very old 1983 application. The records were reconstituted, and my Lord's officer had called me to check up the records are in very terrible condition. And I had seen the records. If my Lord directs me, my own copy is a change, and it's also in a very bad state. I will leave it to my Lord's direction. I have given notice to Mr. Gagar, senior Mr. Gagar, who was appearing in the matter. He is also there. I am in Kadikaman.
Okay. $332 has already been disposed of. Matter number 183, records cannot be traced out.
That's a reconstituted record. Even in my copy, my Lord sees it's in a terrible state of affairs. Again, it came as a change tweet from Mr. Maskara, who is no more.
You mentioned I'll pass necessary directions. In the meantime, you can prepare and give a copy to them so that I'll pass directly an order that it may be reconstructed. Please do that. When should I keep it? After the vacation?
I'll keep it for Monday. Meanwhile, I'll.
Very good. Then it will appear as to be mentioned on Monday. Yes, sir. Out in the
My Lord, there was in this matter there was an order which was passed by my Lord Justice Bahulal Jain, and I can pass that order which will give a matter number. I can only access to that effect, and I can't.
No, act number. Was to trace out matter number 183, 1993, something. If it is not traced out, I have directed him to put it on the list under the EC because it has to be listed. Otherwise, it cannot be listed even. So, whatever way, it will be listed on Monday. Thanks. Yes.
And kindly monthly list item number 294 for upgradation. My Lord, just 30 seconds, my Lord. I have a 12 crore.
30 seconds is too much. Take 5 seconds.
15 seconds.
Yes.
My Lord, 12 crore debt. I
am dealing with 50 crores. Please don't show 12 crores.
Action for 6 crores. Kindly, it's pending for 2 years, my Lord.
Cannot make an exception because I am not being able to touch the matters in the list also. No. These are useless upgradations. No. No, not the matter is not useless. But the upgradation is useless because I cannot reach in any event.
More useless.
No, sorry, no. Yes.
My Lord, kindly leave be granted to draw and complete your Lordship's order dated on 5th
Yes.
August. Thank you.
May I, my Lord, leave to mention item number 39 of my Lord's list today, my Lord.
Same answer.
No, my Lord, if I may just indicate, we file an application for expeditious disposal of a Section 11, my Lord. The Section 11 relates to a project in respect of which arbitration has already commenced under the letters of award. And the arbitration is continuing, my Lord. Issues have to be framed on 29th of September. My Lord, the next date has been fixed on 29th of September. My Lord, they are saying that this agreement under which the Section 11 that we have filed does not exist, has not been given effect to. Therefore, my Lord, this agreement has to also be referred to the same arbitrator. The arbitrator is also has said that
agreeing. Both sides are
agreeing, my Lord. They have filed their
take some time.
opposition.
How can I upgrade it? If it takes some time, I cannot.
The application for expeditious disposal, my Lord, if that could be listed urgently, or my Lord,
I'll dispose of that and direct it to appear on some day of my choice in any event.
If,
which will be after vacation definitely.
my lord, if before the
It's
vacation.
better
is
to keep it as it is. I mean, item 29 is the application for
Item
expiration.
39, yes, it's
39.
the application for expeditious disposal, my lord.
Whenever I reach it, I may take up if I can reach it actually, give a notice to the other side that it is appearing in the list, I may take up the main section 11 also. So let us not be on the expeditious disposal applications. Does
Very
not
well,
mean
my lord.
anything extra.
Because the issues are to be framed on
It does not
29th.
waste time. No upgradation. Yes.
But may I be permitted to mention, my lord, by an order dated 16th of January 2023, my lord, I was directed to furnish counter guarantee to my lord, withdraw the amount that was deposited by the award data for stay of execution proceedings. Now, my lord, the counter guarantee was, my lord, renewable year to year. My lord, now, my lord, the counter guarantee that was deposited, my lord, prior, my lord, has already expired, my lord. My lord, I'm seeking leave, my lord, to file, my lord, furnish the counter guarantee.
Give a notice, it will appear as to be mentioned. Give a notice to the other side that it will appear as to be mentioned on Monday. No, I'll proceed this way. Yes. Yes. Oh, sorry. Yes. You want to mention?
My lord, the only thing which I wanted to say before this on the court was if the chamber applications, new chamber application or execution applications which are coming for the where either notices are required to be given to the judgment debtor or where the matters could be disposed of very fast. They may be taken up on any day before the application so that three orders which would be otherwise be given. There are a lot of chamber applications which have been are pending before the court, and I would be
Very well. Next Thursday, I'll keep those new chamber applications before the examination of judgment debtors. ঠিক আছে? আপনাদের বলছি। Yes, please. Not before vacation. How can I? Yes.
My lord, as per my lord's order, my lord, today it is appearing as item number 22 in my lord's list, my lord. My lord we got the wakalatnama, my lord. It is ready to file, my lord. Bus ad is written in the order, my lord, that it to be filed within a week. But we got this wakalatnama after a week, my lord. And from last week, we are trying to file it, my lord. But they are saying that it is written in the order until and unless you are not taking the leave, my lord. That is the.
This will appear as to be mentioned tomorrow.
Oh, and my lord, there is like till today, my lord, warrant of arrest is stayed, my lord. That to be taken care.
No, warrant of arrest is stayed till today.
Yes, my lord, 26th of September. And it is appearing in
Give a notice, I'll take it up at 2. First thing at 2, I'll take this matter.
22.
Please give on a slip of paper, please write it. Because otherwise something should be on record and give a notice to the other side. Yes.
My lord, mentioning for inclusion, the application is filed on 24th.
What is the application under?
Under
Section?
removal of an arbitrator. 9. Removal of an arbitrator.
Handover, it will appear in the list. Yes.
Leave to file G application for limitation.
Limitation for filing what?
Arbitration appeal under section 34.
34. Very well. Leave is granted. Yes. Contempt in the original side. Come back tomorrow. When I take up appellate side matters, mention appellate side. Call on the list.
Commercial division to be mentioned, item number 1, National Insurance Company Limited.
Yes, Mr.
I am for the award data, my lord, the petitioner in section 34 application. I believe this has come at the instance of the award holder.
What is this application for?
For extension of time to renew the bank guarantee. Because they had given the bank guarantee and withdrawn the award money.
Let them come and move it, Mr. Datta. They should be there. It would be too much to. Even if it was restoration, I could have considered, but let them come. I'm just making it not today, Mr. Datta, so that you don't have to wait indefinitely.
The Lordship, this will be in the list tomorrow?
Yes. একটা line order record করো, none appears for the petitioner, although the You are for the award debtor, you said.
Yes,
None
national
appear,
insurance.
right. None appears for the award holder, although the award debtor is represented through counsel in court. First of let the matter stand adjourned till tomorrow. Please come.
Lordship, deeply.
Item number 2, Grow Capital Limited.
This is in this matter, my lord, all the matter 2 to 4, 5 is the 2 years old, my lord. We need to serve notice upon the award debtor. I am praying only direction, the order under order 21, rule 22, sub rule 1 to be given to the department to see notice, my lord, upon the award debtor.
আলাদা আলাদা অর্ডার হবে 2 to 4. 2 to 4. Since the exec 2 to 4.
2 to 5, my lord. 2 to 5.
Oh, 2 to 5, 4 you said.
So sorry.
2 to 5, sorry. Yeah. The execution case has been filed after 2 years. First of accordingly, notice do issue under order 21, rule 22, within bracket 1 of the Code of Civil Procedure. First of, you have to put in requisites for that.
Yes, my lord.
So requisites in that regard shall be put in by the award holder by tomorrow.
Returnable, my lord.
The matter shall be listed next on November 21, 2024.
Good.
Examination of judgment debtors, item number 6, Cholomandalam Investment.
In item number 6, my lord, Mr. Parthasarathi Devmarman is appearing, my lord. He's just coming, my lord.
Your Lordship, I was also seeking a short pass over. Your Lordship, on the last occasion, my learned senior friend had taken a point of unilateral appointment, and we had contended that it is a waivable bar under section 12(5), and we had also contended that this can be only taken in a point of this point can be only taken in the application under section 34, but there's no section 34. Your Lordship will satisfy. Mr. Rituban Sarkar is leading me in this matter. Your Lordship, exhaust the commercial list. We'll
No password. That will be uncertain. So
Yes,
I'll
Lordship,
make it
that
not
will
to
be certain. He will be here in 5 minutes, Your Lordship.
In earlier occasion, we have prepared, my lord, opposition. Your lordship directed to file reply. Till the date, my lord, no reply has been filed by the.
We will not be filing a reply. Your Lordship will just.
Another thing, my lord, your lordship fixed this matter on 23rd of this month. This matter appeared in the list under, my lord, chamber application final disposal. Till tomorrow, my lord, yesterday, my lord, this matter was appeared under the same heading. But today, my lord, is appeared under this heading, my lord.
returnable separately under this heading.
Yes.
This execution head. A case.
There was a separate order passed in the execution.
No, then not today. The parties seek an adjournment. Let the
Your
matter
Lordship, kindly
stand over
not-
for the day. No. যা আছে তাই থাকবে. Call on the next.
Item number 7, Kotak Mahindra Bank Limited.
Yes.
Your Lordship, judgment letter number 3, Mr. Dhiman Banik was being examined, and he was examined in part. And Your Lordship, he was supposed to give certain documents.
Documents have not been given.
No, Your Lordship. Till date, we have not received the documents. I'm not in a.
What about the documents?
He has not submitted till now.
Your Lordship, the judgment letter number 3 was supposed to give us the.
If they don't give the document, I'll draw adverse inference.
Your Lordship.
Move over, proceed with the matter. You can ask questions. So I don't want to suggest anything. You can ask question on the documents also.
Ask him a question.
আপনার নাম কি?
হিমান বণিক।
এর আগে এসেছেন আপনি? নাম বলুন।
হিমান বণিক।
হ্যাঁ। ধীমান
বণিক।
বণিক। ধীমান বণিক।
Mr. Bonik, have you recently gifted any property to your daughter?
Yes.
Please state me the years or year when you have gifted this property.
ম্যাডাম, এই জমিটা যে মানে আমার বোনরা যে আমাকে দিয়েছিল, তখন একটা যেহেতু আমার স্ত্রী যখন নাকি ক্যান্সারে আক্রান্ত,
Please give me the year.
আপনাকে সাল জিজ্ঞেস করছেন।
এই মাস
কবে gift করেছেন?
তিনেক হবে, হয়তো মাস 2-3
আগে।
হ্যাঁ, মেয়েকে আমার যে অবিবাহিত মেয়ে আছে তাকে আমি দিয়েছি।
So it happened in 2024.
হ্যাঁ।
I have gifted the property to my unmarried daughter 2 to 3 months ago.
So
বোনদের কন্ডিশন অনুযায়ী।
As per the conditions of my sisters.
Done. So the transfer happened in the year 2024.
এই যে
হ্যাঁ
গিফট
হ্যাঁ
করেছেন এটা 2024-এ হয়েছে
হ্যাঁ
তাই তো?
হ্যাঁ হ্যাঁ
Did any transfer happen in 2018?
2018-তে এরকমের কিছু গিফট করেছিলেন?
ওকে
হ্যাঁ সেটাই জিজ্ঞেস করছে।
না
নো।
I put it to you that this transfer have been done in order to avoid to pay the dues of the award holder.
না আমি সেরকম পাইনি যেহেতু এটা
প্রশ্নটা বুঝুন।
ও আচ্ছা
আপনি যে এই যে গিফটটা করেছেন সেটা ওই যে জাজমেন্ট ডেটার কোম্পানি আছে ওইখানে টাকাটা না দেওয়ার জন্য আপনি এই
না
গিফটটা
না
করেছেন।
না না
আই ডু নট এগ্রি। আগে প্রশ্ন বুঝবেন, আগে
আচ্ছা
আগে উত্তর দেবেন।
সেরকম কোনো মোটিভ না যেহেতু মেয়েরা অবিবাহিত
I do not have any such
আমার
motive
একটা ভুলের
because
জন্য
my daughter is unmarried.
Was a gift deed executed?
ওই যে গিফট ডিডটা ছিল সেটাতে সই সাবুত রেজিস্ট্রি এগুলো হয়েছিল?
হ্যাঁ হ্যাঁ
ইয়েস।
Why is such I put to you that you have intentionally not stated about such transfer in your affidavit of assets.
এই যে আপনি সম্পত্তির হলফনামা দিয়েছেন ওই হলফনামাতে আপনি এই গিফট ডিডের বিষয়ে কোনো উল্লেখ করেননি ইচ্ছাকৃতভাবে।
না সেরকম কিছু ছিল না ব্যাপারটা হচ্ছে যে বললাম আপনাকে যেহেতু আমি
I do not agree. There was no such intention of mine.
এরকম কোনো ইয়ে
ঠিক
ছিল
আছে,
না
বলে দিয়েছি।
What is the valuation of the property that has been gifted to you to your daughter?
আপনি যে সম্পত্তিটা দান করেছেন সেটার মূল্য কত হতে পারে?
এটা আমি বলবো কিভাবে বলেন ম্যাম এটা তো আপনারা ভ্যালুয়েশন দেখলেই বুঝতে পারবেন
I cannot say.
Can you produce the valuation on the next date?
আপনি সেই
ভ্যালুয়েশন বলতে গেলে আমি
আপনি প্রশ্নটা আগে শুনুন তারপর উত্তর দিন।
হ্যাঁ
ইয়েস
সম্পত্তির ভ্যালুয়েশন দিতে পারবেন? কত সেটার সম্পত্তির ভ্যালু সেটা দিতে পারবেন? সেটা জিজ্ঞেস করছি।
হ্যাঁ ভ্যালুয়েশন
নেক্সট ডেটে আসবে।
হ্যাঁ অবশ্যই তাহলে আমাকে
Yes,
তুলে
I
নিয়ে
can.
আসতে হবে ভ্যালুয়েশনটা তুলে নিয়ে আসতে হবে হ্যাঁ হ্যাঁ হ্যাঁ
ভেঙে যাচ্ছে।
আচ্ছা আচ্ছা
Mr. Bonik, you are a guarantor to this loan agreement, and therefore you are jointly and severably liable as the borrower. How do you intend to pay back the loan amount, awarded amount?
এই যে লোনটা নেওয়া হয়েছে এটাতে আপনি গ্যারেন্টার, ঠিক আছে? তো আপনারও সেই একই দায়বদ্ধতা আছে ওই লোনটা ফেরত করার। যেমন যে লোনটা তুলেছে তার যেমন দায়বদ্ধতা আছে লোনটা ফেরত করার, আপনারও আছে। আপনি এখন কিভাবে এই লোনটাকে পরিশোধ করবেন সেটা বলুন।
ম্যাম এই জায়গাটা আমি একটু একটা সেকেন্ড একটু যদি কথা বলার সুযোগ দেন তাহলে ভালো হয় আমি বলতে পারি কি বিষয়টা হচ্ছে যে আমি কিন্তু অ্যাকচুয়ালি আমি জানি না এখানে হয়তো কোর্টে বিশ্বাসযোগ্যতা হবে না কিন্তু সম্পূর্ণভাবে ওর বাবা যে বয়স্ক মানুষ তার কথা এবং যারা নাকি আপনার নিয়ে গেছিল কাগজটা আমাকে বলেছিল যে এটা কোনো ব্যাপার না উনি ওনার মতো শোধ করবে এটা জাস্ট আপনি একটা সই করা আমাকে একটা ওয়ার্ক অর্ডার নিয়েছিল
As per the
বয়স্ক মানুষ সেই হিসাবে আমি বিশ্বাস করে এটা করেছিলাম আমার জীবনের একটা বড় ভুল
এক মিনিট as per the words of my father and the persons who had taken the documents I তারপরে বলুন যারা
আমাকে
নিয়ে গেছিল।
একদম টোটালি জাস্ট বলেছে যে এটা হচ্ছে আমি যেহেতু তখন জাস্ট একটা কাজ শুরু আমার একজন মুদি দোকান তো আর ওরা সব থেকে বড় কথা আমাকে কোনো রকম আমার যে আর্থিক ক্ষমতা আছে কিনা মিনিমাম সেটুকু জাজমেন্ট করেনি যে আমি যদি গ্যারান্টার হই আমার তো একটা জাজমেন্ট আমার তো ক্যাপাসিটি থাকা চাই যে আমি টাকাটা দিতে পারবো কিনা
আচ্ছা কি লিখেছে? হ্যাঁ I believed them I have a grocery shop, and they did not even consider that whether I could pay back the loan amount or not. I, with my full heart, believed those persons.
How do you want to repay the amount back?
আপনি কিভাবে সেই লোনটা পরিশোধ
ম্যাম
করবেন
আমার
সেটা
এই
বলুন।
মুহূর্তে আমার তো সেরকম জায়গা নেই, তবে ওর সাথে কালকেও গতকালও কথা হয়েছে যে গাড়ির ব্যাপারটা ছিল, সেটা কথা হয়েছে। কালকে আমি ওকে নিয়েই অফিসে গেছিলাম, যাওয়ার পরে গাড়িটা
আপনাকে
আজকে,
জিজ্ঞেস করছি
হ্যাঁ আমি
কিভাবে
বলছি
পরিশোধ
বলছি
করবেন।
আমি
একটু
ঠিক
ছোট করে বলুন,
ছোট
এত
করেই
বড়
বলছি।
করে কিচ্ছু যাবে না।
গাড়িটা হয়ে গেল, অফিস থেকে বলেছে বাকিটা বসে কথা বলে নেবে, সেটাও একটা কথা হয়ে গেছে। আমি নিয়ে গেছিলাম।
I had a talk with persons in the office, and we had agreed to কি agreement
ওরা
হয়েছে?
যে একটা ওর একটা গাড়ির ব্যাপার ছিল আগের দিন, ম্যাম আর কি একটা গাড়ির ব্যাপার ছিল, সে গাড়িটাও রিটার্ন করে দিচ্ছে, আর দিয়ে তারপরে আপনার ওদের সাথে বসে মিউচুয়াল করে নিচ্ছে।
That
সেটা
the
কথা হয়েছে অফিসে বসে,
the vehicle
ফাইনাল কিছু না, কিন্তু একটা কথা চালু হয়েছে। আজকে আর থাকলে
initial
একটু
talk
জিজ্ঞেস
of
করতে পারেন,
কি ছিল ওটা initial
একটা কথা চালু চলছে।
initial talk with the persons, তারপরে office, the vehicle, they will take the vehicle, and then
যে গাড়িটা নিয়েছে যার কাছে রয়েছে,
the hypothecated vehicle, and then will sit for mutual talks about the matter. গাড়িটা নেওয়ার পর আবার বসবেন, তাই তো?
হ্যাঁ গাড়িটা
ঠিক আছে।
ওরই তো, এই যে রয়েছে, তারপর আবার বসে মিউচুয়াল করবে।
I put to you that you all had offered an amount of 6.5 lakhs as settlement, which has been outrightly rejected.
আপনারা 6.5 লাখের একটা অফার দিয়েছিলেন, যেটা
না সেটা এখনো ফাইনাল হয়নি।
আগে শুনুন,
না
যেটা
অফার,
উনি যেটা বলছেন আগে
আচ্ছা
শুনে নিন, সেটা রিজেক্ট করে দেওয়া হয়েছে সে অফারটা, হ্যাঁ বা না?
না সেরকম গত পরশুদিন গেছিল, তাই তো? গত পরশুদিন ম্যাম সেরকম কোনো কথা হয়নি, কিন্তু রিজেক্ট কিছু হয়নি,
On
আলোচনা
day
চলছে।
before yesterday, we had gone there, but no such kind of thing had happened.
ওনারা 7+ বলেছে, ও 6.5 লাস্ট উঠেছে।
They asked for 7 lakhs or more,
আর ও সেখানে 6.5 বলছে।
ওটা কে, নামটা বলুন।
নাম
কৃষ্ণ দেবনাথ।
ওকে দেখিয়ে তো লাভ নেই, আমরা দেখতে কাগজে দেখাটা লেখা হবে না, নামটা বলুন।
and he, that is
কৃষ্ণ দেবনাথ,
Devnath agreed to pay rupees 6.5 lakhs.
What is the profession of your daughter?
আপনার মেয়ে কি
মেয়ে
করে?
পড়াশোনা করছে।
She is a student.
এবার আপনার ওই জেন পাসেও চান্স পেয়েছে, আবার আসানসোল যেতে হবে।
So how are you financing the studies of your daughter?
আপনি আপনার মেয়ের পড়াশোনার খরচা কিভাবে চালাচ্ছেন?
তো গভর্নমেন্টেরই তো।
She studies
গভর্নমেন্ট
in an government institution, in a government institution.
I put to you that the transfer of the immovable property that has been done to your daughter is a fraudulent transfer.
যে গিফট ডিডটা আপনি আপনার মেয়েকে করেছেন, সেটা ভুলভাবে ট্রান্সফার করা হয়েছে।
সেটা আমি বলতে পারবো না স্যার।
I cannot say.
Lordship, let him give his documents. Other than that, we can't proceed.
If it doesn't give the document, then we'll have to proceed on that.
Then, Lordship, I will be praying for a civil imprisonment because he has been doing a transfer of the property in order to defeat the legitimate use of the award holder.
Ask him to put a question to that effect. I mean, regarding these documents to be produced.
I mean, sir,
দাঁড়ান দাঁড়ান
documents নিয়ে এসছি।
জিজ্ঞেস করছি আপনাকে দাঁড়ান
Supposed to give the title deeds, income tax return.
The question, let him answer. If he produces the document, go through those.
Are you in a position to produce the title deed of the property?
আমি পর্চাটা নিয়ে এসছি।
I have brought the Khatian of the property.
পর্চাটা পর্চায় যাবে।
Are you in a position to produce your income tax return?
আপনি
না, ওইটা আনতে পারিনি।
I could not bring
ব্যাংক
that.
ব্যালেন্সটা নিয়ে এসছি,
I
ব্যাংকের
have
এটা।
I could not bring my IT documents of IT return. I have brought my bank statement records.
Is this the bank statement of Punjab National Bank?
Yes.
Please produce it. For how many years is this passbook statement?
কত বছরের
হচ্ছে
আপডেট?
কারেন্ট অ্যাকাউন্ট, আর একটা হচ্ছে আপনার আপনার ইয়ে ওই লোন অ্যাকাউন্ট।
One statement is of
ক্যাশ ক্রেডিট অ্যাকাউন্ট একটা।
current account and another is of cash credit account. আপনাকে সাল জিজ্ঞেস করতে
1.5 বছর 1.5 বছর 3 বছর চেয়েছিলাম, আপনি বলেছিলেন
কবে থেকে কবে সেটা বলুন।
গত বছর আর এই টাইম পর্যন্ত 1.5 বছর পর্যন্ত দিয়েছে, আর 1 বছর দেয়, 1.5 বছর পর্যন্ত দিয়েছে।
23-24
হ্যাঁ
2023 to 24.
Lordship, I'm done.
So any further examination?
Lordship, on the basis of these documents, I have to make some further examination to him. Lordship, in that case, I will be praying for an injunction on the bank accounts because the balance shows to the. What is the grand total? That is, the balance is showing as 9,54,356.
What is your claim?
না নেই।
আপনাকে জিজ্ঞেস
ও
করতে না।
আচ্ছা আচ্ছা।
Please ask him to get down from the box.
আপনি নেমে যান।
Yes.
My claim is 42,42,556.
You won't be able to have a livelihood. If the bank account is, an injunction is granted, what will you eat? No. Should I refuse that formally or would you not make that prayer?
Lordship,
You should make that prayer. I think.
Lordship.
So this evidence is concluded, that deposition, or you want to examine him further on this?
Lordship, he has two accounts. He has given two accounts. One has a balance of.
I won't advise you, Ms. Das. Either you cross-examine him further or not. Tell me that, I'll put it in my order.
Lordship, give me one more date for examination.
I'll put it after the vacation then.
Lordship.
And
Lordship, I will also ask for the title deeds. This is not sufficient.
The witness is awarded a number?
Three.
The award data number 3 is further examined, full stop. For further examination, comma, the matter shall be listed on November 7, 2024, when the award data number 3 shall be personally present for being so cross-examined, full stop. Learned counsel for the award holder seeks a direction on the award data number 3 to produce the title deeds pertaining to the relevant properties, full stop. Accordingly, the award data shall serve advance copies of the said title deeds through his learned advocate to the learned advocate for the award holder before October 4, 2024. Full stop, next para. Please do that. Title deeds before October 4th.
Yeah, my lord. He's going out of his station to bring his daughter, my lord.
He'll give the documents before that, before he goes out. So what's the fun in that? He goes out, stays in, goes somewhere else, stays there. We are not interested at all. She wants the documents. I have recorded that. I have directed you to produce those. Unless you produce those, then there will be adverse inference. He may go wherever he likes. There is no arrest order.
My lord.
Learned counsel for the award holder also seeks an injunction on the. Please ask him to stop talking. Otherwise, he'll be sent out of court, or I may take further action also. He's speaking too much. Learned counsel for the award holder also seeks an injunction restraining the award debtor number 3 from operating his bank account, the statements of which have been produced in court today and handed over to the learned advocate for the award holder. Full stop, next para. However, it transpires that the account, it transpires that the current balance in the account is somewhere around rupees 9 lakh, whereas the claim of the award holder is in the range of rupees 42 lakh. Full stop, next para. Since in any event, the amount lying in the bank account is grossly insufficient to meet the awarded amount, and more importantly, keeping in view the fact that in the event an injunction restraining the award debtor number 3 from operating his bank account is passed, he may be without any means to sustain himself and his family, such prayer is refused at this stage. Thank you. It will come up on whenever I direct it, November 7th. Yes. If you don't if he doesn't give the documents, we will take adverse inference. You know the law. Next.
Item number 8, IDFC First Bank Limited.
Here for the award holder, my lord.
Yes. So I try to conclude today.
Yeah, I'll try to conclude it.
Because it's coming every day.
Well, I'll be very candid, my lord. From the tenor as well as the contents of the examination, we'll be pressing for a civil imprisonment, my lord. Because he's been disposing of the property.
Whatever. You just
So I don't think that I will have anything to ask beyond this. I will try to conclude it today itself.
Thank you.
একটু স্পেলিংটা দেখুন অরিজিৎ বোস
Mr. Bose, I see that there is a pair of keys hanging in your pocket. Could you please tell the court what the keys are for?
Mr. Naik, this question will not.
Lord,
You
I
cannot
would
do
have-
this.
Lord, I'm in cross, my lord. I would be entitled that there's no bar, my lord.
No, whatever is hanging in his pocket,
My lord, it's there.
it's not a part of the documents which are on
Yes.
record.
My lord, which is precisely, my lord. There's no
No,
bar.
I'll record this. Learned counsel asks, learned counsel for the award holder asks a
Lord, may I just
question.
make a submission before your lordship passes that order, my lord? May I just
Yes.
make one submission? My lord, in cross-examination, lordship would be aware of the law better than I am, my lord. I am not restricted by either the documents or the pleadings. I would be able to ask a question from the tenor of the witness who is in the box, as well as from any other circumstances, my lord, that is, or the questions that have been answered prior, my lord. I'm not barred. There is no restriction that the law imposes on me, my lord. If I'm barred from making that question today, my lord, I would not be able to make a because he's not disclosed whether that's a vehicle. It does not appear to be in the documents either. So today, my lord, if I do not pose that question, he would, my lord, have the luxury of getting away with it.
Right.
Yes, yes.
Learned counsel for the award holder seeks to put a question to the witness regarding the keys hanging from the pocket of the witness, the question being as to what are the keys what are the keys, what are the keys
for?
of, what are the keys of, full stop, next para. However, the court interdicts, since in the opinion of the court, the said question cannot have any direct bearing on the matter. Full stop, next para. At this juncture, learned counsel for the award holder submits that it is well settled that in cross-examination, the party asking the questions is not fettered by the previous answers and stroke or the materials on record or documents on record, but for the purpose of eliciting relevant information, is entitled to ask any question. Full stop, next para. However, since the keys hanging from the pocket of the witness are neither a part of the records, nor have been referred to at any point of time, such question would be a direct invasion on the privacy of the witness. Full stop. In any event, whatever personal belongings a witness may carry, merely because he is exposed to cross-examination, the parties or the court are not entitled to compel him to answer queries relating to materials which are not even referred to in the pleadings or in prior evidence and or are not in any manner a part of the hodgepodge of the litigation. So accordingly, such question is not permitted to be put to the witness. Please continue.
Mr. Bose, who is Ruby Bose?
Ruby Bose is my wife.
Mr. Bose, could you please tell this court what is her profession?
She is a school teacher.
Mr. Bose, are you aware of the salary that she draws every month?
I can't tell you the exact amount, but it's around 70 to 80,000.
Mr. Bose, on the last occasion, you had stated that your wife is dependent on you. Why is that so?
She is a family member.
I repeat my question. Question repeated through the court.
Question.
On the last occasion, you have stated that your wife
No, dependent in the sense she is a part of the family. You never asked me what she does by profession.
Mr. Bose, what, according to you, is the meaning of the word dependent in common parlance?
I thought you were asking me who are the other family members other than me.
Who are the other family members?
Mr. Bose, what is the profession of your mother?
She teaches, private tuitions.
Is she employed with any organization or institution?
No, she is not.
Would you be able to tell the court what is her approximate source of income every month?
10 to 15,000.
Mr. Bose, are there monetary transactions between your mother and you?
Yes.
Could you please tell the court what these monetary transactions are for?
Actually, my mother took financial help from our family members. Help from our family members, especially from my maternal uncle's side. And maybe at times that amount got transferred to my account because I do all the family expenses.
Are you saying that the money that was received by your mother as financial aid was transferred to your account?
It was transferred to her account, and from there it got transferred to my account or to my wife's account as per requirement.
And from there, it got transferred to my account and to my wife's account.
Can you give an approximate amount of such transfer into your account from your mother's account collating to such financial aid referred to by you in the answer to the previous question?
Offhand, it is not possible for me now because I don't remember it. But if you instruct me or if you tell me to produce a note sheet, I will definitely do that. But for that, I need time.
Will you be in a position to look at the bank statements that you have already produced before this court and identify such transactions?
No, because for that I need all the bank statements and I have to make a detailed note sheet, which is not possible over here. But I will definitely submit it to the
Submit
documents which are required or which you are asking for to the Honorable Court.
Is it your evidence that all the bank statements belonging to you have not been produced before this honorable court?
It is being produced. I am talking about my mother's bank statement, which I need to refer for those calculations.
Mr. Bose, please take up the supplementary affidavit of evidence produced on behalf of the judgment debtor number 2, that is you. Kindly look at page number 142. The original website. Kindly look at the third last entry. Can you please tell this court what this transaction is for?
And this is not an entry. This is a letter.
142, judgment letter number 2, supplementary affidavit.
Could you please repeat the question?
প্রশ্নটা গেছে?
What is transaction?
Third last entry.
4th November 2023. It has come from my mother's account.
It has come from my mother's account.
Please turn over the page and look at the fifth transaction from the top. Can you please tell this court what this transaction is for?
This is again from my mother's account.
Can you look at the 12th transaction from the top and tell the court what this transaction is for?
My mother's account. It has come from my mother's account.
Could you please tell this court what this transaction is for?
I have taken from that account, my mother's account.
Can you please turn over the page and look at the third sorry.
I have taken that money from my mother.
It is from my mother's account বলেছিলাম আমি।
Yeah.
যাই হোক।
লিখতে পারে।
Please look at page number 144. At the third transaction from the top, why has this amount of rupees 1,64,000 transferred to your account?
Again, I have taken money from my mother's account.
Can you look at the 12th and 13th transactions on the same page dated 7th of November 2023? Could you please tell the court what this transaction is for?
Taken money from mother's account.
Could you please tell this court the reason for a transaction of approximately rupees 4.5 lakhs received from your mother within a span of 4 days?
That I have to look for. I don't remember exactly because against which the expenses were made. And I can provide the details to court in future if asked for.
Mr. Bose, could you give the approximate time of this transaction as appearing from the bank statement?
Sorry, I couldn't understand your question.
Can you please give the court the approximate date of the above referred transactions?
The credits All the dates are there in the bank statement.
Mr. Bose, would I be correct to say that these transactions have been made approximately 8 to 9 months back?
It is nearly a year back.
Mr. Bose, is it your evidence that you are unable to recall a transaction of approximately 4 to 5 lakhs that you have incurred just 1 year back?
Yes, I can't remember because I can't give any false declaration in the court. So I'll give exactly what has happened with this money if I'm given a time to produce the document.
Mr. Bose, would I be correct to say that you have not prepared yourself with the transactions prior to giving evidence before this court in the instant proceeding?
No, I was not asked for any kind of preparation of note sheet or anything.
Mr. Bose, please look at page number 140 of the same affidavit. Can you look at the 5th transaction from the top?
Yeah, it has come from my wife, Ruby Bose.
Could you please tell the court the reason for receipt of an amount of rupees 1,70,000 from your wife on 19th October 2023?
Because there were a lot of liabilities, expenses liabilities, so I had to meet up with those. So I had to meet up those personal expenses, family expenses. Because after that, all the debits are also there. I had taken money from friends, which I repaid from that amount. Next entry is Sanjay Chakraborty. I had taken 48,000 earlier, so I had to pay 48,000 to him.
Mr. Bose, have you, during such time, made any efforts to repay the loans of the award holder from
No.
such, I'm not done with my question, from the amounts received? Yes, from the amounts received.
No, I couldn't. I was not in that position because I had to meet my personal expenses, family expenses.
Mr. Bose, could you please tell the court the breakup of such monthly family expenses running to an amount of above 1,70,000?
No, it is not 1,70,000. As I said, I had taken earlier loans from friends and families. So from that amount, I have repaid few of them.
Repeat few of them.
What was the money used for from the amounts received from such friends?
That details I cannot give you offhand right now because normal family expenses, medical expenses, because it is the date which you are referring is October 2023. In that same year, a lot of hospital costs were incurred at AMRI Salt Lake for the treatment of my father. He was a cancer patient and he passed away in 4th February 2023.
Mr. Bose, can you come to page number 144 of the same affidavit and look at the first transaction dated 29th of October 2023?
$144.
I'm sorry, 141. আমি কত বললাম?
One.
Oh, sorry, 141. I'm sorry, sir. Extremely sorry.
Yes.
Why was this amount received into your account?
First entry. First entry you are talking about?
First entry, 29th of October 2023.
I think the page number is wrong. 141 you said.
29th of October 2021st.
First entry dated 29th of October 2023 আছে তো ঠিক আছে একটু কোশ্চেনটা পড়ে দিন না ওনাকে আরেকবার just one second he'll repeat the question for
Page
you.
141. 141. It is first entry is
There is a debit.
date টা বলুন আপনি।
First entry
21st
dated
October.
কোশ্চেনটা একবার পড়ে দিন প্লিজ
29.
Was this amount received?
It has come from my wife's account.
why was this money received by you?
I needed that money.
I needed that.
Is it your evidence that there are other several transactions with your wife whereby you have received similar amounts of money into your account from your wife's account?
Maybe yes. But all the entries are reflected in the bank statement. Whatever money I have received and whatever money was there as an expense is all reflected in the bank statement. Both my bank statements.
Would you agree with me if I say that you have similar transactions with your mother where you have received amounts above rupees 6 to 7 lakhs just for one financial year from your mother's account?
I can't tell you the exact figure, but definitely I had taken money from my mother's account. But I can produce a note sheet to the court in future where the total amount will be there.
Mr. Bose, on the last occasion, you had stated that your present residential house is in the name of your mother. Is that correct?
Yes, it is correct.
Is the house purchased on mortgage?
Yes, it is.
Mr. Bose, please could you tell the court who pays for the mortgage EMIs?
No, I'm sorry. I want to rectify the question. The house was not.
My lord, would he be allowed to rectify or change his answer after I've posed a new question?
No question of rectifying. That will be a fresh answer.
Just answer.
Whatever has
house-
gone, that will be there only.
Well, I've already posed my next question.
Answer the question. Next question.
What question?
It could just have the question read
No,
back.
you're right. In that case, you have to have a recall.
The
Do you understand what I said?
Yes.
What?
Oh, my lord, please.
He cannot rectify any answer. He cannot give a fresh answer of his own. If you want to explain any of the cross-examination questions, you have a right to file an application for recall of the witness to explain the points.
That I may file.
As under the Evidence Act and the Civil Procedure Code, if necessary.
Actually, he
Not
has
now, not now, not in the midst.
Yes, yes.
Please carry on, Mr. Naik. Please just answer his questions.
The house is under mortgage as a security kept with DCB Bank. It was against an DLOD account, drop line OD account, which I had availed in the company's name, where I stood as a guarantor.
Stood as a guarantor.
Till October 2019, as far as I remember, the interest against that DLOD was paid by the company, that is Shantiniketan Wills Private Limited. All these entries are also there in the bank statement of DCB Bank, which I have produced to the Honorable Court earlier. Since 2019 October, I couldn't pay any interest against those accounts.
What was the relationship of your mother with Shantiniketan Wheels Private Limited?
Nothing.
Is it your evidence that the loan taken for the purchase of the immovable property, being your residential house, was taken in the name of Shantiniketan Wheels Private Limited?
The loan was taken in the name of Shantiniketan Wheels Private Limited.
Is it your evidence that after such loan was taken and the purchase of the immovable property was made, the same was taken in the name of your mother?
The property was there since 2003. The loan was taken in 2015 or 16. The property was kept as a what do you call security to the bank, to DCB Bank. It's an old property. It's a 2003 property.
Is it your evidence that your mother had given consent to such mortgage to DCB Bank upon the creation of the loan?
Must be so. It was a parental property. I, as a director, had applied for the OD account, overdraft facility account, to DCB Bank, and they asked me to keep that parental property as a security.
Mr. Bose, was your mother the owner of such property from the first day of purchase of such property?
Absolutely right. Since the day of registration.
Mr. Bose, what was the source of the funds with which such property was purchased?
I was very young at that time, so I don't have any details of source of fund from which my mother purchased that property.
Mr. Bose, kindly look at page number 153 of your affidavit of assets, supplementary affidavit of assets, sorry. Can you look at the second transaction dated 26th of December 2023 and tell the court what this transaction is for?
26th.
6th of December 2023.
The amount paid to Holiday Home Puri.
Why was such amount paid?
Because we had gone there to give puja. That's why we had to stay there.
Can you please tell the court the reason for the next transaction on the same date made at 7:34 p.m.?
That 10,000.
Is it your evidence that the same was also spent at a hotel?
Yes, it is written Holiday Home Puri.
Mr. Bose, can you please take up page number 132 of the same affidavit and look at the second last transaction? 132. 132, second last transaction. And tell the court what this transaction was for.
It is paid to a promoter 5 lakh rupees against the amount received on the same day, one transaction above, from a friend of mine, Anupam De. He was outstation, he was booking a flat, he transferred that amount, and I immediately paid that amount to the promoter after going through few documents which needed to be checked.
Mr. Bose, why couldn't this amount of rupees 5 lakhs be directly paid by Anupam De by way of RTGS?
It was a against a flat booking, as I said, and the first payment which he needs to do, but for an emergency case, he had to move out of Kolkata. The documents
He
he had to move out of Kolkata the day before. But there were few documents which needed to be checked by an advocate. So I had taken that advocate to the promoter's office. He gave a green signal, after which I paid.
Mr. Bose, I repeat my question. Why couldn't this amount of rupees 5 lakhs be paid by way of RTGS by a person who is physically not present in Kolkata?
Because that day only the flat needed to be booked, and adding a beneficiary wouldn't have been possible on the same day to transfer 5 lakh rupees. My beneficiary was added to his account long time before. So he transferred that amount to me. After that, all the amounts were paid by him to the promoter directly.
Mr. Bose, please turn over to page number 133 and look at the transactions dated 11th August 2023 at 3:24 p.m. and 13th August 2023 at 10:06 p.m. Sorry, 10:06 a.m. And tell the court what these transactions are for.
These are against that flat only.
that flat against the payment of
Against the payment of that flat. In the narration also I have written flat.
So I have written flat.
Mr. Bose, why is it that you are paying the consideration sum for the purchase of someone else's immovable property?
I never thought this can be a problem, so I have paid on his behalf. He has deposited cash on 11th August, and I have immediately transferred that fund in the same day.
Mr. Bose, would you be aware of the conveyance of this flat stands completed today?
No, I am not.
Mr. Bose, on the last occasion, you had stated before this court that you have made some cash withdrawals for the purpose of running your monthly expenses. Is that correct?
Right.
Mr. Bose, kindly take up page number 131 of the same affidavit and look at the transaction dated 14th of June 2023 at 2:20 p.m.
Yes.
Would you say that this amount of rupees 1 lakh was withdrawn for the purpose of running your monthly expenses?
Not monthly expenses. Must be, I had to repay back someone, so I had withdrawn that amount. I had just the previous entry, that is 13th of June 2023, I had received 1,15,000 from SPK Consultants.
Received
1,15,000 from SPK Consultants.
consultants.
Mr. Bose, who is SPK Consultants? Or what is Kuruddin actually? What is SPK Consultant?
SPK Consultant is a chartered accountant firm, and the owner of that firm is Mr. Praveen Khemka, who is a close friend of mine.
Khemka.
Mr. Praveen Khemka, who is a close friend of mine.
Do you have any other professional relationship with SPK Consultants?
No, I don't have.
Does SPK Consultants act on your behalf or give you any financial or other kinds of advice professionally?
No, not professionally, not financial advice, but yes, he is beside me, and whenever I fell in any kind of financial trouble, he tried to help me by lending money to run the expenses.
Mr. Bose, in the transaction dated 30th of June 2023 at 1:24 p.m. Why is SPK Consultants referred to as your client? Client inverted commas এর ভেতর থেকে।
I don't know. Whatever narration was put, it was put by him. This is a debit. Sorry, credit. It is a credit. So the entry was done by SPK Consultant.
Mr. Bose, would you say that it is common to refer to your friends as clients?
That he can answer, because the entry was initiated by him.
Mr. Bose, there are several other transactions in the bank statements wherein you have received significant funds of money from SPK Consultants. Would
Yes,
you agree?
I do agree.
Mr. Bose, has it ever occurred to you that from all these funds that you have received, you could have repaid the loans of the award holder in the present proceeding?
No, I was not in a position.
Mr. Bose, have you purchased any immovable property or sought to purchase an immovable property in the last 2-3 years?
No, I haven't.
Mr. Bose, there are several transactions in the bank statements where you have received money from one, inverted commas, Orijit Bose, inverted commas, close, full stop. Does this Orijit Bose refer to yourself?
Yes, it is.
Mr. Bose, could you please tell the court why transactions worth lakhs of rupees have been made inter se between two of your accounts within one financial year?
These transactions they have happened in between my two accounts, which I have produced the documents to the court. These are interbank transfers in between my two accounts.
Mr. Bose, from the bank statements, it is also clear that there are several payments that you have paid to one, inverted commas, Apple Services, inverted commas, close. Could you please tell the court what this Apple Services is?
Can you just refer to one such entry?
Please look at the transaction on 30th May 2023 at 5:57 p.m. appearing on page number 131 of the supplementary affidavit of evidence of the judgment, debtor number 2.
₹100. Is it ₹100 you are talking about? This is for my Apple ID.
Mr. Bose, does this refer to the electronics company Apple?
Yes, the mobile phone Apple company.
Mr. Bose, are you a user of an Apple iPhone?
Yes, I'm an user of Apple iPhone 6s.
Mr. Bose, I suggest to you that you have taken several amounts of money in your bank account and then have conveniently disposed of such funds of money during the pendency of the arbitration proceeding being the subject matter of the award before this court.
Sorry, I do not agree.
Well, I want to refresh the witness's memory with a document. I have a certificate, my lord, under section 16. Electronic evidence. ওই original টা ওনাকে দিন। Thank you. Mr. Bose, please take up page number 8 of the affidavit that has been handed to you and tell the court what is this document or what is this web page.
Sir Nayak, it would be better if you refer to the page so that it goes in evidence.
Yes, no, page 8 I've referred.
Oh,
Page 8 বলেছি তো?
I missed that.
Where is the site name written over here? I don't understand where from this document has come. It was not submitted by me. By me.
Mr. Bose, would you be able to recognize the GST number appearing on this page?
Maybe it's the GST number of the company. I have to check.
Mr. Bose, can you refer to the phone number and the name of the general manager mentioned at the bottom of the page?
Yes, he was there before 2019 October, and the phone number, I think it belonged, it was one of my company's phone number.
Mr. Bose, can you look at a drop-down box on the right-hand bottom of the page which says inverted commas লিখবেন leave a message inverted commas close?
Yes, I can see that.
Mr. Bose, would I be correct to say that this is an advertisement from a portal belonging to Shantiniketan Wheels Private Limited?
See, there are a lot of portals, car sale portals, car sale portals,
Sale বললেন SALE.
sale, car sale portals, which the dealers uses. Now, there are two categories of portals. One is free subscription. The other one is paid subscription. Till 2019, Shantiniketan Wheels had few paid subscriptions with few car sale portals, online portals. Till 2019 October, the source of leads were these online portals. We used to sell our vehicles based on these portals. After 2019 October, we couldn't renew the subscriptions. So they must have moved Shantiniketan Wheels from paid subscription portal to free subscription portal. And it may be a printout of any of that, one of the portal, which seems to me. But if you can put effort and submit a message, then you'll find out that there is no stock reflecting or no reply will come back to you. But just because at one point of time the company was registered with these portals, it is still there as a free subscription. It is still reflecting in their portal. Like there are Just Dial also. Just Dial, even if you don't pay the subscription, your details will be there in Just Dial. But if you further enter into this portal, then you can find that there is no vehicle reflecting, or even if it is reflecting, then you can refer to the upload date. It will definitely be before October 2019.
What upload are you referring to, Mr. Bose?
Upload means when you are a paid subscription, using a paid subscription portal, you can upload the vehicle details in that site.
Mr. Bose, can you tell the court the date and the time appearing on this page at the top left-hand corner?
It's August 8, 2024, 1:02 a.m.
Next second.
102.
Mr. Bose, can you please look at page number 179 of the affidavit? Specifically, the third transaction from the top. And tell the court, what is this transaction for?
This is a payment which has been made of 1,75,000 to the owner of a vehicle, that is owner of a Renault Duster vehicle, against which I had received the amount the same day. At 11:43 a.m., I had received an amount of 1,80,000 from Monojendra Lal Mukherjee. He's a friend of mine. He wanted to buy a vehicle. Monojendra Lal Mukherjee. He wanted to buy that vehicle. The payment I have received is of 1,80,000 on 14 September 2021 at 11:43 a.m. Because I was in front of that vehicle, which I had gone there for valuation on his behalf. He wanted to use my experience, so he was with me. And when I finalized that vehicle, just because my beneficiary was added in his account, you can find other payments also coming in from him as financial help. So he transferred that amount to me, and I had the facility. It's a Kotak Mahindra Bank, so I had the facility in my mobile banking to add a beneficiary and transfer it instantly after 2 hours.
Instantly after 2 hours.
And the payment was made at 12:25 p.m.
Mr. Bose, how long do you think it takes to add somebody as a beneficiary on a mobile banking account for a mobile banking transaction?
It depends from bank to bank. Like in the HDFC, as I know, if you add a beneficiary now, you can transfer fund of maybe 50,000 after 2 hours, and your third party transaction limit will get activated after 48 hours.
Mr. Bose, in that case, why was Mr. Monojendra Lal Mukherjee not pay the amount of rupees 1,80,000 directly?
Because the account which he had didn't permit him to transfer amount instantly. But Kotak Mahindra Bank used to permit that point of time.
Mr. Bose, why did Mr. Monojendra Lal Mukherjee pay you in excess of the amount that you actually pay towards the purchase of the car on 14 September 2021?
He paid me 5,000 extra because the vehicle also needed to be insured. So 5,000 was with me. After a few days, I paid that amount for the insurance purpose.
Can you please point out to the transaction that would reflect the insurance of rupees 5,000 that you have allegedly paid?
Maybe not in the same day, because the car needs to be cleaned, washed, serviced. After that, the insurance amount was paid. Cleaned,
Washed, serviced. After that,
the insurance amount was paid, maybe in cash, maybe through bank. That I have to see, if I can remember.
Mr. Bose, can you put some effort and please point out that transaction to me?
That is not possible right now. I don't remember.
Mr. Bose,
Yes,
would you?
maybe this is the one. 23rd, 23rd September 2021 minus 4184. It has gone to HDFC Argo GIC Limited. Argo GIC Limited. 4183 debit.
Mr. Bose, Mr. Bose, can you produce any evidence to show that such transaction on 23rd of September 2021 for an amount of rupees 4184 was indeed against the car insurance of Mr. Monujendra Lal Mukherjee?
That is not possible now because it is a matter of 3 years before. Even if I ask him to provide me the document the insurance policy document, which belonged 3 years before, after which 3 times he had renewed it, I don't think he will be able to provide me also. He will be able to provide me also.
My lord, could I pray for this document that I have produced, my lord, to be exhibited, my lord, and marked? There's a document, my lord, I've produced that. Exhibit. Lordship will, my lord, have to pass an order, my lord, exhibiting and marking the original.
This entire document?
No, there's only one document, my lord, which is appearing from page number 8 to 11. The remainder of that is my affidavit. Because I'm required to give an affidavit under section 63 of the New Evidence Act, my lord. The BNA. So the
This affidavit you have otherwise filed in court?
No, I'm filing it for the first time. To confront the witness, I've produced this for the first time.
Yes, yes.
Now that he's recognized the document, he's admitted to the document, my lord, this can go down as an exhibit.
The affidavit affirmed by এটা আমার order হিসেবে যাবে. The affidavit affirmed by সৈকত ঘোষ on September 25, 2024 is filed by learned counsel for the award holder and kept on record. Full stop. Next para. The annexures to the said affidavit annexed at pages 8 to
my lord 11.
8 to 11 are marked as exhibit now are tendered to the witness and marked as exhibit নাম্বারটা যা হবে এটা
Sir,
ব্র্যাকেটে
one more
থাকবে
question,
প্লিজ এটা ব্র্যাকেটে থাকবে আবার কোশ্চেন ফিরে যাবে এটা দিয়ে দাও এটা নিয়ে নাও
কত নম্বর এটা প্রথম
এটাই এক্সিবিট হবে এখানে বডিতে
Exhibit A.
It's not a suit, my lord, so this can go down as an A only.
Yes, whatever. Exhibit A thale korun. There is no previous exhibits.
No, sorry, A first. Mr. Bose, I put it to you that during the functioning of the award debtor number 1, you have, using the goodwill and advertising of the award debtor number 1, procured clients and received payment of such money in your personal account.
Not from the stocks of the company, never. It has never happened.
It has never happened.
All the accounts have been submitted and it clearly reflects that there is no such entry in those accounts. Neither in those accounts nor in my bank statements. Neither in those accounts, in the company's accounts, nor in my personal bank statements.
I suggest to you that such payments are not reflected in the bank statement of the company because the same was received by you either in your personal account or by way of cash.
No, that is not true.
Mr. Bose, I suggest to you that purposely purposely defeat the claim of the award holder, you have disposed of the amounts received in your bank account as well as the bank account of the award debtor number 1 after the commencement of the arbitral proceeding in 2021.
Sorry, I don't agree with you.
Well, I think this can be closed.
Concluded.
Yes.
Very well. So I'll discharge this witness.
This,
Is there any other award
Yes, my
debtor?
lord. Judgment debtor number 2 can be discharged, my lord. Judgment debtor number 3 and 4 are there. If the
So I'll fix a date for
whoever my
3.
lord is appearing, 3 or 4, either of them, depending on my learned
I'll
friends.
put it on the next date.
Yes, yes.
Lord, yeah.
Yes.
Maybe the warrant of arrest is suspended till 30th of this month, my lord.
I'll take care
My
of
lord,
that.
my lord.
Warrant of arrest was regarding all the award debtors.
No, only award debtor number 2. Yeah, my lord.
No, that is, I'll discharge that warrant.
Yes, my lord.
Because no longer necessary. The evidence of award debtor number 2 is 2.
2, my lord.
2 is closed. Full stop. The warrant of arrest issued in respect of the award debtor number 2 stands discharged. Full stop. The matter shall next be listed on November 7, 2024 for examination of the award debtor number 3. Full stop. The said award debtor shall be personally present in court on the said date for being examined by the award holder. Thank you.
My lord, I was only praying for this, my lord. If the bank account of the award debtor number 2, my lord, could be injuncted from usage. And I was listening to the previous matter also, my lord, where the similar prayer was made. Even in that case, my lord, the balance was quite low. In this case, what is reflected from the statement that has been made over, my lord, there is not more than 2,000 rupees in the bank.
In
The
that
only
event,
reason
Mr.
I make that prayer, my lord,
Mr. Naik,
is-
then I'll have to ask you to, I'll record that prayer.
And
I'll
formally
ask you to
reject it.
file a formal application so that they can controvert that.
Yes. Then in that case, it's not necessary. Well, I'll come up with by way of an application itself. That could be taken into
Yes,
consideration.
very
At
well.
the,
I'll not record anything then.
nothing, my lord.
Very
I'll come by way of an application.
Thank you. So this matter is over for today.
Yes.
I'll take up the next matter after 5 minutes. Yes, yes, yes. Thank you.
Item number 9, JAME Financial Asset Reconstruction.
Item number 9, my lord, this matter warrant has been issued.
No police report. Good.
No
Yes, you are
Your
appealing.
Lordship, I am appealing for the judgment debtor.
Where is he?
Your Lordship, my senior is out of station. Your Lordship, kindly keep the matter after
No.
vacation, Your Lordship.
Warrant of arrest has been issued.
Yes,
Your client must be present in court today.
Your Lordship, I have no instruction.
The warrant will be continued then.
yes, can you fix the returnable anyway? If they file affidavit, they can mention this matter. No, my lord, if they have to file affidavit asset, my lord. No affidavit asset has been filed by them.
At the time of call, an adjournment is sought on behalf of the award debtors. First up, it transpires from the records that previously warrant of arrest had been issued against the award debtor number 2, Ketan Madhusudan Shroff, SHROFF. First up, however, comma, neither has any affidavit of asset filed by the said award debtor, comma, nor is the said award debtor personally present in court today at the time of call. First up, there is no police report as yet furnished, comma, as per the report of the Deputy Sheriff dated September 26, 2024. First up, next para, accordingly, let the warrant of arrest be extended until further order, subject to further costs in that further requisites being put in by the award holder in that regard. Full stop. The award debtor number 2 shall file his affidavit of asset by November 8, 2024. Full stop. The matter shall be listed on November 14, 2024. Next, for examination of the award debtor number 2.
Gratefully, Your Lordship.
Item number 10, JAME Financial Asset Reconstruction.
Warrant has been issued, my lord, against 1 and 2.
Yes. Could not be traced. I'll extend the arrest and
Yes,
find
my
out.
lord.
From the police report, comma, as reflected in the report of the Deputy Sheriff, comma, the award debtor numbers 1 and 2 could not be traced. Full stop. Accordingly, let the warrants of arrest be extended until further order, subject to the award holder putting in due requisites. Full stop. It will be open to the award holder to trace out the current addresses of the award debtors in the meantime. Full stop. The matter shall next be listed on November 14, 2024.
Grateful, my lord.
Item number 11, Aditya Birla Finance Limited.
Lordship, on the last occasion, we were directed to find the new address, but as on that we could not find the
The
same. We
Deputy
need
Sheriff's
some
report
more time.
says that you have not put in requisites for extension of the
Lordship, we were supposed to put in requisite with the current address, so we could not ascertain the current
then the
address.
warrant cannot be continued.
No, Lordship. Lordship, we need to ascertain the current address.
First up, the Deputy Sheriff's report dated September 25, 2024 indicates that no effective steps could be taken for extension of the warrant in view of no requisites being put in by the award holder. First up, next para. The counsel for the award holder submits that since the current address of the warranty stroke award debtor could not be traced out, comma, the requisites were not put in. First up, how much time? It will go out of the list.
After vacation.
It will go out of the list you mentioned, when
Lordship.
push up in order to enable the award holder to trace out the current address of the award debtor, comma, the matter is adjourned and shall go out of the list for the time being, with liberty to the award holder to mention for inclusion in the list in the event the current address of the award debtor is traced out.
Gratefully, Lordship.
Item number 12, IDFC First Bank Limited.
In this matter, I am for the award.
I appear for the award debtor. Lordship, may I file my affidavit of affidavit?
You have handed over a copy to them?
Yes, Lordship.
Your Lordship, we have received.
So the witness is present there. Let us start the examination.
Your Lordship.
After line at affidavit of asset filed by the Award debtor Nirmal Kantinath today be kept on record. Full stop. The examination of the said award debtor is commenced.
আপনি
এবার
এর আগে
বলুন।
এসেছেন এখানে আপনার নাম বলুন।
নির্মল কান্তিনাথ, নির্মল কান্তিনাথ।
না, এর আগে এসছে।
Can please take your seat.
হ্যাঁ,
First day, he said yes.
এর আগে যখন লক
আচ্ছা
তখন
বলুন আমার পরে পরে আমি
আমি
এই মামলায়
এই মামলায়
সাক্ষ্য দিতে এসে
সাক্ষ্য দিতে এসে
যা কিছু বলবো
যা কিছু বলবো সত্য বলবো, সত্য ছাড়া
মিথ্যে বলবো না,
মিথ্যা বলবো না,
কোনো কিছু গোপন করব না।
গোপন করব না।
আপনার নাম বলুন।
নির্মল কান্তিনাথ,
বাবার নাম
সুধীর চন্দ্রনাথ,
সুদীপ চন্দ্রনাথ। আপনার বয়স
বয়স
50।
50।
আপনি কি করেন?
আমি এখন বর্তমানে রিক্সা চালাই।
রিক্সা পুলার
পুলার হবে কি?
চালাই। আপনি কি পা দিয়ে
কি
চালান
রিক্সা?
না, ব্যাটারি রিক্সা।
I
রিক্সা
operate.
ড্রাইভার
I operate a
ব্যাটারি ড্রিভেন রিক্সা।
yes.
আপনার অ্যাড্রেস
In this matter, Brotin Kumar De is appointed by legal aid. He is on leave before courtroom number 19.
No difficult.
I'm
You are there. Yes.
আপনার ঠিকানা বলুন।
ঠিকানা হাতিয়ারা ঝিলবাগান।
হাতিয়ারা
ঝিলবাগান।
ঝিলবাগান কোথায় এটা? ঝিলবাগান
রাজারহাট ইকো পার্ক থানা।
রাজারহাট ইকো পার্ক থানা,
হ্যাঁ।
মানে পিএস ইকো পার্ক, কলকাতা কত জানেন?
কলকাতা 157।
157।
Mr. Nath, what is your current source of income?
আপনি এখন আপনার আয়ের সোর্স কি? আপনি কি দিয়ে আয়
এই
করেন?
যে রিক্সা চালিয়ে ইনকাম যা হয়।
I drive an e-rickshaw.
Mr. Nath, in your affidavit of assets, you have mentioned that your wife and your son is dependent on you. Is it true?
আপনি আপনার এই সম্পত্তির হলফনামাতে লিখেছেন যে আপনার স্ত্রী এবং আপনার পুত্র আপনার উপরে নির্ভর।
না, আমি রিক্সাও চালাচ্ছি প্লাস আমার ওয়াইফ।
আপনার স্ত্রী আর ছেলের খরচা আপনি চালান, তাই তো?
হ্যাঁ।
ইয়েস।
What is the age of your son?
আপনার ছেলের বয়স কত?
বয়স এখন 15 প্লাস।
15 years.
Whether he is studied?
হ্যাঁ, পরে
পড়াশোনা করছে? ইয়েস।
In which class and which school?
মাধ্যমিক দেবে।
He will sit for the matriculation exam next year. আর কি বলছিলেন?
স্কুল।
স্কুল
প্রমিলা অ্যাডভান্স স্কুল।
প্রমিলা অ্যাডভান্স স্কুল কোথায়?
বাগুইয়াটি।
What is your annual income, Mr. Nath?
বছরে কত আয় করেন?
বছরে 10-12 হাজার টাকা মাসে। এবার বছরে কত হয়?
10 to 12,000 per month.
Mr. Nath, you have mentioned that you are a rickshaw driver. Are you the owner of that rickshaw?
না, ভাড়া রিক্সা।
The rickshaw is rented.
Mr. Nath, are you familiar with the legal proceedings initiated by IDFC First Bank, the award holder, against you?
আপনি কি জানেন তথ্যগুলো যে আইডিএফসি ফার্স্ট ব্যাংক আপনার বিরুদ্ধে কোনো মামলা বা এই ধরনের কোর্টে কিছু ফাইল করেছে?
বুঝলাম না।
এই যে আইডিএফসি ফার্স্ট ব্যাংক আপনার বিরুদ্ধে এই কোর্টে মামলা করেছে, এই বিষয়ে আপনি কি জানেন?
না, আমি যখন লক আপ হলাম তারপরেই তো জানতে পারলাম।
I came to know when I was arrested by the police.
The address you have mentioned in your affidavit of assets, are you residing there from very beginning, or any other residence you have?
আপনি আপনার সম্পত্তির হলফনামাতে যে ঠিকানাটা দিয়েছেন,
হ্যাঁ
আপনি কি ওই ঠিকানায় প্রথম থেকেই
হ্যাঁ
থেকে
আমি
এসেছেন, নাকি আপনি যে ঠিকানাটা দিয়েছেন ওই ঠিকানার আগে অন্য কোথাও ছিলেন?
ওইখানেই ছিল,
I was in that address since beginning.
এখনো ওইখানে আছে।
At present also I am residing there. I am residing in that address.
Mr. Nath, why you have taken loan from IDFC First Bank Limited?
আপনি এই আইডিএফসি ফার্স্ট ব্যাংক থেকে লোন কেন নিয়েছিলেন?
ব্যবসা করার জন্য।
টু রান এ বিজনেস।
What kind of business?
কি ধরনের ব্যবসা করার জন্য নিয়েছিলেন?
ওই চকলেট ক্যাডবেরি এসব।
চকলেট ক্যাডবেরি কি, ওটা একটু বলে দিন।
চকলেট দোকানে দোকানে সেল করতাম আর কি।
আচ্ছা, মানে এজেন্টশিপ।
হ্যাঁ
না, মুখে কিছু কথা বসাবেন না,
আচ্ছা
উনি যা বলছেন।
আচ্ছা, টু সেল চকলেট ক্যাডবেরি চকলেটস from shop to shop.
Mr. Nath, from when you have started driving rickshaw?
আপনি কবে থেকে রিক্সা চালাতে শুরু করেছেন?
প্রায় 3 বছর হয়ে গেল।
লাস্ট 3 years.
লকডাউনের সময়।
আচ্ছা, from the COVID-19 lockdown. 3 years to
Before COVID, what was your occupation?
লকডাউনের আগে আপনি কি করতেন?
আমার ছোট একটা দোকান ছিল।
I had a small shop.
Was that shop is a rented one or ownership?
রেন্টেড।
ভাড়াতে ছিল।
ভাড়াতে ছিল।
That shop was rented.
What is the status of your that business?
ওই ব্যবসার এখন কি অবস্থা আছে?
ওই ব্যবসা তো স্যার 3 বছর আগেই বন্ধ হয়ে গেছে।
That business is closed 3 years ago.
The reason of close of that business?
কেন বন্ধ হয়েছে সেই
লকডাউনের দোকানগুলো সব বন্ধ হয়ে গেছে, আর মালপত্র বিক্রি করতে পারিনি দোকানে দোকানে।
During lockdown, I could not sell anything in that shop. Therefore, the shop was closed.
When you have took loan from IDFC First Bank, what are the documents that you should produce for getting that loan?
আপনি যখন আইডিএফসি ফার্স্ট ব্যাংকে লোনের জন্য আবেদন করেছিলেন, তখন ওই ব্যাংকে আপনি কি কি আপনার যাবতীয় ডকুমেন্টগুলো জমা করেছিলেন?
প্যান কার্ড, আধার কার্ড,
প্যান কার্ড, আধার কার্ড,
ইনকাম ট্যাক্সের ফাইল ছিল,
ইনকাম ট্যাক্স ফাইলিং রিপোর্ট,
আর কি দিয়েছে অতটা আমার এখন মনে নেই।
and I do not know what else I had submitted. I do not recall.
Mr. Nath, what is the amount of the loan you have took from IDFC First Bank Limited?
কত টাকা নিয়েছিলেন লোন হিসেবে আপনি ওই আইডিএফসি ফার্স্ট ব্যাংক থেকে?
8,75,000 হবে।
Nearly 8,75,000 rupees.
When you have started defaulting in the EMI?
আপনি কবে থেকে ওই লোনের কিস্তি দেওয়াতে আপনার ব্যাঘাত ঘটে? কবে থেকে?
আমি মনে হয় 4টা কি 5টা আমি দিয়েছি, এরপরে লকডাউন পড়ে গেছে, লকডাউনের মধ্যে 2টাই কিস্তি দিয়েছি।
আচ্ছা, I had paid 4 to 5 installments for the loan. After that, COVID-19 had occurred. After the lockdown, during the lockdown, I paid 2 installments of the loan.
Mr. Nath, do you remember the date or year when you have entered into the agreement with IDFC First Bank?
আপনি ওই আইডিএফসি ফার্স্ট ব্যাংকের সাথে যে লোনটা আপনি নিয়েছিলেন সেটা কবে সই-সাবুত হয়েছিল কিছু মনে আছে?
সই-সাবুত লকডাউনের 3-4 মাস আগে হবে।
3 to 4 months before the lockdown.
Mr. Nath, I am put it to you. You have entered the agreement with IDFC First Bank in the year 2019, October 28.
উকিল বাবু বলছেন যে আপনার ওই এগ্রিমেন্ট যেটা সই হয়েছিল সেটা অক্টোবর 2019-এর অক্টোবর মাসে। আই এগ্রি।
How, oh, sorry. Mr. Nath, could you please inform the Honorable Court that what are the EMI amount of your loan?
EMI amount ছিল 28,676।
The EMI amount was 28,676 rupees. এটাই তো?
Mr. Nath, can you confirm that a termination letter was issued by IDFC First Bank? Whether you have received the same or not?
আইডিএফসি ফার্স্ট ব্যাংক একটা টার্মিনেশনের চিঠি, বাতিল করার চিঠি ইস্যু করেছে ওখান থেকে, সেটা কি আপনি জানেন?
না।
আই ডু নট নো।
From where you have got information regarding this proceeding?
আপনি এই আপনার এগেইনস্টে যে মামলা চলছে এখানে, এই খবরটা আপনি কোথা থেকে পেলেন?
প্রথমে আমার বাড়িতে নোটিশ যেত, ওই নোটিশগুলো থেকে তারপর জানতে পারলাম।
At first, some notices had reached my house. From there, I came to know about this proceeding.
What kind of notice?
কি রকমের নোটিশ বাড়িতে যেত?
নোটিশগুলো তো আমি পড়তে পারতাম না, আমাদের পাড়ায় একটা উকিল বাবু ছিল, ওনাকে দেখাতাম।
As I am not able to read and write, I used to show the notices to a learned advocate present near my house. আর উনি বলে দিতেন, তাই তো? অ্যাডভোকেটকে দেখাতেন, উনি বলে দিতেন, তাই তো? And he had explained me about this notices.
Mr. Nath, at the starting of this examination, you have intimated that when you have been locked up, you have been informed or having knowledge of this proceeding. So now you have informed that you have received some notices. From where you have got information regarding these proceedings. So, Mr. Nath, can you please tell me which one of your statements should be true?
আপনি যখন এখানে এখন এলেন, আপনাকে জিজ্ঞেস করা হয়েছিল যে আপনি এই আপনার বিরুদ্ধে যে মামলাটা চলছে এটার খবর কোথা থেকে পেলেন? আপনি এসে বললেন আপনাকে যখন পুলিশ অ্যারেস্ট করে নিয়ে গেল, তারপরে আপনি এই মামলার খবরটা জানলেন। কিন্তু এখন বলছেন যে আপনার বাড়িতে নোটিশ যেত, আপনি উকিলবাবুকে সেটা দিতেন, উকিলবাবু আপনাকে পড়ে শুনিয়ে দিত, তারপরে আপনি জানলেন। আপনার এই দুটো যে কথা বলছেন এটার মধ্যে কোনটা সত্যি? কোথা থেকে জানলেন? আপনাকে অ্যারেস্ট করা হয়েছিল সেটা তারপরে, নাকি আপনি উকিলবাবুর কাছ থেকে যিনি আপনাকে পড়িয়ে শোনাতো তার কাছ থেকে প্রথমে জানলেন?
আমি উকিল বাবুর কাছে যেতাম, এরপরে নোটিশগুলো আসতো বাড়িতে।
সেটা বলছে না, কোন কথাটা সত্য? আপনাকে পুলিশ অ্যারেস্ট করেছে তারপরে আপনি জানলেন, নাকি উকিলবাবু আপনাকে পড়ে শুনিয়েছিল তারপরে আপনি জানলেন?
দুইটাই সত্য।
Both the statements are correct.
Mr. Nath, when your advocate intimated you regarding the proceedings, then why don't you appear before the Honorable Court earlier?
আপনাকে যখন উকিলবাবু প্রথমে পড়ে শোনালো আর ব্যাপারটা বোঝালো, তখনই আপনি এই কোর্টে এসে কেন হাজির হননি?
উকিল বাবু আমাকে বলেনি সেরকম।
The learned advocate did not ask me to do so.
Mr. Nath, did you know that an arbitration proceeding was initiated against you due to the defaults occur of payment of EMI in your loan agreement?
আপনার একটা আরবিট্রেশন মামলাও চলছে কারণ আপনি ইএমআই গুলো সঠিকভাবে দেননি। এটা কি জানেন আপনি?
হ্যাঁ।
Yes, I know.
Have you appeared in that proceeding?
আপনি ওই আরবিট্রেশন মামলায় কি হাজির হয়েছিলেন?
না, আমি জানতাম না স্যার।
আপনি এখন বললেন জানতেন। আপনি কি ওই মামলায় হাজির হয়েছিলেন?
Exactly.
I did not know that.
Mr. Nath, did you know that in that arbitration proceedings, an award has been published against you?
ওই আরবিট্রেশন মামলায় একটি অ্যাওয়ার্ড পাস করা হয়েছিল আপনার বিরুদ্ধে। আপনি কি সেটা জানেন?
ব্যাপারটা হলো আমি যতগুলো নোটিশ আমার বাড়িতে যেত আমি উকিল বাবুকে দেখাতাম। এবার উকিল বাবু আমাকে কিছু বলেনি, আমিও সেভাবে জানতে পারিনি।
Many notices had come to my house and I had shown the notices to the learned advocate, but the learned advocate did not instruct me to do anything of that manner. Therefore, I did not take any steps.
Mr. Nath, the arbitrator has already issued an award ordering you to pay rupees 12,36,092.05 paisa. Can you explain how could you repay this amount?
ওই আরবিট্রেশন মামলায় 12,36,900 কত সামথিং টাকা আপনার
92
against-
টাকা,
হ্যাঁ,
92.
হ্যাঁ, পয়সা আপনার বিরুদ্ধে ওই আরবিট্রেটর ঘোষণা করেছেন। এই টাকাটাকে আপনি কিভাবে পরিশোধ করবেন আপনি একটু বলুন।
না, আমার কাছে 1 বছর আগে ব্যাংক থেকে ফোন এসেছিল সেটেলমেন্টের ব্যাপারে।
A year ago, a phone call had come from the bank for settlement.
Mr. Nath, আচ্ছা
আমার
বলুন।
শেষ হয়নি।
বলুন।
আমার কাছে 2,15,000 টাকা চেয়েছিল।
They had asked 2,15,000 rupees from me.
তারপরে ওনারা আমার পরিস্থিতি দেখে আমি বললাম আমার পরিস্থিতি খুব খারাপ। তারপর ওনারা বলল আপনি এখন যা পারেন তা দিয়ে যান, যখন আপনার হাতে পয়সা আসবে আপনি এককালীন টাকাটা দিয়ে দেবেন। তারপর
Thereafter, by looking at my condition, they said that whatever money you have in hand, you pay it.
তারপরে আমি বললাম স্যার আমি এককালীন দিতে পারবো না, আমাকে ইনস্টলমেন্টে করে দেন।
I said that, sir, I cannot pay the money altogether. So please arrange for me for making the payments in installments.
কিন্তু ওনারা রাজি হয়নি।
And they did not agree to that.
তারপর আমি 14 তারিখে লোক আদালতে এসেছিলাম।
Thereafter, I came to Lok Adalat on 14th.
তারপর ওখানে গেছি, ওখানেও 2 লাখ টাকাই চেয়েছে।
14 কবে?
এই যে এই মাসেরই 14 তারিখ।
14th September. তারপরে
ওখানেও 2 লাখ টাকা চেয়েছে।
There also they had asked me rupees 2 lakhs.
আমি এককালীন দিতে পারছি না, এটাই।
I cannot pay the money at one time.
আমি বলেছি অ্যামাউন্টটা একটু কমিয়ে দিন,
তারপর আমি দিতে পারবো।
I said that please accept my prayer of to
Please reduce the amount so that I can pay.
so that I can pay.
Mr. Nath, you have said IDFC Bank has proposed you a settlement a year ago. And now you have appeared before Lok Adalat on 14th also. Have you quoted any reduced amount?
আপনি কত টাকা কমিয়ে দেবেন সেটা কি আপনি কিছু
না
বলেছেন?
আমি কিছু বলি।
I have not quoted anything.
Mr. Nath, according to your affidavit of assets, your residence is at Jhil Bagan, Rajarhat, Gopalpur. Is this your primary residence?
আপনার সম্পত্তির হলফনামা অনুযায়ী আপনার যে বাসস্থান সেটা হচ্ছে ঝিলবাগান হাতিয়া ওই যেটা বললেন হ্যাঁ রাজারহাট গোপালপুর তো আপনার মূল আবাস কি ওখানেই ওখানেই থাকেন ইয়েস
Mr. Nath, you have mentioned that your annual income is of rupees 2,01,600. How could you come to the exact figure of this amount?
আপনি আপনার সম্পত্তির হলফনামায় বলেছেন যে আপনার বছরের আয় 2,01,600 টাকা। আপনি কিভাবে এই অঙ্কটা করলেন যে এত টাকা আপনার মাসে বছরে ইনকাম হচ্ছে?
ওই যে রিক্সা চালিয়ে যেটা মানে 10-12 হাজার টাকা ওইটাই।
I calculated the amount as I said that I earn rupees 10 to 12,000 per month.
Mr. Nath, when you have took the loan from IDFC, along with your PAN card and Aadhaar card, have you deposited there your ITR?
আপনি যখন আইডিএফসি ফার্স্ট ব্যাংক থেকে লোন নিয়েছিলেন আপনি আপনার প্যান কার্ড আধার কার্ড দিয়েছিলেন আপনি কি আপনার আইটি ফাইলের রিপোর্টটা দিয়েছিলেন?
হ্যাঁ দিয়েছিলাম।
ইয়েস আইটিআর রিপোর্ট।
Mr. Nath, have you disclosed all your assets in this affidavit?
আপনি আপনার যতগুলো সম্পত্তি আছে সব এই সম্পত্তির হলফনামায় উল্লেখ করেছেন?
আমার কাছে কিচ্ছু নেই বর্তমানে।
I do not have anything at present.
Mr. Nath, in your affidavit, you have mentioned about two bank accounts. One is with SBI and another is with Indian Overseas Bank. When last these two accounts you have operated?
আপনি আপনার সম্পত্তির হলফনামায় দুটো ব্যাংক অ্যাকাউন্টের কথা বলেছেন একটি এসবিআই এ আছে একটি ইন্ডিয়ান ওভারসিজ ব্যাংকে আছে আপনি শেষবারের মতো কবে এই দুটো ব্যাংক অ্যাকাউন্ট চালিয়েছিলেন মানে টাকা লেনদেন করেছেন এই অ্যাকাউন্টে?
এই 2-3 বছর হয়ে গেছে।
লাস্ট 2 to 3 years ago.
Mr. Nath, in your affidavit of assets, you have mentioned regarding your SBI account that in your SBI account there is an amount is of 565 as on 19/9/2024. From where you have got this information?
আপনার সম্পত্তির হলফনামায় আপনি উল্লেখ করেছেন যে এসবিআই অ্যাকাউন্টে 565 টাকা আপনার ব্যালেন্স আছে 19/9/2024 অনুযায়ী আপনি এই ইনফরমেশনটা কোথা থেকে পেলেন এই তথ্যটা কোথা থেকে পেলেন?
ব্যাংক অ্যাকাউন্ট থেকে।
ফ্রম দ্য ব্যাংক অ্যাকাউন্ট।
Mr. Nath, can you produce your bank statement of both the accounts for last 5 years?
আপনি কি আপনার এই দুটো ব্যাংকের স্টেটমেন্ট গত 5 বছরের এই কোর্টের সামনে নিয়ে আসতে পারবেন?
হ্যাঁ পারবো।
ইয়েস আই ক্যান।
Mr. Nath, do you possess any other financial assets like any fixed deposit, bonds, or investment?
আপনি কি অন্য কোনো সম্পত্তি যেমন ফিক্সড ডিপোজিট বা বন্ড এইসবে কোনো টাকা ব্যয় করেছেন, মানে গুলোতে
একটা
টাকা আছে?
এলআইসি আছে 3 বছর ধরে বন্ধ আছে।
I have an LIC which is closed since last 3 years.
Mr. Nath, why don't you mention regarding your LIC policies in your affidavit of assets?
এই সম্পত্তির হলফনামায় ওই এলআইসির বিষয়ে কেন উল্লেখ করেননি আপনি?
সেটা আমি বুঝতে পারিনি ব্যাপারটা।
I did not understand, that's why I did not mention it.
Mr. Nath, when your LIC bonds will be matured or it was already matured?
এই এলআইসি কবে আপনার ম্যাচিউর করবে নাকি এটা ম্যাচিউর করে গেছে?
হয়নি এখনো, 2029-এ শায়দ।
It will mature in the year 2029.
Mr. Nath, can you, on the next returnable date, produce these LIC policies details?
আগামী দিন যখন আপনি আসবেন এই এলআইসি পলিসির যে কাগজ সেটা এখানে জমা করতে পারবেন?
হ্যাঁ, পাবো।
Yes, I can.
Mr. Nath, when you have took the loan, in which account your loan was credited?
আপনি যখন লোনটি নিয়েছিলেন কোন ব্যাংক অ্যাকাউন্টে ওই লোনের অর্থ ঢুকেছিল, টাকা?
ইন্ডিয়ান ওভারসিজ ব্যাংক।
ইন্ডিয়ান ওভারসিজ ব্যাংক।
Did you have avail any other loan facility from any other banks or financial institutions?
আপনার কি আরো অন্য কোনো লোন নেওয়া আছে আরো অন্য কোনো ব্যাংক থেকে?
হ্যাঁ, আরেকটা লোন আছে।
Yes, I have another loan.
With which bank or financial institution?
কোন ব্যাংক বা সংস্থা থেকে নিয়েছেন?
ওটা বন্ধন ব্যাংক।
From বন্ধন ব্যাংক।
What is the purpose of that loan?
ওই লোনের উদ্দেশ্য কি ছিল? লোনটা কেন নিয়েছিলেন?
ওটা আজকে মানে 10 বছর পর রানিং, মানে 1 বছর পর পর ওটা লোন বাড়ে আর কি। মানে প্রথমে 10,000 20,000 থেকে শুরু হয়েছিল, এরপরে চলতেই রয়েছে আর কি।
The loan increases every year. It had started from 10,000, then 20,000 and so on.
লোন মানে উনি বুঝতে পেরেছেন তো, ধার।
ধার, যে ধারটা আপনি নিয়েছিলেন বন্ধন ব্যাংক থেকে।
হ্যাঁ, ঠিক আছে। Yes.
Mr. Nath, why don't you disclose this regarding your loan of Bandhan Bank in your affidavit of assets?
আপনি এই বন্ধন ব্যাংক থেকে যে আপনি লোন নিয়েছিলেন এটার বিষয়ে আপনার সম্পত্তির হলফনামায় কেন আপনি উল্লেখ করেননি?
স্যার আমি বলছি, উকিল বাবা আমাকে বলেছে আপনার নামে কি ব্যাংকের অ্যাকাউন্ট গুলো দেন। ওটা আমার লোন অ্যাকাউন্ট, ওটা সেভিংস না, ওখানে শুধু টাকা জমা হয়।
My learned advocate had asked me to provide him with my bank accounts, so I gave him my savings bank accounts, and that is a loan account. That's why I did not give the details.
Mr. Nath, in your affidavit of assets, on affidavit, you have disclosed false statements.
আপনি আপনার সম্পত্তির হলফনামায় যে তথ্যগুলো দিয়েছেন সেগুলো ভুল তথ্য, উকিলবাবু বলছে। মিথ্যে তথ্য, ভুল তথ্য দিয়েছে।
এটা আপনার কি বক্তব্য আছে?
আপনার কি বক্তব্য? আপনি সেটা মানতে রাজি? মানতে রাজি?
মিথ্যা বলতে উকিল বাবা আমাকে বলেছে আপনার
না,
কি কি
এই উকিলবাবু বলছেন।
হ্যাঁ,
ইনি বলছেন যে আপনি যা কিছু তথ্য দিয়েছেন আপনার সম্পত্তির হলফনামায় সেগুলো ভুল, মিথ্যে। আপনি মানতেও পারেন, নাও মানতে পারেন।
হ্যাঁ, আমি দুইটা কথা বলিনি, এটাই স্যার। LICর কথা আর বন্ধন ব্যাংকেরটা বলিনি।
Yes,
Yes, I have not disclosed.
I did not disclose details of LIC and a loan in Bandhan Bank.
Now I am putting it to you. Is there any other liabilities or debts that you have not disclosed here?
আপনার কি আর অন্য কোনো এই রকমের লোন বা ধার দেনা আছে যেগুলো আপনি এই সম্পত্তির হলফনামায় উল্লেখ করেননি?
আরেকটা লোন বলতে আমার আরেকটা কেস চলছে বাংশাল কোর্টে।
আপনাকে লোনের বিষয়ে জিজ্ঞেস করছি।
না, ওই উত্তরটা যাবে যেটা বলে।
হ্যাঁ,
I have a case pending against me in Bangshal Court.
Mr. Nath, when you have took loan from Bandhan Bank?
আপনি বন্ধন ব্যাংক থেকে কবে লোন নিয়েছিলেন?
লোন নিয়েছি 6-7 মাস আগে।
6 to 7 months ago.
What is the loan amount?
কত টাকা নিয়েছিলেন লোনে?
ওইটা আগে 1,20,000 ছিল, এখন 1,60,000 হয়েছে।
The loan was earlier 1,20,000. Now it has become 1,60,000.
Mr. Nath, what is the EMI of that loan amount?
8,000 টাকা, 8,000 something.
8,000, approximately 8,000 or more.
What is the repayment terms?
আপনার ওই লোন পরিশোধ করার যে কন্ডিশন গুলো সেগুলো কি? কবে ফেরত দিতে হবে, কতদিনের মধ্যে?
মানে মাসে মাসে আর কি।
মান্থলি।
Have you repay that EMI every month?
আপনি কি প্রতি মাসে ওই লোন শোধ করেন? Yes.
Mr. Nath, on the returnable date, can you produce the Bandhan Bank details?
এর পরের দিন যখন আসবেন বন্ধন ব্যাংকের যে কাগজপত্র সেগুলো দিতে পারবেন?
হ্যাঁ, অবশ্যই দিতে পারবো।
Mr. Nath, what is the occupation of your wife?
আপনার স্ত্রী কি করেন?
লোকের বাড়ি রান্না করে।
She cooks at other people's homes.
What is her monthly income?
ওনার মাসে আয় কত?
আমি জিজ্ঞেস করিনি ওনাকে কোনো।
I have not asked her.
Mr. Nath, you have mentioned that you have pay rent for your rickshaw yearly 67,200. Right?
আপনি আপনার ওই রিক্সা যে চালান তার জন্য ভাড়া দেন হচ্ছে বছরে 67,200 টাকা, ঠিক তো?
হ্যাঁ, ডেলি 200 টাকা করে দিতাম।
Yes, I used to pay 200 rupees per day.
Mr. Nath, are you currently hiding or concealing any assets that could be used to satisfy the outstanding debt of rupees 12,36,000?
আপনি কি এখন এমন কোনো সম্পত্তি গোপন করেছেন যেটা বিক্রি করে এই লোন পরিশোধ করা যেতে পারে?
না।
12,36,000?
না, আমার কাছে আর কিছু নেই।
No, I do not have anything.
Mr. Nath, do you or your wife have any ancestral property?
আপনার বা আপনার স্ত্রীর কোনো পৈতৃক সম্পত্তি আছে? মানে আপনার বাবার সম্পত্তি আপনার কাছে আছে? বা
না,
আপনার
এখন
স্ত্রী?
তো নেই, আমার কাছে কিছু নেই।
I do not have anything now.
Mr. Nath, you have said you have nothing now. Previously, have you?
আপনি বলছেন আপনার কাছে এখন নেই, আগে কি ছিল?
আগে আমার বাড়ি ছিল,
Yes,
পৈতৃক সম্পত্তি আর কি।
earlier I had a parental house.
Where is that parental house?
ওই বাড়িটি কোথায় ছিল?
ওই অ্যাড্রেসেই ছিল।
In the same address.
Mr. Nath, I am putting it to you. Are you right now hiding another thing that the present address where you residing is your ancestral house, but there you are residing as a tenant by paying rent?
আপনি কি আবার কিছু লুকাবার চেষ্টা করছেন? আপনি বলছেন যে আপনার যে পৈতৃক সম্পত্তি সেটা এখন যে অ্যাড্রেসটা ওখানে, আবার আপনি বলছেন একই সময়ে যে আপনি যেখানে এখন থাকেন সেখানে থাকার জন্য আপনি ভাড়া দেন।
না, ওইটা ব্যাপারটা হচ্ছে আমার আগে একটা লোন ছিল, হোম লোন। ওই
Earlier I had a home loan. বলুন।
হোম লোন ছিল, তা আমি ব্যাংকের টাকা পরিশোধ করতে পারিনি, ওই বাড়ি বিক্রি করে আমি লোন ক্লোজ করি।
I could not repay the loan, therefore I sold out the house and repaid the loan.
With which bank that loan was?
কোন ব্যাংকে ওই লোনটা ছিল?
উজ্জীবন ফাইন্যান্স।
উজ্জীবন ফাইন্যান্স।
What was the purpose of the loan and the amount of loan?
ওই লোনটা কেন নিয়েছিলেন?
ওটা বাড়ি করার জন্য নিয়েছিলাম।
To build a house.
Amount of loan?
কত কত টাকা নিয়েছিলেন?
12 লাখ ছিল।
12 lakhs.
When your ancestral property was sold out?
কবে আপনি সেই বাড়িটি বিক্রি করলেন? আপনার
লকডাউনের পরে।
আফটার দ্য
লকডাউনের পরিস্থিতি এরকম হয়ে গেছে, আমি লোন টানতে পারছি না, তারপর ব্যাংক চাপ দিয়েছে, আমি ওই বাড়ি বিক্রি করে ব্যাংকের টাকা শোধ করি।
during the lockdown my financial condition worsened, therefore to repay the loan I had to sell the house after lockdown পরে বিক্রি করি, after lockdown.
If you already sold out your ancestral house, then how you become the tenant in the same house? Under whom you are tenant or to whom you pay the rent?
আপনি যখন ওই বাড়িটি বিক্রি করে দিয়েছেন তাহলে ওই বাড়িতে আপনি কি করে একজন ভাড়াটিয়া হিসেবে আছেন?
ওই বাড়িতে না তো, আমি পাশেই থাকি, মানে পাড়ায় আর কি, একই
I
পাড়ায়।
do not reside in the same house. I reside nearby that house in the same area.
Mr. Nath, what is the address of your ancestral house?
আপনার পৈতৃক সম্পত্তি যে ছিল ওটার অ্যাড্রেসটা কি, ঠিকানা?
হাতিয়ারা ঝিলবাগান।
বলুন। হাতিয়ারা ঝিলবাগান।
সেম অ্যাড্রেস, ইকো পার্ক থানায়।
সেম অ্যাড্রেস আন্ডার ইকো পার্ক পিএস।
Mr. Nath, you are again and again try to mislead the court.
আপনি পর তখন সমানভাবে এই কোর্টকে আপনি ভুল তথ্য দিচ্ছেন।
কেন? আমি তো সেম জায়গায় থাকি।
I am not misleading. I stay in the same place.
Mr. Nath, do you agree that you are legally obligated to pay the outstanding debt as per the arbitration award?
আপনি কি মানতে রাজি যে আপনি আইনিভাবে আপনি ওই টাকাটা পরিশোধ করতে বাধ্য? Yes, I agree. I agree.
Mr. Nath, I am putting it to you. When you have already taken loan from IDFC First Bank, then again you have taken a loan from Bandhan Bank. Have you disclosed regarding your IDFC First Bank loan before Bandhan Bank?
আপনি যখন আইডিএফসি ফার্স্ট ব্যাংক থেকে লোন নিলেন, তারপরে আবার আপনি বন্ধন ব্যাংক থেকে লোন নিলেন, তখন কি আপনি আইডিএফসি ফার্স্ট ব্যাংকের যে লোনের বিষয়টা এটা আপনি বলেছিলেন?
না, ওরা অত কিছু দেখে না তো।
No, the persons did not check much details.
ওইটা বছরে বছর রানিং থাকে।
Mr. Nath, I am putting it to you. Are you intentionally delaying the payment to avoid your legal obligations?
আপনি কি ইচ্ছাকৃতভাবে যে পেমেন্টগুলো আছে সেটা আটকে রেখেছেন বা দিচ্ছেন না এই লোনটা পরিশোধ না করার জন্য, এই যে টাকাটা পরিশোধ না
টাকা
করার
তো আমি দিতে চাইছি।
I want to repay the amount.
আমি তো মাসে মাসে টাকাও দিয়েছিলাম 2000 টাকা করে।
I had also paid I had also paid rupees 2000 per month for few months.
Mr. Nath, can you explain why, after knowing about the arbitration award, you are not taken any steps towards the repayment of the awarded amount or any part thereof?
আপনি যখন এই আপনার বিরুদ্ধে যে আরবিট্রেশনে একটা মামলা চলছিল, সেখানে যখন ঘোষণা হলো একটি অর্থের যেটা আপনাকে ফেরত দিতে হবে, সেটা জানার পরেও আপনি কেন কোনো স্টেপ নেননি সেই টাকাটাকে পরিশোধ করার জন্য?
কেন, আমি তো ব্যাংকের সাথে যোগাযোগ রাখছিলাম, 1 বছর ধরে যোগাযোগ হচ্ছে ব্যাংকের সাথে।
কত বছর ধরে?
1 বছর ধরে।
Since last 1 year I had contact with the bank.
Your Lordship, let them file their statements and other documents. Other than that, I cannot conclude the same.
Supplementary affidavit may be filed.
The award debtor is examined in part. Stop. Learned counsel for the award holder submits that the documents referred to in today's deposition be furnished by the award debtor. Push up. Learned counsel for the award debtor seeks to furnish such documents by way of an affidavit. Push up. By way of a supplementary affidavit. Push up. Accordingly, the award debtor is directed to file the documents by way of a supplementary affidavit within November 8, 2024. Full stop. A copy shall be furnished to the learned advocate for the award holder in advance within the said date. Full stop. The matter shall next be listed on November 14, 2024.
Well, 14 is the difficulty one. Can it be 20?
November 21, 2024, comma, when the award debtor shall further be present personally for being examined.
Item number 13, Aditya Birla Finance Limited.
Lordship, on the last occasion, the judgment debtor number 2 was arrested and produced before this court. He was supposed to file his affidavit of asset.
Not filed.
Not filed. The warrant was suspended till 30th September. It needs to be revived, Lordship.
You are the.
Yes.
Please come here. Come to the top. Why haven't you filed affidavit?
Sir, I want to say something. I already settled loan.
You are directed to file affidavit by the court.
I already settled the loan. Aditya Birla loan already settled.
What is about?
Lordship, we need to take instruction regarding that. On the last occasion, he was when he was produced, he didn't say anything
When you were
regarding
produced
that.
on the last occasion, you did not say that. You are directed to appear to. You are directed to file an affidavit of asset.
That time,
Did you say that?
मुझे नहीं पता था. उसके बाद मैंने बैंक
आपको
वालों.
नहीं पता था कि ये लोन सेटल हो गया है?
नहीं, उस समय सेटल नहीं था.
उसके बाद हुआ?
उसके बाद किया सेटलमेंट.
कब?
ये सर on 20th
of this month.
जी.
Lordship, may I hand over letter which we have received last day from the learned advocate?
Your advocate has written that you are not contacting him, not giving him वकालतनामा.
सर I settled.
डॉक्यूमेंट्स कहाँ है सेटल का, सेटलमेंट का?
व्हाट्सएप में है सर.
व्हाट्सएप में है.
जी.
आप प्रिंट आउट दे सकते हैं?
तुरंत दे सकता हूँ सर.
मैं कल रखता हूँ ये. आप लाइए वो प्रिंट आउट लाइए. आप एडवोकेट के जरिए अगर ना अपेयर कर सके तो नो ऑब्जेक्शन लेकर अपने आप भी अपेयर कर सकते हैं. कल मैं ये रख रहा हूँ, कल सुबह 10:30.
10:30.
Okay.
Learned na. It is submitted by learned counsel for the award holder that no affidavit of asset has been filed by the award debtor number 2 in pursuance of the order dated August 29, 2024. Full stop. The award debtor number 2, comma, at this juncture, comma, appears personally before the court and submits that the dues have been settled with the award holder by the award debtor number 2 on September 20, 2024. Full stop. Upon being asked by the court as to whether he can produce documents in that regard, comma, he submits that it's in his phone in soft form and he can produce a printout if so required. Full stop. Next para. Let the matter be listed tomorrow. No, not tomorrow. Monday को रख रहा हूँ मैं. Monday 10:30. Let the matter be listed on September 30, 2024 at 10:30 a.m. under the heading to be mentioned, when the award debtor number 2 shall be personally present in court with a printout of the settlement documents for the purpose of filing the same before the court. Full stop. A printout of the said purported document of settlement shall be handed over by the award debtor during the course of the day to the learned advocate for the award holder. Full stop. Next para. Learned award holder submits a copy of a letter written by the learned advocate for the award debtor dated September 25, 2024, that is yesterday, indicating that the award debtor has not contacted him, comma, nor has had any vakalatnama signed. Full stop. Next para. Be that as it may, comma, the matter shall be listed on September 30, 2024 as directed above, when the award debtor number 2 shall be personally present, comma, for further orders. आप समझ गए तो एक कॉपी प्रिंट आउट अभी वो एडवोकेट साहिबा को दे दीजिए या एडवोकेट साहब को दे दीजिए. बाहर जाकर प्रिंट आउट लेके अभी दे देंगे. वो इंस्ट्रक्शन लेंगे. सोमवार को आप 10:30 बजे यहाँ आएंगे, पर्सनली आएंगे, एक प्रिंट आउट और भी लाएंगे कोर्ट में फाइल दाखिल करने के लिए. ठीक है? ठीक. लेकिन आइए जरूर.
100 सर. 100.
नहीं तो फिर वारंट ऑफ अरेस्ट इशू होगा.
मैंने सेटल कर दिया सर. ये मेरे को बैंक वालों ने कहा कि मैं उनको इन्फॉर्म करेंगे, वो उनको इन्फॉर्म नहीं कर रहे.
We shall also take instruction in that regard.
उसीलिए तो आपको
वो बैंक वाले की गलती.
उसीलिए तो आपके ऊपर विश्वास करके मैं आप
The document.
उसीलिए तो आपको आने के बोल रहे हैं. आप आइएगा, नेक्स्ट ऑर्डर पास करेंगे सोमवार.
Thank you.
Yes. Next.
Item number 14, Grow Capital Limited.
Yes.
Appearing on award holder.
The judgment
They have last for appear and direction on given to file their affidavit of asset, my lord. till date, they have filed or not, I have not received. my lord.
Affidavit of asset you have not filed?
Today
Please
I
use the
have- I
microphone.
have-
Use the microphone, please.
Kindly allow me to file today, my lord.
You should have given a copy.
Because 3 days, 4 days ago, the document was submitted by the judgment date.
We will give it today. I'll keep it on.
Yes.
If in any day subject to my lord convenient for examination, my lord.
I'll keep it after that. Well,
Shall file that.
affidavit of asset. And this is the affidavit of asset of which of the award debtors?
It is affirmed by Sutapa Ghosh, my lord. I think he is
Judgment
judgment number 3, but 2 warrant has been issued against 2 also. 2 is the Rajkumar Ghosh. He has not filed any affidavit of asset.
He is not able to tell anything because he was affected by the nerve problem and
Where are the documents regarding that?
yes, I have a document.
But
This is regarding his medical disorder.
No, my lord, here there is a document which
These are documents relating to what?
what assets, document of registered deed of conveyance.
But he is not being able to affirm that
Yes.
due to his nervous disorder.
Yes, I have.
But the assets are with you.
I
Very
have-
well. I'll
I
give
have
you
it.
liberty. I'll give the award debtor number 3 to affirm this affidavit of asset on behalf of her. Her. Was the relation between 2 and 3?
My lord, both are director of the
Very well. So they are not related otherwise, not relatives. Both are Ghosh.
Both are husband and wife.
So I'll permit 3 to affirm the affidavit of asset on behalf of husband debtor number 2 also. And please annex your medical disorder documents to that asset also. I'll put that in my order.
My lord, today I have already.
Today it's not an affidavit. Don't you understand what I say?
I have filing affidavit.
Please repeat what I have said to you. That
I have already.
you have filed affidavit of asset for
In this
number 3,
Yes, my
not
lord.
for number 2.
But 3 is telling about the.
What are those documents?
This is the medical document and also assets.
Assets of 3
Yes,
or 2.
2 and 3 both.
That is precisely what I am telling you. 3 will now affirm an affidavit. She will annex those documents on behalf of 2 also. Now, affidavit of asset on behalf of award debtor number 2, Shutapa Ghosh, filed today, be kept on record. Full stop. A copy thereof is handed over to the learned advocate for the award holder here and now. Full stop. Next para. Keep the other documents with you.
You file by way of affidavit. You have to file this by way
Next
of
para. Learned counsel appearing for the award debtor submits that award debtor number 2, Rajkumar Ghosh, is suffering from neurological disorder and is not in a position to affirm his affidavit of asset. Full stop. However, the medical documents pertaining to such ailment of award debtor number 2 as well as the documents relating to the assets of award debtor number 2 are with learned counsel. Full stop. Next para. In view of the above submission, affidavit award debtor number 3, Shutapa Ghosh, is directed to file affidavit of asset also on behalf of her husband, namely Rajkumar Ghosh, that is award debtor number 2, within November 7, 2024, and hand over an advance copy of the same to the learned advocate for the award holder. Full stop. The award debtor number 3 shall be personally present in court on November 14, 2024, in order to face cross-examination from the award holder. Within 7th November, you will affirm the affidavit of asset. Award debtor number 3, Shutapa Ghosh, will affirm on behalf of her husband, annexing all these documents. Yes. That will be handed over to them also by November 7. On November 14, Shutapa Ghosh will come and she'll face examination.
Grateful.
Thank you.
Item number 15, Grow Capital Limited.
I am for the judgment debtor.
I am
Yes.
not for the award holder. The judgment debtor, my lord, was in the box.
Yes.
Incident number 2, my lord, was in the box.
Right. Yes, let us continue.
আপনার নাম বলুন। নাম পূর্ণচন্দ্র নস্কর। নস্কর।
You have 10 minutes. So within that Try to cram in as much as you can.
Are taxes being paid for the property as you have mentioned in paragraph 8E of your affidavit of assets?
আপনি আপনার সম্পত্তির হলফনামায় প্যারাগ্রাফ 8E তে যে সম্পত্তির কথা উল্লেখ করেছেন তার ট্যাক্স কি দেওয়া হচ্ছে?
আপনি দেখতে চাইলে ওটা দেখাতে পারেন।
ট্যাক্স
না না, যদি অ্যাফিডেভিট অফ অ্যাসেটটা দেখতে চায় দেখাতে পারেন। 8E উনি বুঝবেন কি করে?
I apologize.
হ্যাঁ, এভিডেন্ট অ্যাসেট।
Of the judgment letter number 2.
এর সঙ্গে বাঁধতে পারেন। ঠিক আছে, এনিওয়ে ওটা দিয়ে দিতে। এটা 2 তো? 2 না এটা কি? না না এটা বোধহয় এইটা।
আপনি এর আগে এসেছেন তো এখানে?
পূর্ণচন্দ্র
এই জিজ্ঞাসাবাদ চলছিল এর আগে।
ওরা দেখিয়েও দিল বোধহয়।
দেখছি পূর্ণচন্দ্র ঘোষ না? হ্যাঁ।
অন্য অ্যাফিডেভিটটা নিয়ে নাও।
পূর্ণ, হ্যাঁ, সবখানে নাম পূর্ণ লাগে।
এই প্রপার্টির ট্যাক্স দেওয়া হচ্ছে কিনা উনি জিজ্ঞেস করছেন।
স্যার এটা আনপার্টিশন ল্যান্ড।
This is an unpartitioned land.
My question to you was, is anyone paying, who are paying taxes in
যদি
respect of this property?
যদি কেউ এই সম্পত্তির ট্যাক্স দিয়ে থাকেন বা দিচ্ছেন তারা কারা? কে দিচ্ছে?
দিচ্ছে মানে যেহেতু জায়গা তো আমাদের ভাগাভাগি হয়নি, এবারে সেইভাবে কোনো দাদা হয়তো কাটতে পারে।
As our property is undivided, therefore some or any of my brothers may be paying the tax of this property.
How do you intend to satisfy the decretal debt?
যে ধার আছে ওই টাকাটা আপনি কিভাবে পরিশোধ করবেন?
আমি তো এই ব্যবসায় অনাদায় হয়ে গেছি, সেইভাবে আমার পরিশোধ করার মতো কিছু নেই। আমার যেটুকু মর্টগেজ করা আছে সেটুকু নিয়ে আমাকে মুক্তি দেওয়া হোক।
I do not have the financial capability to repay the loan. Therefore, কি বললেন শেষেরটা?
যেটুকু আমার মর্টগেজ করা আছে,
The property that is mortgaged be the loan repaid by selling out the property. ওই প্রপার্টিটা সেল করে যা টাকা আছে। একটু গুছিয়ে বলবেন নাহলে অসুবিধা হবে।
In your estimation, what is the value of the property that has been mortgaged?
আপনার হিসেব অনুযায়ী যে সম্পত্তিটা মর্টগেজ আছে তার ভ্যালুয়েশন কত হবে?
ভ্যালুয়েশন মানে আমি ওটা কিনেছিলাম 3 লক্ষ টাকা দিয়ে কিনেছিলাম। টোটাল মানে যে এটা আছে, জমিটা আছে 3 লক্ষ টাকা দিয়ে কিনেছি।
I had purchased the property with an amount of rupees 3 lakhs.
Here at this instance, may I make a prayer for appointment of a receiver for the purposes of sale of such property?
What is the property? Movable?
My lord, the property, the details whereof are appearing at page 63.
So, whether you want to proceed with the cross-examination, see that.
My lord, if I can have the property valued as on date, and if such valuation can
So
satisfy.
you want to stop the cross-examination?
Yes, my lord.
For the time being.
For the time being, since he has deposed that he would like to satisfy the decretal debt by virtue of sale of such.
Would you like to further cross-examine him?
In the event, my lord, the valuation is deficient to that of the amount in due from the judgment
So for the
debtor.
time being, I'll
Yes,
defer his cross-examination, and you're asking for
I am
receiver.
asking for receiver for the purposes of sale of the property.
Mr. Vatajaji, what do you say to that?
My
Because
lord,
your client said that he wants that to be.
I'm agreeing with his point, but the problem is that he cannot pay the amount of the receiver. He is not able to pay me the full fees
There is
of
no
mine,
question
so
of he's paying the
he's
amount.
not having any money to pay. It
There is no question of he's paying.
He's
I hope the
bankrupt now.
amount ultimately doesn't exceed the claim.
Because this property was 3 lakhs in 2017. Now
Yes,
hopefully
after order.
Not a junior member could be appointed for the purpose.
No, the whoever gives me cards, I serially appoint from there, so that there is no bias. I keep it serially, and whoever gave first come, first service.
I am not aware of the process.
No, that I also was not aware before taking up this jurisdiction. The witness is examined further in part, full stop. Further cross-examination is deferred for the time being on the prayer of the award holder, full stop. Next para. In view of the statement of the witness in his deposition, to the effect that he is agreeable to the secured asset being utilized for repayment of the loan, comma, learned counsel for the award holder seeks appointment of a receiver to take possession of the asset for the purpose of ascertainment of its valuation and if necessary, comma, for taking steps regarding sale. Full stop. Next para. Accordingly, such and such blank rekhe is appointed as receiver to take possession of the secured asset. Where is the secured asset described? Anywhere?
My lord, if my lord kindly comes to page 63 of my affidavit in support of tabular statement. This is a part of the agreement, my lord. This is the in part of the agreement, my lord. Column number 1, 2, 3, 4, 5, 6. 6 from the top. Security details.
That residential property?
Yes, my lord.
But no, but that's a joint property, he said.
No, it's been given. It is in his name, my lord. This does not form part of his affidavit of assets. This is the property that he had given to us for the purposes of security to obtain the loan. And my lord kindly, if my lord kindly takes the bunch of documents supplied by the judgment debtor, award debtor on
Must have satisfied yourself regarding the title deed.
Yes, I have. He has also satisfied himself by
He is the owner.
Yes, my lord. He is the sole purchaser of the
Very well.
property.
Of the secured asset being the residential property at Mouza hyphen Paschim Gabtala, GABTALA, comma, JL number 141, comma, DAG number 1275, TO2, 1280, 1275 to 1280 and 1291 stroke 1489, comma, Khatian number 152, comma, 154, comma, PS Kultoli, comma, District South 24 Parganas, comma, pin code 743349, comma, State of West Bengal, at the earliest. First of the remuneration of the learned receiver is fixed at rupees 34,000 for the present, payable by the award holder at the time of taking such possession. First of the award holder shall cooperate with the receiver for the purpose of taking such possession. First of the receiver shall file a report on the next returnable date in the above regard. First of the matter shall next be listed on November 14, 2024 for passing further orders.
Lordship, the next matters, I just want an extension of the warrant of
My lord,
arrest.
sorry to interrupt. The warrant of arrest may be suspended till.
The warrant of arrest issued earlier is suspended until further order. Mr. Trivedi, she said first, she's first. So first come first.
Unqualified.
Two and next two matters.
Next two
Well,
matters.
Mr. Trivedi, what do you want to?
Well, nothing, my judgment debtor in a non-commercial segment of my lord's list, item number 13. It has come way from Uttar Pradesh, a rustic village, my lord. So this will spill over in all probability on the 7th, my lord. The vehicle has already been sold. The award was for 13
So
lakhs.
you
and
want
all.
it to be kept on 7th,
Yes,
and
my lord,
the
because he is an old man, my lord, and if my lord, if can be spilled over to maybe first week of December, my lord, subject to my lord, it is just an amnesty I'm asking from my lord. What
But it's a question of amnesty. After 1 month, in any event, it will be taken after one.
My lord, I would not. He's a poor person, therefore, otherwise coming from there, and aged man, my lord, therefore,
Poverty has nothing to do with the period of adjournment.
therefore, I
1
was saying
month.
amnesty, my lord. Amnesty is the word, my lord, where I'm not
No,
entitled.
no. Where
to
is the question of amnesty? The amnesty has no connection with the prayer.
My lord,
If
the
it was
right-
amnesty regarding reducing the amount, I could have understood.
lord, that is
Which I
right.
cannot do. Which I cannot do.
My lord, that my lord,
Regarding time, I'm keeping it after 1 month in any event. The puja vacations
my
ended.
lord, maybe, my lord, if it is
No, he'll come on
second week,
7th of November.
second week of November, my lord.
Why?
7th, my lord, it is there. 7th, in all probability, will be taken up. 7th of November.
7th, yes.
Can
Why
it
not
be-
7th?
But if it falls, my lord, I will ask him
What?
to come on.
7th and 14th, there is no difference between the two. What is the difference?
My lord, Diwali is on the 31st.
So please call that matter out of turn. On our matter. What is your item number?
My lord, item number 13 of my lord's non-commercial list.
Non-commercial.
আচ্ছা ঠিক আছে আমি নাম্বারটা দিয়ে অর্ডারটা নিন ফাইলটা আস্তে আস্তে বার করুন the matter is being taken out of turn you are appearing for the matter is being taken out of turn on the prayer of the award debtor full stop his award debtor number
1.
full stop learned counsel for the award debtors submits that the award debtor number 1 has come for adducing evidence all the way from Uttar Pradesh.
Awarded
2 হবে ওটা all the way from Uttar Pradesh, and since the matter cannot be taken up today, comma, seeks an adjournment. Full stop next para. Accordingly, let the matter stand adjourned till November 7, 2024, when it will be listed next under the same heading. Full stop, the award debtor number 2 shall be personally present on the said date for being examined by the award holder. Full stop. The warrant of arrest is
Warrant of arrest is
not
not.
warrant of
It is
arrest.
suspended.
আচ্ছা এটাই and next matter call করুন না
Grateful.
thank you
Commercial.
our commercial is finished 16 17 ফাইলটা হ্যাঁ yes extension of warrant
Warrant.
the matter is taken out of turn at the behest of the award holder in view of the innocuous nature of the order sought. Full stop. From the deputy sheriff's report, comma, it transpires that no police report regarding the warrant has been furnished. Full stop. Accordingly, the warrant of arrest is extended until further order, for which due requisite shall be put in by the award holder by tomorrow. Full stop. The concerned police station is directed to file a report. Full stop. The deputy sheriff shall also file a report before the next a further report before the next returnable date. Full stop. The matter shall next be listed on November 14, 2024 under the same heading.
And also similar prayer in 17.
You are appearing 17 same prayer, same order.
Yes. My lord, may I mention item number 9 from the non-commercial list, my lord?
No further mentioning. It's already 120.
आवाज कर
My lord, under compelling circumstances, I am.
Yes, Mr. Bhattacharya, what is the compelling?
I am drawing your lordship's attention, my lord. Lordship has issued an warrant of arrest.
Yes.
But the person, the contemner, who is really innocent, and he had no idea, he was actually not properly advised. He want to file an application for modification. Will your lordship kindly allow?
What is the question of my allowing? You have a right to.
My lord, so the warrant of arrest has to be withheld for some days.
He has been arrested.
No, police reached there, but he was not there,
But you have to file an application.
Yes.
How can I pass an order on that? You should have filed that and come with that. I could have taken up tomorrow.
Just today, it is not.
That is the difficulty. I take up appellate side matters. This is appellate side or origin?
Appellate side.
I take up only on Fridays. We have to wait till next Friday then.
Tomorrow is Friday.
No, that is not possible.
My lord, otherwise he will be.
He must have not appeared. I don't issue warrant of arrest unnecessarily.
So, my lord, some protection.
How can I? Without the file being before me, without the appellate side matters being taken up, that would also be equally illegal.
My lord, can
If you had filed the application today, I could have directed it to appear. But now, what can be done?
My lord,
you have to file a proper application, Mr. Bhattacharya.
My lord, can your lordship accommodate this to let the matter appear in the list?
How can I? There is no application as yet.
Tomorrow is your lordship.
Tomorrow he is to be produced. So instead of producing, if he is, warrant of arrest cannot be stated just like that. You mention the matter tomorrow morning then.
He's standing.
Yes, call on the list.
My lord, from non-commercial item number 9, my lord, warrant of arrest was issued and further then was suspended on the last date of occasion, and today was the date of my lord, further examination, my lord. My lord, my client is here, my lord. If the examination is not conducted today, the warrant of arrest will revive on 30th, my lord. If my lord takes up the matter, my lord, only one judgment debtor, my lord. I'll inform the other side.
It has been suspended till 30th.
Till 30th. Today was the date of further.
So hand over the is appearing in the list.
My lord, item
I'll
number
keep
9.
it as to be mentioned on 30th.
my lord.
My lord,
Give
regarding,
notice to the other side.
My lord.
my lord, may I be permitted, my lord. In the morning, I mentioned, my lord, regarding that Wakalatnama, item number 22, my lord.
Yes, yes.
My lord, the permission to file this Wakalatnama. Second, my lord, the warrant is stated.
What is the item number?
It's item number 22. It's appearing in my lord's list.
বলেছিলাম তো বলে দাওনি
Commercial matter, item number 22.
Yes, you were asking for leave to file wakalatnama.
Yes, my lord. As it is mentioned in the order, my lord.
That was granted to you.
My lord,
Within a week. That's why.
That's why, my lord.
So you want only that? I mean, the extension of that.
An extension of that warrant, my lord. Stay in that warrant of arrest.
The matter is otherwise due to appear when?
My lord, today it was done.
So next Thursday then. Very well.
My lord, and subsequent one development, my lord. Again, another OT.
No, I'll cannot. The learned counsel appearing for the auditor number 2 seeks an extension of the time for filing wakalatnama and submits that due to unforeseen circumstances, the wakalatnama could not be filed within a week in terms of the order dated September 5, 2024. Full stop. On the prayer of the auditor number 2, the time for filing wakalatnama in the department is extended till September 30, 2024. Full stop. The warrant of arrest shall remain suspended till October 4, 2024 or until further order, whichever is earlier. The matter shall be listed under the usual heading on October 3, 2024. Thank you.
Non-commercial matters, company matter new, item number 193 fixed at 2 p.m.
Yes. So this will not take any time. Lord, there's an order passed by your lordship, which is at page 24. Lord, directing sale of some units of a company in liquidation. So your lordship had said that a valuation will be done by court-appointed valuers subject to confirmation of court.
Yes.
So this was the direction. Now, Lord, pursuant to that, Lord, some Lord e-auction notices have been taken out, which shows that the reserve price is set at about 34 crore rupees. Now, Lord, I belong to I represent a consortium of banks who are the creditors of this company. And Lord, we have not had 2 valuation reports done. I've annexed them. Minimum valuation of this is not in excess of 220 crores. Now, Lord, this reserve price has been fixed. We were never given the valuation report. Now, Lord, this would be sold at a huge undervalue. So we had written a letter to the official liquidator saying, please postpone the sale. Lord, they said, look, we can't do anything. You have to approach court. Lord, this is the long and short of it. I'll show your lordship the valuations. Lord. First, Lord, if your lordship would take the e-auction notice, Lord, which has come out, which is at page 26. Now, there were 3 properties not belonging to this company. Your lordship has directed not sale of all 3. As far as 2 are concerned, I have no problems. It's only one of those plants. Not at page 26, if your lordship sees at the bottom, not item number 3.
Yes.
DRI power plant.
Yes.
Not the third column shows the valuation at 34.74 crores. There's a typed copy also annexed, which is on the next page. Your lordship will get it at page 28. It's clearer.
Yes.
So 34 crores is the reserve price. Now I have obtained 2 valuations. Both are annexed over here. Page 45 is one valuer's report. Lord, it starts at 43. If your lordship would come to page 45, your lordship will find market value 70 lakhs, realizable value 70 crores. I'm sorry, I'm sorry.
Page 43 itself.
Yes, at 43, your lordship will find 3 values given: market value, realizable value, and distress value. Lord, each of these is, and this is only the land. Then, Lord, the machinery is in addition. I'll show that to your lordship. Lord, there is also, to show your lordship, this is bona fide. There is a second valuer which we had also Lord, used, page 58. Page 58 at page 59. your lordship will find those values are more or less corresponding. The second value has also given the
Where is the
same
valuation? At page
but
60, there is no value.
page 59. At 59, present market value, realizable value, and distress sale value.
Right.
Not more or less similar.
So, yes.
Now, not in addition, plant and machinery, your lordship will get that. That's separate. Not page 58 is one. Page 84 and page 95 are the two valuation reports, separate ones. Page 84. ₹156 crores is the market value.
Page 84 and 90?
95. So one is valued at 156, the other is valued at 145.
98 apparently.
98, I'm sorry. Yes, 95 at 98. So your lordship has seen roughly 220 to 230 crores if one adds up the two values. Would be the value, and the reserve price is at 35. Now, we are public sector banks. There's a consortium of lenders. Not more than 300 crores is due to us, I understand.
The publication has already been made.
600 crores to the consortium, 300 crores. So
what do you,
It's not only the publication has been made, Your Lordship. The last date for submitting the EMD, that has also expired. Tomorrow is the date for the auction, my lord. That is why my learned senior friends, clients have come up, my lord.
So
Now, it's an ongoing
we
process.
were never given the valuation report.
No, that was never circulated. There was
we could
person
not
to
have
the
known.
Because we are also not aware of
Not
the
if they
reserve
had
price.
asked
All the
us.
reserve price fixed by the valuer, my lord.
When was the advertisement published? I mean,
Not 30th
September.
of August.
Pursuant to the lordship's order.
30th August. No, it was published on 2nd September. It's dated
And on that
2nd
very day,
So you could have come before.
the council was also present at the time of passing this order. If your lordship kindly
see.
sees the order.
Lord, if my learned friend would just let me finish.
Order
Lord,
sheet though.
Lord, we had a, Lord, please have a look, Lord, at page 21. Page 21. Lord, this is a consortium of banks. We have to have meetings. We have to discuss with senior authorities. There was joint lenders meeting held. And Lord, we had to get consensus. Page 21. So Lord, thereafter came the consensus that yes, let us approach
the consortium. The Bank of India the Bank of India is a part of that consortium.
Yes, Union Bank of India. It's Union.
Separate application, my lord, CA number 9, my lord.
But you were present on that date.
But I was present in that date in regard to
That date, not only that date, more important than that, it was published on 2nd of September.
It was published on 2nd of September.
But we are not opposing sale. Lord, let me make it clear. There are 3 properties, 2 we are not. We are not objecting to. It's only the 3rd property where there is this huge discrepancy.
But after publication, the offers have been taken, Mr. Bachawat. It would be too difficult to get the clock back.
Lord,
the not an accrued right, but a right has it has devolved in favor of the participants in the.
May I just just try and not give your lordship some ideas on this. I may be wholly.
Yes, Mr. Bachawat, please.
But the fact is, I never had the valuation report. There was no scope to know it.
No.
Now, Millard, these valuations were obtained.
But the
by
reserve
me.
price was there in the advertisement.
Yes. Now, Millard, may I just indicate this?
Yes.
Before these advertisements came out, we had got the valuation done. It's not that I've got the valuation done now. If the OL had even consulted us or taken the views of the security.
No, Mr. Bachawat, like now, will suppose the will does not consult you.
Yes.
But on 30th, on 2nd of September, he knew that this was the reserve price,
yes,
which does not tell you which is much less than your valuation. If you had the valuation before that, you could have come up before court before the.
Before
not on
the. It has to go through certain procedures. Please take.
You have come up at the 11th hour, Mr.
I understand. I can't say anything about that. But please come to page 21. So this consortium had a meeting. They had to agree first that all of them are going to challenge it. So, after this assessment is arrived at, we write immediately to the OL, which is on 17th. That is annexed at page.
But after the advertisements, the offers have been closed. The date is also over. If you had come before that date, I could have understood, Mr. Bachawat.
In a e-auction, as I understand it, in a e-auction, it's not that offers come and they are closed. And in an e-auction, I thought it's an increasing process. I don't know how my learned friends conduct it. I have no idea. But an e-auction usually proceeds on the basis I put in something for 10, the price 10 shows someone else can put in 11 and it keeps on increasing. It keeps on increasing. But
But there has to be a cut-off date. That date is over now.
No, that happens then. Lord, please see the notice once, Lord. May I just say?
Yes.
Now, Lord, no doubt we have come, Lord. The auction is going to start tomorrow. The auction is tomorrow. Nothing has happened today. My learned friend is giving the impression as if it's all over. Nothing has happened till now.
But the expenses incurred for the
That's a
entire,
different thing.
Well,
That's a
that's a
different thing.
huge
Page
expenses that has been
42,
incurred.
nothing has happened. The auction time is tomorrow, starting at 11 o'clock. Right? It's one thing if the auction had happened, my learned friend, some purchaser could have come up and said, some equities have been created in my favor. Here, nothing has happened. It's only the cost of one Lord advertisement. How much is it? Lord, to save 200 crores, I'm sure the banks will not.
But the last, the auction date is tomorrow.
Yes, it's tomorrow.
So even if an order is passed, it has to be publicized also. So because
No, they simply don't hold the auction. They simply
But there
don't
are
hold it.
3 properties.
Lord, this is an e-auction. Please.
so, Ms. Dasde, it can be done. I mean, because the purpose of this sale is to fetch the maximum value.
Yes,
That is
my lord.
always the endeavor of the court.
Yes, of course.
So there are 3 properties. You can go ahead with the sale of the other 2.
And Lord, what
Objecting to the third one.
What they have done, my lord, I tell your lordship, they've taken a valuation of 2021. Couldn't have done that.
I'll look into that. Yes, what do you say,
Lord, your lordship's direction is after valuation. There's no fresh valuation taken by them.
Oh, acha. No fresh
Yes, your
valuation
lord.
after my order.
That's what I can. That's what I understand, Lord.
But this matter was pending for a long time, my
Maybe,
lord. So
maybe.
this is for the just to conduct the entire sale. And in respect of some other properties, the valuation,
Page 24.
the valuer was
The last
appointed.
3 lines, such e-auction shall be conducted lotwise upon considering the valuation report submitted by court-appointed valuers, subject to confirmation of court. Not as I understand it, but I may be wrong. But the valuation was to happen, and then this is to take place.
No, valuation has already been taken place. Maybe it's
3
way
years
back
ago.
in 2021, but that was also pursuant to the court's order.
And
And
that
that
was
was
in a pandemic year.
And that
when-
has been
when
kept
nothing was
pending for such a long time.
But that can't be excused not to follow the procedure.
And the official liquidator is also not aware of the reserve price because it was all in a sealed cover, my lord.
No. You are granted leave to open the valuation report.
Yes.
And
Yes,
also
for,
the
for
assistant is
for advertisement purpose, and again it was
you can't
resealed,
claim
my lord.
ignorance of the valuation report.
No, we cannot open it, my lord. It's only after obtaining the leave from this honorable court we have been
It
able
was granted in that very order.
Yes, that was
The official liquidator is also granted
the
leave
reserve price because the reserve price has been fixed by the
leave to-
valuer.
No, the official liquidator is also granted leave to open the valuation report in respect
To
of
open
sale.
the valuation
For the
report. but-
purpose of fixation of reserve price.
Yes, for the fixation means the valuer on the basis of the valuation report, my lord. The valuers they have assessed. There were 3 valuers, my lord.
Lord, it's clear from the order that they did not inform your lordships that there is already a valuation report.
No, that was the prayer there.
Yes, what about your submission?
Property number 1, my lord, the solar thermal power plant, which I am concerned, Bank of India.
Yes.
Property is valued around, my lord, 16.54 crores, my lord.
Mm-hmm.
That valuation is around 246 crores, my lord. According to the valuation report, my lord, which in my CA, my lord, I filed the valuation report.
You filed a separate application also. No, Mr. Bachat, no further direction was not given for holding another valuation.
No,
that was
Lord,
not there.
Lord,
They were given leave to open the valuation report only.
Lord,
it was not pointed out by the Bank of India also that the valuation report was of much
Lord,
earlier.
may I just point this out?
Yes,
Lord?
Mr. Bachat, which portfolio?
Lord, my understanding, I could be wrong, Lord. Please. The first, Lord, the big para on page 24, leave is granted to the official liquidator to conduct e-auction through Railtel of the immovable properties, etc. at so-and-so. Such e-auction shall be conducted lot-wise upon considering the valuation report submitted by court appointed valuers subject to confirmation by court. But impression I get from this is that a valuation is to be carried out.
No.
It does not say that a valuation report is submitted on court.
No, subject to confirmation of the court is the
No, I'm not on the confirmation. I'm not on confirmation. But confirmation of court, I'm not worried about.
No, it's in past
Upon
tense, submitted.
considering-
Such e-auction shall be conducted as lot-wise upon considering the valuation report submitted by the court-appointed value. That may mean either way.
It could, but not that's the impression I got because not of what is also not there later. Not the third pair on the next page, official liquidator is granted leave to open the valuation report. It's as if a report is going to come, it will be open. Otherwise, your lordship would have normally opened it up and said, look, this will be the reserve price. Normally, that's
the
what
valuation report was lying with the assistant registrar company, my lord. We did not have any access. It was only after obtaining the leave, my lord, we had the access to reopen it, just to open it, again reseal it.
I'm not blaming my
Regarding
lord.
property,
You have
the
not
asset,
suppressed anything.
the asset number. No, it's not a question of allegation against you. The asset number 2, there is no
No allegations
controversy.
or no objection, I believe.
Not by us.
Well, this has to be considered, Ms. Dasde, these applications. I mean, you go ahead with the
But
item number
tomorrow, your lordship, instead of stalling the entire procedure,
No. Then rights will be
let's
created.
see what is the actual amount. What is the
Actual amount will come.
is
The
fetched-
bids will come
is
only on
fetched
the.
from the
No, Ms. Das, the bids will only come on the reserve price. If the reserve price is higher, people will know that the reserve price is higher.
because we do not know what is the
there's a-
amount they have received because my instructions there's a lot of offers received, but we cannot open it, so we don't know. But tomorrow when the auction will be conducted, everything will be there, my lord.
Auction is to be conducted tomorrow.
Yes. And the offers, because EMDs and everything were submitted. Yesterday was the last date, my lord.
No, Ms.
Instead of stalling the entire, let it go on, my lord. If they are
if the
anyway aggrieved, my lord,
if
they
the
can
auction
come up and
goes through-
challenge it.
If the auction goes through, then these people will have accrued rights in their favor. If the auction goes through and there is a highest bidder, he or she will or it will have an accrued right. How can we divest them of that right then? We cannot.
The OL can't play with money belonging to us because
No,
not if
no,
they are
no.
secured. They are
They're not
secured
playing
assets.
with the money.
They are secured in my favor. They have nothing to do with it.
But they're coming at a very
They can have
belated
nothing
stage,
to
my
do
lord. They could have come up much earlier, then we wouldn't have gone for this process, my lord.
True.
Lord, in fairness, my learned friend should have had it valued instead of relying on a valuation.
On the basis of that valuation, maybe
The valuation is of
2021.
2021.
COVID years, COVID valuation. Could it have been relied on at all?
But then 2 also has to be revalued.
Then again a fresh valuation has to be done.
Yes.
It's a
Yes.
de novo process of the entire.
Not de novo because the valuation is of 2021.
No, again the
We're in
valuation
2024.
valuer may remain same, but again the valuation
No,
because
but
of
Ms. Dasde,
taking
how can you
taking
proceed
care
with
of the
how
present
can you
market.
proceed with a sale on the basis of 2021 valuations? You should have been conscious of that. Just because the court gave you the leave, you are proceeding on 2021 valuations for a sale in 2024. These are all immovable properties and solar thermal power plant, etc. Landed asset. And not only that, there are plants and machineries on some. They might have depreciated, but the assets must have the valuation must have enhanced.
Appreciate.
In three years, it must have appreciated.
But there are some also must have been depreciated also. So
Must have appreciated.
appreciated or depreciated.
Appreciated the
otherwise.
plants. Plants.
and
The
all those
valuation of the
machinery.
plants is much
But
less.
in respect
The
of the lot
depreciation has
2,
been
my
taken
lord,
into
since there is no
account.
objection.
The plant has been valued in July by us.
So lot 2 also you are.
Lot 2,
Lot 2
but
also you are
still
proceeding.
there is no objection
Even if
received.
there is no objection, the same logic holds. The same logic holds. 2021 valuation, we cannot proceed on the basis of that.
If your lordship so holds, then the EMD, whatever EMDs have been received,
Return.
then have to be returned back,
Yes.
my lord.
What is the difficulty in
Yes.
returning that?
Point keeping lot of other people stuck. It's pointless.
Yes,
No, unless I have the order, I cannot do
No,
that.
how can you?
Yes.
Both of you are petitioning, you are creditors.
Yes. not-
Secured creditors, both.
Yes.
Both are banks.
Yes.
The present applications আচ্ছা কুন্ডু তোমার প্রচুর ভুল হচ্ছে তুমি ঠিকঠাক করে you have to carefully. The two applications have been filed by two secured creditors of the company in liquidation. Push up. Next para. Learned counsel for the applicants point out that the sale, the e-auction sale, comma, pursuant to the order dated August 29, 2024, has been fixed to be held on held tomorrow, that is on September 27, 2024. Push up. It is pointed out that the reserve price has been ascertained on the basis of valuation reports of the year 2021. Push up. It is contended that the three properties involved primarily pertain to immovable assets, comma, in some cases along with plants and machineries. Full stop. As such, comma, in the past 3 years, comma, the valuation must have appreciated. Full stop. Next para. In any event, comma, valuation reports have been annexed to the applications, indicating that as per the report of the independent valuers appointed by the two applicants, comma, the current valuation of the properties is much higher than the reserve price as depicted in the sale notice. Full stop. Next para. Learned counsel places reliance on the annexures to the applications in support of their contentions. Full stop. Next para. Learned counsel for the official liquidator submits that huge expenses have been already borne in undertaking the previous valuation and in advertising the sale. Full stop. As such, comma, if the sale process is halted at this stage, comma, the official liquidator shall have to refund the EMDs deposited by the bidders and by the prospective bidders, and also to hold the entire process of sale and valuation de novo, comma, which would eat into the funds of the uh, company in liquidation. Full stop. Next para. Upon a consideration of the applications and the annexures thereto, comma, it transpires that prima facie there is sufficient materials on record to indicate that the reserve price has been fixed on a valuation in terms of a report of the year 2021. Full stop. It is obvious that since the assets comprise primarily of immovable assets, comma, the price must have appreciated much since the year 2021, and comma, as such, comma, it would only be prudent to proceed with the sale by fixation of reserve price on the basis of current valuation reports. Full stop. Next para. As such, comma, the official liquidator is restrained from going ahead with the scheduled e-auction sale as scheduled tomorrow. Full stop. Next para. Consequentially, comma, the official liquidator shall also refund the EMDs already received from prospective bidders, and you also have to put up a notice to that effect, and put up a notice and publish a notice, further notice, within 7 days in the newspapers where the sale notice was carried, to the effect that the said e-auction sale has been cancelled by virtue of an order of the court. Full stop. Next para. The applications shall be heard on merits on November 7, 2024, when the matter shall be listed for further orders. If you want to use, do you want to use any opposition to
No,
this?
my lord,
I
but
don't
in
think.
But I don't think so it's any point of keeping the matter alive, because
What should
if
it-
they can appoint their own valuers and get it
That
done.
They have already annexed those.
We
Ah.
annexed it. Can it be done on the basis of those valuations? They can, from that valuation, choose the way they want.
Because let
You
their
have,
valuer.
you have valued the item 3 property
Yes.
and you won.
So on the basis of their valuation,
Regarding
this
2,
can
what
be
will
done.
happen?
Because
Regarding,
again,
regarding
valuer
2,
appointed.
valuation has to be done.
Yes, that can be done. That can be done by the same valuer, the impanel valuer who has already done the valuation of that property. But my lord, it's one thing, the EMD has been received by the E-Railtel, not the Railtel Corporation has received the EMD, not the official liquidator. So that needs to be
No,
corrected.
they have done it on behalf of you.
On behalf, because that platform is being used as per
যেখানটা
the
বললাম যে
guidelines to be
refunded
maintained
বলেছি,
by
একটা
the
জায়গাতে refunded কথাটা যেখানে ইউজ করেছি, EMD shall be refunded
Railtel
by the official liquidator through
licensed auctioneer.
the licensed auctioneer. Railtel, what is the full?
Corporation Limited.
ওটা আগের অর্ডারে ছিল দাও।
Corporation of India Limited. Railtel Corporation.
That is the Railtel Corporation of India Limited, within bracket designated E-auctioneer as per the guideline of the Ministry of Corporate Affairs, bracket closed.
So
Should
may I
I
suggest
directly to
there
go?
is no point of keeping these matters alive, because since because they are challenging only the valuation, my lord. So again, a fresh valuation is going to come up
Matter shall
before
next
you.
be listed যেখানটা বলেছি ওটা কেটে দাও, তার বদলে করে দাও। Accordingly, এই অ্যাপ্লিকেশন নামগুলো CA 9 of 2024 and yours is CA
8. Ours is
CA 8 of 2024 and CA 9 of 2024 are disposed of by directing the official liquidator to. No, then 3 properties have to be sold together. You want to sell
No, not
1 and
sell,
2, 1 and
because for
3.
the second one, the valuer of the official liquidator
1 and
is
3
going
want
to
to go
revalue.
ahead.
Yes, and the 1 and 2 is the valuer to be appointed by the
They
respective
have already.
banks.
I'll ask you to
Yes.
proceed on the basis of the valuations. But there are 2 valuations you have given.
My lord, they are free to choose from them or take the higher or the lower. What would be the better way?
No, no.
Lord,
That will be appointed by the secretary. Evaluation can be
or that will at least be binding on all banks then. Otherwise, your lordship may have some.
Or the valuer appointed by the official liquidator, and their valuers can, this is what my instruction is, they can sit together and get the thing done. Maybe if it is can be done jointly, because it'll any the benefit for all the creditors, my lord.
But it will save some expense. Let the OL
But
convene a meeting where he can meet these valuers and they can fix a value for these.
Very well.
It's only subject to everybody's convenience.
Thereby directing the valuer already appointed by the official liquidator to have a sitting on a commonly agreed date with the valuers appointed by the
Union Bank and Bank of India.
applicants in CA number 8 of 2024 and CA number 9 of 2024. Full stop. The said valuers, comma, in the meeting as directed above, comma, shall arrive at a consensus as to the current valuation of the property on the basis of their own feedbacks. Full stop. Accordingly, the said agreed valuation shall be forwarded to the official liquidator for fixation, for the purpose of ascertainment, fixation of the reserve price in respect of the assets described in item numbers, in lot numbers 1 and 3 in the advertisement for in the sale e-auction sale notice annexed at page 26 of CA number 8 of 2024. Full stop. The said valuers shall have a joint inspection of item number 2 as depicted in the said e-auction notice dated August 30, 2024, which was published on September 2, 2024, comma, for the purpose of ascertaining the current valuation of lot of the property of the asset described in lot number 2, whatever they repeat. Anyway, full stop. Next para, upon such valuation being arrived at by the said valuers, comma, the current valuation of the asset described in lot number 2 shall also be forwarded to the official liquidator. Full stop. It is expected that the entire process, how soon can we evaluate the lot number 2? I'll give you 3 weeks for that.
Lot number
2 also has to be evaluated.
Lot number 2.
Secure creditors is IFCI. But the IFCI is not, did not raise any objection with regard to
these
the
applicants,
valuation.
because they are
Yes,
raising
yes,
the bogie,
yes, my lord.
Yes. So do it within 3 weeks. That the entire exercise 4 weeks. The entire exercise.
But I understand because of pujas, it may be difficult to persuade people to do it within that time.
So let it be done by November 15th then. 15th of November. The entire exercise shall be completed within November 15, 2024. Full stop. Next para. Upon the valuation, the current valuations of the 3 assets covered by the e-auction notice being forwarded to the official liquidator, the official liquidator shall hold an e-auction upon publication of appropriate notice in consonance with the directions in the contained in the order dated August 29, 2024, preferably within December 13, 2024. Full stop. Next para.
13 December, my lord.
13 December.
1/3.
1 month after you get the evaluation reports. 1/3. 1 month I'm giving you. 1 month I'm giving you 1 month.
But one suggestion I had, not subject to what not my learned friends also feel, but we are not the only secured creditors, there are others. One does not want them coming and then challenging not those valuations and saying it's higher. So when the OL not gives a notice for the meeting, he might as well give a notice to all secured.
I'll put that in, yes. Within December 13, 2024. Full stop. A report with regard to the in that regard shall be filed on the next returnable date by the official liquidator. Full stop. The matter shall next be listed in the monthly list of January 2025.
Yes, in the meantime, I believe everything.
Full stop. Next para. Acha. একটা line add করে দাও. It is made clear that the official liquidator shall, within a week from date, give a notice of serve copies of this order on the remaining creditors,
secure creditors,
of the remaining secured creditors of the company in liquidation. Full stop. The said secured creditors shall also be at liberty to designate their own valuers to participate in the meeting and to undertake a fresh evaluation of the 3 assets, if they so choose. Full stop. This much.
My lord is seeking only one indulgence with regard to the expenses, because already in expenses, because my
All
lord's
goes from
order
the-
was also that it goes
from the funds of the company in liquidation. They are affected.
Doesn't have, because the assets have been not been sold yet, my lord. So usually these are all taken from that sell proceeds, but that
The expenses for what? The
the
publication.
secure creditors, if they can bear, because already there was an order for making that expenses, my lord. And if your lordship kindly sees the
For publication and the
and for
valuation.
the evaluation, whatever the entire process.
Is being done by the other.
Yes, valuation,
Then it
and
will have to be
for the entire auction process, my lord.
You are one of the creditors. The secured creditors will share
All the second on pro rata basis, then if they can.
Yes. The expenses for conducting the e-sale, e-auction sale, including publication expenses and other expenses, as well as appointment of valuation for the purpose of appointment of valuer, shall be borne on pro rata basis by all the secured creditors.
My lord, if your lordship says bond, some don't pay, then there will be a problem. Your lordship could say bond, lord, at the very end. But at the moment, someone will have to pay, and then it will be distributed pro rata. Not your lordship can say it will be not borne by the two appearing parties for the time being. Or it could be discussed at a meeting of the liquidator. Not at the liquidators meeting, whoever turns up, not the fees can be, the sharing can be decided.
It will be open to some of the secured creditors, including the present applicants, to bear the above expenses for the time being, subject to realization on pro rata basis from the other secured creditors. What else?
No, EMD, those are to be returned from the Railtail only.
It's through Railtail, I've said.
And it's actually, this matter was returnable on 3rd of October. So for the filing the report of the sale confirmation. So that becomes redundant now. Okay.
Needless to say, the official liquidator shall not be required to file a report in connection with the e-auction sale, which was scheduled to be held tomorrow.
3rd of October.
E-auction sale was
Tomorrow. Yes,
Yes,
and
that
I
is what
was
I've said.
supposed to file. Yes, in
I've said that only.
Deeply obliged.
Item number 118, Corporate Ispat Alloys Limited.
My lord, I am appearing for the applicant, my lord. My lord, here, my lord, on the aspect of whether, my lord, I am a secured creditor, my lord, on the last occasion, I took time, my lord, to submit, my lord.
Yes.
My lord, I have, my lord, shared the two judgments I will be relying upon. I have shared, but, my lord, only this morning, my lord, I could share.
Ms. Chakravarti, put in a short written notes of arguments.
My lord, I will not take much time. I will just place
Give
the
a half-page written notes because this is being taken up on so many dates.
My lord.
Initially, I
shall.
had track, but now I have lost track.
Very well, I
Just
shall
put
try.
it a half-page written notes of arguments. I have got my notes also.
My lord,
Just to Ms. Dazdi, you can or you may not have. Just put in a half-page
Yes,
written
I
note.
will also.
Just the bullet
Yes,
points
yes, yes,
and the
because-
judgments.
Yes, my
So do it when? When should I keep it? You will argue today?
My lord, I will just place two judgments. My lord, since my lord, I have given the copies, my lord, only my lord this morning. My lord, perhaps my lord, Miss Dasde has no. My lord, so my lord, any day I can come back. Any day, my lord.
But in respect of this particular issue, may I submit only one thing?
Yes.
That after the order passed in 2015, order passed by Justice Banerjee, my lord, subsequent thereto, there was another order passed by Justice Aurinder Mukherjee in respect of the same CP. And the winding up order was passed in a different CP that was by Justice Arindam Sinha in the year 2019. So may I hand up a copy of this order? 20.
You can annex it with your written
Yes,
notes.
yes, I will
Fardita?
definitely.
Yes. I'll not take it up today.
only
You just
the-
yes. Just annex it with your written notes of arguments, and on the next date you can just compositely because she has given you
And
copies
from
today.
the definition of the secure creditor, she doesn't fall within that. And even if I consider the waterfall mechanism, she's an employee and she can be only be treated as a preferential creditor, and she has to be in the queue. The moment when it is going to be disbursed,
Ms.
automatically
Dasdat,
she'll
because
get the
I was
chance.
against her initially, that's why I gave her opportunity because she
Yes, my
wanted to
lord.
use further
Yes.
judgments. So that's why only I gave her the opportunity.
Yes,
Prima
so-
facie, I'm against your proposition.
My lord, on this proposition, because my lord, that is the reason, my lord, I have taken out two judgments. One is, my lord, a judgment of the Court of Appeal, which is also, my lord, followed by our High Courts, my lord, High Court of Gujarat, my lord. My lord, I have shared both the judgments. My lord, I will include in the note, my lord.
When should I
kindly-
keep it? Tell me a date when
Any
you
day,
will advance short oral arguments and I'll conclude the matter
lord.
and take the written
My lord,
notes.
my lord.
When should I keep it?
My lord, next Thursday, my lord, because it's a company day, my lord. I can
Very
come.
well. Learned counsel for the petitioner seeks to rely on certain additional judgments, copies of which have been shared with learned counsel for the official liquidator today. You've given only today. Full stop. Accordingly, to enable learned counsel to come prepared on all issues and to file their respective brief written notes of arguments. Let the matter be adjourned till October 3, 2024, when it will be listed under the self-same heading.
Grateful.
Item number 119,
Not today.
item number 120,
Same advocate, not today.
Item number 121.
Your Lordship, I appear for the petitioner.
Yes,
I am praying for an adjournment, Your Lordship.
granted.
Great.
They're all in respect of the same company in liquidation.
to?
Up to 121, my lord.
Let it be 120. This is 120.
They're all the employees they have come up. So you'll abide with the result of that because they are also want their money, but
Yes,
not
Your
in the
Lordship.
respect of.
Why are you asking for time in these matters? You are for the employees. The puja vacation is coming.
Your Lordship, I am one of the creditor in this matter. I actually,
Creditor, you take time. Very well. Employees should not take time. The puja. Anyway, since he is not here, not today.
gratefully, Your Lordship.
Thank you.
Item number 122, Rajiv Garg.
This is my appeal from an order passed by the Company Law Board, my lord, on 29th of September 2014. Now, this is an appeal under Section 10F of the 1956 Act. And my lord, your lordship will see there is an associated cross objection by Mr. Banerjee, which is the next item number.
There will be, yes. Duto item action on that.
I'm opposing, my lord.
Yes,
my lord, if I can give your lordship, kindly have a look at 10F, my lord. It's on a question of law.
Have to start from there.
Yes, please have, my lord, 10F.
Yes.
1956 Act. Told it. Unless it gets capital, it goes for 2 hours. Yes, kindly have section 10 capital.
What is the scope generally? Fact and law?
Yeah. No, on a question of law. But now, my lord, it's received.
Yes, on any question of law.
It's received judicial interpretation in the context of 10F by the Supreme Court saying perversity akin to a second appeal if material evidence is ignored
Yes,
or contrary.
basically section 11. Section
Not-
100. Section 100.
It's basically, my lord, similar to section.
All right.
My lord,
Mr. Roy also says so.
Mr. Roy agrees with.
Then it has to be.
Roy, my lord, always has different views as well, my lord, on everything.
That's not my comment.
I don't know, my lord. That's what he's going to say.
Does anybody have a duster?
Just, my lord, 10 years, my lord, that the appeal, my lord, has been.
Only 10 years.
I don't know what survives in the appeal, but I'm sure, my lord, understands.
Yes, you may comment, yes.
Now, my lord, if I can
Waiver, I mean.
just give your lordship, my lord, a very brief, my lord, overview. But my lord, kindly don't hold me to that overview. That is only for your lordship's benefit because I will need to take your lordship through, my lord, the order also.
Should I make it parted before the vacation?
My lord, that is up, my lord. Frankly, this matter will take some time. This is not a matter that can be heard by your lordship in 20 minutes. Because the order itself runs into about 25 pages. Mr. Banerjee says unless it's dismissed. I agree with him unless it's dismissed. But I don't think this matter warrants a dismissal because
We'll see that, my lord, when the time.
at least not in limine as Mr. Banerjee would suggest. But this will take time. This will take time.
Keep it after the
Took a
vacation.
considerable period of, my lord, there. And, my lord, so, my lord, I don't know how much, what survives, but I'm sure when the appeal is taken up, my lord, that will be, my lord, a point, my lord, which, my lord, will.
I'll keep it after the vacation.
Any day, my lord.
I'll keep it on the
Because your
very
lordship
first
takes it on
Thursday. After.
Thursday.
Yes,
Yes,
I'll
very
keep it
well.
on the first Thursday after.
Now, 14th, my lord, Mr. Mukherjee is also leading me.
7th, my lord, I have some difficulty.
Mr.
my lord.
I'll put it on 7th. 7th.
My lord, 7th, I have some difficulty.
7th you
My
have.
lord, Mr. Mukherjee and I are in difficulty on 14th. We have a part heard matter fixed before court number
Then
4
it will be 21st.
in the second
Right.
half.
21st.
21st.
21st, I can keep it at 2. I can fix it at 2.
Very well.
Yes.
Considering the ambit of the present challenge and counter challenge, comma, it is doubtful as to whether the hearing can be concluded before the upcoming puja vacation. So accordingly, let the matter be listed on November 21st, November 21, 2024 for hearing, for being heard at 2 p.m.
Grateful, my lord. Both matters, my lord.
Both.
Great.
Challenge and the counter challenge.
That's right.
Sub documents are
Matters করে দিও ওটা. Thank you.
Item number.
Stay application, I understand, my lord, has all the papers, so, my lord, it will be only heard on. So,
Then I'll not direct any.
no.
122 and 3.
Yes, 120.
Item number 124, Avani Projects.
Your lordship, this is an application by one of the Avani project's home buyers for registration in their favor, your lordship, of the flat which they had applied to, and entire consideration has been paid, your lordship. Even we had approached the RP, we had shown that entire consideration is being paid only, and we have also been given the possession.
A resolution process is ongoing.
Your lordship, yes, but there are no resolution applicants.
Can you
will
pass
show your
orders?
lordship.
Can you pass orders during pendency of the resolution process?
Yes, your lordships, previously several orders have been passed. in
Can we
this
do
matter.
that? Previously orders were passed does
Your
not mean
lordship,
that
the
we can
only
do that.
thing is that this is in the nature of a
Confirmation of something which happened earlier, no?
yes, your lordship. Essentially, what remains is that the consideration has been paid, the possession has been given. The only thing which remains is the registration and nothing more. So the only direction which we are seeking here before your lordship is for directing the RP to
The
register. in a-
sales were confirmed.
Yes, your lordship.
Consideration was paid. Was it a court sale or?
No, your lordship. This was prior to liquidation, prior to winding up, your lordship. Before all those happened, the
But the
applicants
difficulty is
had
that
applied.
that will affect the assets of the company.
Your
under
lordship, that
resolution.
is what I am seeking, your lordship. Those are no longer the assets of the company because everything has been made prior to that. The,
What has been made
consideration has been paid prior to that. The possession has been given to us prior
Unless the
to that.
title passes, it remains the asset of the company.
But possibly, your lordship, then kindly allow us to satisfy on that front, your lordship, because firstly, previously your lordship had raised an issue before us that whether the Honorable High Court has the jurisdiction to pass any order. That I have to satisfy your lordship.
Why can't the High Court have? Why did I raise the?
Basically, your lordship, the winding application was filed,
Oh,
and thereafter also an application under IBC.
IBC is the more difficult part.
But may I assist your lordship on this? But previously, a winding up petition was filed before this court in the year 2016 against this company. A winding up order was passed. The provisional liquidator was appointed over all the assets of the company. Now, before that, various persons had purchased flats from this particular developer, and the owner of the particular lands were all different. Now, after the winding up order was passed, proceedings before the NCLT was initiated under the IBC, where an order was passed admitting the company into the CIRP. Now, there an issue rose because after the CIRP order is passed, the resolution professional has to have all the documents and the details of whatever records are there in respect of the company, has to have all those in his possession. But since the official liquidator was already there, appointed by this court, all the records were before the official liquidator. So the resolution professional applied before this court seeking a direction upon the official liquidator to hand over all the records or photocopies of the records to the resolution professional. There, this issue arose as to which court would retain jurisdiction insofar as the company is concerned and how to go about it. An order was passed by the single judge. There, it was held that since a CIRP is under the Insolvency and Bankruptcy Code has already been commenced, the CIRP will be conducted before the NCLT. But if the CIRP fails, then the eventuality is liquidation. But the liquidation will happen before this court. Well, that was an order passed, whereby this court retained jurisdiction insofar as the liquidation is concerned. Because under the Companies Act, although there are provisions for scheme,
if resolution fails, we cannot reassume jurisdiction.
That is the order which was passed because
that was not challenged by anybody.
No, your
that was
lordship.
not challenged.
Was
That has
not
attained
Everybody's interest. That's why.
And your
the rationale, perhaps.
What was the rationale?
That was that under the Companies Act, in a winding up proceeding, there was no formal procedure for resolution of a company. It is liquidation from the very beginning, unless
doesn't the IBC subsume every other procedure? No.
Yes,
IBC is all comprehensive.
Yes, but IBC, in case of failure of CIRP, liquidation
everything.
commences.
Yes,
your lordship, those provisions have not been repealed. The provisions in the Companies Act have not.
Non-obstante clauses are there galore in the IBC.
Yes, your lordship. The only difference which remains is that the maximization of assets, which is the principle in the IBC, that can be applied at best at a stage before liquidation. Because once it goes into liquidation, everything follows.
But now the company is in moratorium.
Company is a moratorium.
Yes,
so we cannot touch it. This will be directly, divesting the assets of the company.
why,
which will affect the corporate, the resolution ultimately.
Why,
if sale deeds are executed in your favor and registered, those will affect directly the assets of the company.
But
And resolution, what will remain for the resolution to be, I mean, for the resolution professional to do? If the assets are directed to be transferred, that too by a company code. I don't think that is
in this,
civil in law.
what in the IBC, there are, in case of a real estate company,
Hmm.
there are specific provisions to the effect that in case of real estate company, there are various projects. Now, if the company goes into the CIRP or in liquidation, all those real estate projects come to a standstill,
Yes.
which would affect the interest of the bona fide home buyers.
True.
So for that, there are amendments which have been carried out, and there are judgments which govern the field, which is in respect of specific real estate projects, the home buyers can themselves come, take over that particular real estate project and continue with it, which would then
even then they have to approach the section 7, I mean the
NCLT. Yes,
NCLT
for that they would. Now, my lord, insofar as certain flats are concerned for which the conveyance has not been executed, although consideration paid and agreement for sale, etc.
So these will be claims under the IBC. You can approach the resolution profession. I'll give you that liberty, but the company code cannot
there are
direct
some-
registration to.
but there are certain areas which, the certain orders which cannot be passed by an NCLT, your lordship. If I may take your lordships through the order of 12th December 2019 by this honorable court, your lordship. We had your lordship, we had handed up
that
from
is
your
the
hand-
order which
this one.
Yes, your lordship.
All right. Yes. Thank you.
Your lordship kindly considers this is a very longish order, your lordship. If I may
What do
only
you mean by ish?
I
It's
apologize.
long.
Yes.
Yes.
If I may
Yes.
draw your lordship's kind attention to para 4 at page 3 first. After appointment of the provisional liquidator, the hearing of the main winding up petition could not proceed, so much as several applications were made from time to time by persons who intended to purchase.
This is the order where it was held that it would the liquidation, after liquidation, if the resolution failed, it would come back to this court.
Yes, it will retain jurisdiction. It will, it can't proceed until the resolution plan.
Can we stop arrest it midway? If the resolution fails, then liquidation under IBC has to be proceeded
Your
with.
lordship, in furtherance of this, another subsequent order was passed also in these proceedings.
in that
and
order,
also,
which my learned friend mentions, in that order, it was held that the flat in question in that particular application is no longer an asset of the company in liquidation. So that is why that order, an injunction was passed on the resolution professional not to dispose, not to interfere. And in pursuance of that order, and a separate order has been passed directing the resolution professional to execute the deed of conveyance. Now, what used to happen is that since the resolution is always for the benefit of the creditors, and the home buyers are the creditors of the company.
Undoubtedly, but they have to approach under the IBC scheme. They have to approach the resolution professional.
Yes, that option is also there, and still this
is it an option or is it a mandate of law?
But this,
I mean, because they have paid consideration this much.
Yes.
They have been given position.
Yes.
Wouldn't they have to file a suit for specific performance otherwise?
But
if they did, they have an actionable claim at best.
Yes.
They don't have a right in presentee.
Well, that your lordship has said, that has been.
The Transfer Property Act says that.
The agreement for
Section
sale, it
54,
is at
yes,
best an actionable
obviously,
claim.
yes. At the best actionable claim.
But since it is for the benefit of the home buyers, this view
for the benefit, you can flout the law.
Absolutely, that is true.
I don't have the power to flout the law. I would love to benefit them, but I don't have the powers.
That is true. But this court, since it retained jurisdiction in some sense, so far as the liquidation is concerned, that is why many applications were filed and orders have been passed. But we are not coming in the way because we don't have anything to do with the asset, we as in the resolution profession.
Take a chance before a better court knowing the law better. The limited law I know regarding IBC and company law, I know nothing almost. IBC I know something. But the limited law I know, I cannot permit this to happen. But you are in the company assets are in moratorium. You are asking for registration of a sale deed in your favor from the assets which are under CIRP.
That I appreciate fully.
No court of law can do it under the law of the land. Yes, maybe some courts can do, but I can't.
But your lordship then kindly
I'll
maybe
keep it after
come
the
back,
revision.
kindly allows us to
Yes,
come back
yes.
on the next week, because I'll show those provisions under which, in the nature of which we are seeking this order, your lordship. And your lordship, I'll also would want to place this order, particularly of 12th December. The reasons, the grounds given are quite extensive, because there are some areas in which the order cannot be passed by an NCLT, which this honorable court can pass, which is why the jurisdiction was retained.
What is the area relevant to your case?
Yes, your lordship.
Tell me one such area in your context. There may be certain areas, gray areas. Yes, you're right. But I mean,
insofar as
transfer of the assets of the company.
That's
That's not an area which is gray.
I may,
Yes, your lordship.
I may add one thing here. When the CIRP commences, an asset list is prepared of the company, which the RP generally takes possession of.
Right.
And or is the custodial legis of the company.
Yes.
Now, insofar as these flats are concerned, or various flats are concerned, in which the company deemed to be doesn't have any interest, those assets have not been made a part of the asset list. That is the position now. But your lordship is absolutely correct. We can't join issues here. That it still remains an asset of the company in liquidation, unless the title is transferred, formally conveyed by way of an execution of a conveyance deed.
Only test in my, limited knowledge is that whether this would affect the ultimate resolution. The resolution will definitely be affected if some of the assets of the company are deflated like this. They're allowed to be transferred to third parties.
But your lordship, in the I submit that the concept of deemed ownership possibly comes in, because
Deemed ownership?
Yes.
What sort of creature is that?
Your lordship, because what remains is only the registration, and the possession also has been delivered.
I'll ask you only one question. Answer me yes or no.
Very well, your lordship.
Under normal circumstances, if this was the scenario, you had paid the consideration, you had been given possession, no sale deed registered.
Very well.
Wouldn't you have to file a specific purpose suit, sir?
Said your lordship that under ordinary circumstances, yes, but your lordship, here we can.
What is the extraordinary circumstance?
Because your lordship, when the winding up of a company is before this honorable court, we can always ask, we can always pray that this property is not the asset of the company. By virtue of
one such order which we'll have to place with your lordship, an order passed by Justice Bhattacharya. But we shall place. I don't have the copy of that order now.
What was the ratio of that?
Your lordship, may I place only annexure G of one of the applications?
CA 47 I have with me.
CA 47.
If you can place it from there.
CA 47.
All of them have permitted. Justice Mukherjee, Justice Chakraborty, Ashish
No,
Chakraborty.
your lordship,
Then I must be wrong. Yes, if all the company courts, Justice Ashish Chakraborty's order is there, Justice Anindam Mukherjee,
No,
Justice
your lordship.
Moushami Bhattacharya.
Finally, it was allowed by Honorable Justice Kapoor, but before that, in furtherance of this order of 12th December, your lordship, I only want to place one order
Place
of
that.
Honorable Justice Bhattacharya
Yes.
at page 66, your lordship.
Not 6. Yes, I've got it. 67.
Asset.
Order dated 20th of November.
Yes, your lordship.
Yes.
This application has been. Should I only place the operative portion, your lordship, or the
just the ratio at least? This was an application for similar application.
This was
Like
a precursor. This was a precursor to a similar application.
This was for preserving and protecting the
Yes,
property.
that was the precursor.
The IBC was on, the CIRP was on at that stage.
Yes.
It had
Yes, your
started.
lordship.
Let us see how the court did.
2019.
So that was not, was that considered by the court? Yes.
Yes, your lordship.
Resolution professional also
Your
was
lordship,
represented.
when it comes to page 4 of the order, page 3 of the order.
Page
your
3, I
lordship.
am there only. Yes.
The
yes.
last paragraph.
Yes.
The primary issue is the construction of the judgment dated 12th December 2019, which
Justice
I referred
Mukherjee.
to, your lordship, which involved issues relevant for deciding the present application. It is clear from the judgment that the learned judge was of the view that the company court retains jurisdiction over winding up petitions which were filed before the IBC came into force. In that view of the matter, The court held that the official liquidator acting as the provisional liquidator could retain the symbolic possession of the assets and properties of the company in liquidation. It was also decided that questions of title to the flats were declaratory in nature and could hence only be decided by this court. This is one of the issues, Your Lordship. The important part of the judgment, however, is the point of time when this court reasserts its jurisdiction for deciding the issues related to the company. This court is informed that the corporate insolvency resolution professional commenced in March 2019. An order of the NCLT Kolkata bench dated 12th February 2022 records that the CIRP period of 330 days was completed on 5th February 2020. And that one more opportunity for resolution of the corporate data, the company in liquidation, was being given, and 90 days was excluded from the CIRP period. The resolution professional was directed to complete the entire CIRP within 3 months from the date of the order. The order also mentioned that no further extension or exclusion would be allowed. It is clear from this order that the date for completing the CIRP finally came to an end on 12th May 2020. This would also be reinforced from the submissions made on behalf of the resolution professional that no resolution plan has been received from any quarter till date. This court has been informed that numerous intending flat owners are in the same position as that of the present applicant. The order of the NCLT dated 12th February 2020 also records 150 home buyers may get affected if order of liquidation is passed. The relevant portion of the judgment passed by the court states that the proceedings pending before the NCLT should be proceeded with until the stage of resolution plan being accepted or rejected. Once the resolution plan is accepted, further orders may be sought for regarding discharge of the provisional liquidator. The learned judge also proceeded to hold that if the plan submitted before the NCLT is not approved or an appeal from such non-approval is dismissed and the order rejecting the resolution plan achieves finality, the winding up of the company in liquidation, corporate debtor before the NCLT, should be proceeded with by the company court. In view of this court,
in the view of this court,
in the view of this court, the operative part of this judgment makes it clear that the company court will again take over from NCLT in terms of passing necessary orders in relation to the company in liquidation once the resolution plan fails or is rejected. The resolution plan has admittedly not seen the light of the day. More than 6 months have passed since the 90 days extension given to the RP in terms of the order dated 12th February 2020 of the NCLT. It is evident that therefore that no resolution plan is forthcoming in the near future. However, since the application of the RP is due to be listed on 15th December 2020,
this did not lay down any ratio. This relied totally on the order of Justice Mukherjee.
But your lordship kindly sees that the last line, at least the flat in question mentioned in the judge's summons being flat 14A of the 14th floor of the building together with additional spaces mentioned in prayer A of the judge's summons should accordingly be preserved and protected for a limited period of time.
Should be preserved and protected does not mean any injunction order is passed on anybody. That's an observation of the court. That's the expectation of the court. But this does not direct anybody to preserve and protect. If nobody does that, nobody preserves and nobody protects, nobody can be hauled up for contempt. I mean, it's an expectation of the court that the flat in question, such and such, should accordingly be preserved and protected for a limited period. But who will preserve and who will protect? This is not a direction on anybody.
Since the resolution professional or the official liquidator are the custodians of the assets, this possibly could
as per the IBC, can it come back to this court at all?
As per the IBC, no, your lordship. But the question is, there was a winding up petition pending before this honorable court. Now the question arises that under the transfer
Aren't
rules,
all pending proceedings hit by IBC provisions?
No, your lordship.
Show me that from the IBC.
Your lordship, I'll have to refer to the transfer rules for that. Your lordship, in
transfer
kindly
rule says that if no irreversible step has been taken in the winding up proceedings, then
No,
it
that
would
is
be
different.
transferred.
That has nothing
Yes,
to
Your
do with
Lordship.
this. Transfer rules is something else. When it will be transferred,
Whether or not it
that
will be
is
transferred
circumscribed by
also.
IBC substantive
Your
provisions.
Lordship,
Transfer rules cannot govern substantive provisions of a statute, central statute, special statute on the subject.
yes, Your Lordship, but the transfer rule not only takes care when it will be transferred, also it takes care that whether at all it will be that particular application will be transferred or not.
Transfer rules, what is the source of authority of enactment of the transfer rules?
It is under the Companies Act. Since
If that be so, the rules cannot override. If the Company Act
parent
itself
agency.
cannot override IBC, then the rules framed under that cannot, by any stretch of imagination. Transfer rules cannot override the provisions, substantive provisions of a special
Your
statute
Lordship,
like
but
the IBC.
In several judgment of the Honorable Supreme Court also, they have dealt with, the Honorable Supreme Court has dealt with whether at all every application has to be transferred. And
That's on a different perspective altogether.
Yes, Your
Whether
Lordship.
any, Supreme Court now it is probably settled that if it's irreversible, unless it's
Yes,
irreversible,
that is so. It's
and
action equal.
and it has lastly been said that not only irreversible, the sale has the sale has occurred, not confirmed or something like that, or confirmed up to that stage. That's on a different footing altogether in normal circumstances, non-IBC circumstances, if I may say so. None of those cases of the Supreme Court IBC was taken into consideration or pleaded even, or argued even.
It is
IBC is a
in this
different
case, Malad,
ball
it's a-
game, if I may say so. I mean, so IBC has a non-obstante clause everywhere. Wherever you can see, it's I mean, spread all over the IBC non-obstante clause.
All is defeated in front of IBC.
IBC is like the
But your
constitution of insolvency.
That is so. But your Lordship kindly considers today, in view of the 12th December 2019 order, which
Take a
has
chance
not
before
been,
a different bench.
Malad,
and
maybe come
that
back after
prayer
the
itself
vacation.
has been rejected, your Lordship. The question of transfer goes out since that prayer was made by the RP by filing an application in this winding up proceeding, and that has been rejected. That the winding up proceeding will be stayed for the time being unless there is an outcome by way of a resolution plan.
As per the IPC, if a resolution plan fails, what will happen?
Liquidation.
Liquidation, your Lordship.
Under which provision?
That is 50
Under-
starting from 50.
Under which act?
IBC only. IBC.
How can we reassume jurisdiction on that? Is it a sort of suspended animation?
You'll,
During CIRP, we don't have jurisdiction.
You'll-
After CIRP, if a resolution plan fails, liquidation will not happen under that provision. We'll reassume jurisdiction
but
under the Companies Act.
your Lordship kindly considers again, this is not a case of a transfer again, because a separate proceeding, a parallel
Transfer is a different concept.
Yes, but
It's a question as to whether we are not, I'm not saying that it's transferred, it comes back here. No. Here IBC comes into play and it's under a different statute. If it was under the Companies Act itself, then I could look into the transfer rules. Definitely everything could be looked into.
Yes.
Because the entire thing is within the aegis of the, under the aegis of the company jurisprudence. But here IBC is something else. It's a different statute. These are rights flowing from different statute altogether, which subsumes every other statute insofar as its operation is concerned.
Lordship kindly considers there is a pending winding up petition before the enforcement of the IBC code. IBC. Now, your Lordship, after the IBC came into force, there is a parallel proceeding which has been filed under the IBC. Not that this was sought to be transferred so that it can be proceeded before the NCLT. That's a parallel proceeding which was
What
taking place.
remains of this? There will be conflicting judgments then.
Your Lordship,
Suppose
now,
if I take up the company petition now and pass orders, go on passing orders regarding liquidation. Even today, if we have jurisdiction, it cannot be suspended till CIRP is over and again we get back jurisdiction. Then if it's a parallel proceeding, then all along we have to have parallel jurisdiction with the IBC, with the CIRP. We have to have parallel jurisdiction with the NCLT. If it is a normal company law scenario, this court could have, if it was not irreversible, we could have retained jurisdiction straight away. Then we would have had the jurisdiction, not the NCLT. These are mutually exclusive. Two forums or two courts cannot simultaneously have jurisdiction over the same liquidation process. Either the NCLT has, NCLT not acting as NCLT under the Companies Act. If that was so, I could have appreciated your submission. Transfer rules would come in. Here, NCLT as an authority under the IBC. IBC designates NCLT as the authority. So under that capacity, NCLT is functioning, not as NCLT under the Companies Law, Companies Act. So forget NCLT or High Court. It's a question of conflict of statutes. Company law versus IBC. Which one will prevail? See the provisions of the IBC.
That. But on a lighter note, Malad, even before your lordship, Malad, whichever company court we used to Malad, come up with this judgment of 2019, all company courts used to express the same surprise as your lordship is expressing. But Malad, thereafter, Malad, since orders
The
have been
difficulty, I am also trying to shirk my duty, probably keeping it after the vacation, not only for you to take your chance, but I'll have to differ with the judgment and refer. Because that is not only a judgment passed in this proceeding, but a citation also, but of binding value on me also. So as a precedent also, then I'll have to probably differ with it and refer it.
Refer it to the last.
Which I want to avoid as much as possible. Committee of Courts.
But maybe come back. Malad.
Maybe come back after the vacation.
And hope and trust that the data.
No, we
should not. Your lordship then kindly keeps item numbers 124, 125, 126 and 127.
Up to 127,
your lordship, and thereafter
164 to
thereafter 164 to 172 and 174.
and
এই
170.
নাম্বারগুলো একটু নোট করে নিন আগে তারপর কমা
Maybe write down in a piece of paper and hand it.
Please do that.
কত কোন আইটেম নাম্বারগুলো সব লিখে দাও।
All the matters are taken up together in view of the issues involved being identical and connected. Full stop. Since extensive hearing is required, comma, which is not possible before the upcoming puja vacation due to paucity of time, comma, let the matters be listed together in the monthly list of November 2024.
Function is nothing, but they are holding symbolic position and the documents also. Dear losses, kindly give me hand over documents.
Take the trouble for some more time.
Grateful.
122 কি আপনার?
না
মান্থলি লিস্টে রিফ্লেক্টেড হবে কোম্পানি ম্যাটার হিসেবে মান্থলি লিস্টে দেখানো হবে somebody is interested, I mean, yes, what is matter number 124 to 127 right now দেখিয়ে দিন আপনি 127 4-127 এক্ষুনি দেখিয়ে দিন I'm relegating the matters to the November monthly list. 124 to 127. What are the other lot of matters?
I have handed up you.
But there's one more, 128 is
164 to 172.
128 also relates to this company. But my learned friend is not.
128 who is appearing.
164 to 170.
Similar issues are involved.
পরে হচ্ছে 174.
What happened is, my lord,
176.
I am appearing for the respondent, my lord. My application is item number 129, my lord. That whereby I have paid with your lordship for registration of the car.
Oh, same.
174.
Item number 120. I have heard what say for my lord, my lord. 128, my learned friend is
Conveyance, my lord, to be done.
my learned friend has
already
come up with an application before your lordship asking for dismissal of my application.
So then it has to be taken up along with you.
Yes, my lord. That is what my prayer is, my lord. Kindly, my lord. As
But
my
they
lord,
also have to be heard naturally.
yes, my lord. As my lord is relegating all the matter after vacation, my lord, kindly relegate this two matters.
So up to 129.
My lord.
এইগুলো বাকিগুলো দেখে দিয়েছেন তো তাহলে 120
128, my lord.
বাকি সব দেখে দিয়েছেন এবার 128 আর 129 দেখি
128,
164 to 172
হ্যাঁ দেখানো হয়ে গেছে
164 to 172
164 to 170.
আপনি বলে জোরে জোরে বলে দিন ওনাকে 164 to 172 তারপর বলে দিন বোঝা যাচ্ছে
Item number 164 to 172, item number 174, item number 176, 177, and item number 186.
These are the matters which are clubbed together and sent to the monthly list. And 128 and 129 টা বোর্ডে দেখিয়ে দিন
Item number 128 and item number 129.
May I only point out, my lord, of your lordship's list, From 164 to 186, all relates to this
Why
company.
were only some numbers given? You are appearing.
I believe
not
the
appearing in those matters, but those are
petitioners
similar
in the other
applications.
applications are not present, perhaps. That is why it's not pointed
No,
out.
no. Let them be called on them.
Very grateful, Your Lordship.
Yes. Grateful, Lordship. Thank you.
Yeah,
What-
30 calls.
So please, somebody remain present to point out which are the matters which are. When those are called on, if nobody appears, I'll delegate it to be heard along with these matters.
Along with those matters.
Grateful. Call.
Item number 130, IAG Company Limited.
I'm for the official.
Yes.
Milord, the first one is a disclaimer, Milord, filed in long back.
Yes.
Now, Milord, the second one, Milord, is what is it?
Second one means 131.
Yes, Milord. 131, Milord, is my new application now today.
Which are the connected matter? 130 and 131 only.
Yes, my.
So 131 to board dekhe. Yes. Duty daw.
Item number 131.
Milord, 131 is because 130, Milord, I made a disclaimer application.
Yes.
In that, Milord, the official liquidator, Milord, visited the premises and Milord could not take possession and said, Milord, on the basis of whoever people was there, Milord, filed a report saying there are 6 entities, Milord, who are there. Now, Milord, that report has come before the court and Milord, I have prayed in that disclaimer that let them, Milord, be evicted and this be handed over to me. Now, Milord, a long time has passed, Milord, from 2019. Today, this application, Milord, is on the basis of certain affidavits filed by these 6 entities where they have in the earlier application.
Earlier is 131.
130.
130 was a disclaimer.
Disclaimer.
Yes.
In that application, Milord, pursuant to, of course, direction of the court,
These
entities, Milord, have filed an affidavit saying that, Milord, they are willing, ready and willing to pay me, I am the owner, the rent, Milord, for their occupation. As in occupation charges, Milord.
Subject to disclaimer, of course.
Subject to the disclaimer. And one of them, Milord, have also said there are only 2 affidavits, one by 3 entities and the other by 2. And Milord, in the first one, they say they are willing to pay 32,000 and accept that I am the owner. The other one, Milord, says I have been paying 30,000 to the OL, but if the court directs, I am willing to pay the owner also directly.
This takes care of 2.
This takes care of 5.
Acha.
The 6th, Milord, has not come before this court. So, Milord, I
Served notice and all.
everything done. Everything done. The others have come.
So they have to abide by the result of the disclaimer application.
Yes, but today,
According to you.
yes, Milord.
What is your your right?
The Milord owner of this area.
What was the company's claim in the property?
Company was a lessee. And these entities also, Milord, if your lordship lifts the veil, they are all their people. That, Milord, is evident from the affidavit only. Sub-leases have been created in their names. And Milord,
Company has created subleases.
yes, company has created sublease. But, Milord, there is no registered document for this sublease. Milord, the affidavit also that is filed by the person, Milord, on behalf of 3 entities is actually the vice president of the company who is in liquidation.
Must have been company's employees or something like that.
No.
Not company.
No. So this is the position. Now 131, Milord, is an application that since 2019, Milord, it is pending and Milord, money if being collected by the OL. Since I am the owner, Milord, it can be disbursed as an interim relief. Or, Milord, these persons may be directed to pay in my favor because they are enjoying the property, Milord. I am not.
Ms. Banerjee, the amount which has already been paid.
Post liquidation. If any paid, I don't know. The liquidator has to, Milord, inform your lordship.
Account, yes, paid.
Post liquidation. Now, before that, so Milord, the company was there, Milord. I have other rights. Post liquidation. And one most important thing is, Milord, this property, Milord, it's on the 4th floor. There, Milord, Morning India, Navami, Milord, newspaper companies are being run. Now, they are, Milord, stacking newspapers and waste material in a manner, Milord, which might cause fire hazard. So, also, Milord, that has to be taken care of, Milord. I have a specific prayer, Milord. If they are occupying, they should ensure, Milord, necessary fire equipment. This is an old building. So, whoever, that is, Milord, subsequent.
That's a different proposition. Let us hear the disclaimer first.
The main disclaimer.
Disclaimer first, yes. Your other rights are consequential on that. If you have a right on disclaimer, then the other application can be granted. or
Covering both the Morning India and Awami News.
you are a lessee there?
I have been inducted by the company. Till the OL is seized of the property, I can pay to the OL. I cannot pay to any third party, be it the disclaimer applicant, till it is decided. That is my stand for now. I have made a proposition for paying 30,000. They have come up with a prayer that we should pay 60,000 and directly to them. On what basis nothing has been mentioned.
No, there is a lease, I'll show.
That is there, but the issue is till this issue is decided,
Unregistered
we
lease.
cannot pay to any other entity apart from the OL.
If the disclaimer is allowed, then they become they get the property, then the rest can be resolved between you and them.
Also a suit has been pending before the civil court.
Suit for eviction?
Suit for injunction and declaration eviction, yes.
You have filed that.
I have filed a declaratory suit,
They have filed.
eviction suit. These are also pending activities.
Those will take their own course but they will only step into the shoes of the company.
Right. But as lordship will decide.
Company has instituted that eviction suit.
Company haven't, they have.
They have.
And sublessee, one of the sublessees are set up by the company.
Subject to correction, we are a premises thing.
Yes, whatever else we cannot, the company court cannot decide on the fate of the outcome of the suit or even the trappings of your relationships, jural relationships.
But yes, I bow down to that. But disclaimer, if your lordship holds that I am the owner, and you're in this application itself, my lord, the third party rights, my lord, which are created, my lord, your lordship has the power under this disclaimer application to evict them and hand over possession to me. That is there. That is settled. And from these affidavits, which is why I was pressing for this interim application now, because before the vacation, my lord, disclaimer will take some time.
Interim application, let us hear the official liquidity on the interim application. Yes.
With regard to the collection of rent on account of the occupational charges, my lord, my instruction is that they have not collected from the date of the winding up. I can come up with a report in the form of an affidavit disclosing that whether we have been able to
when the
collect
property
any.
was
And with regard to the disclaimer, they need to satisfy your lordship their right title interest over the property. So that is a different issue.
Let us have that report with the accounts,
Yes, my lord.
with the details.
Let me come back.
That will in any event
Not
have
before
to be
puja.
called on.
After puja.
Lord,
What?
I was, my lord, only playing, my lord, if
31 কোনটা গো? Disclaimer টা কোনটা?
by the sublessees, where they agree to pay occupation charges. My lord, if I can, my lord, show prima facie, my lord, that I am which I have disclosed the rent receipts, that order perhaps.
No, Ms.
my lord,
Banerjee, first let us have the accounts. These two have to be disposed of together. Unless your rights of disclaimer are ascertained, we cannot direct the rents to be paid directly to you. And if I hold that you are entitled to disclaimer, why should I keep the disclaimer pending? That is the reason I'm saying both have to be heard together. Your right of disclaimer has to be the pivot of the court directing these payments to be made to you. You have to have a right of disclaimer.
but subject to what falls from your lordship, my lord, on prima facie basis, my lord, an interim order can be passed. Like, my lord, in occupation charges, when an appeal is pending, my lord, in an eviction suit. These days, my lord, even at trial stage, my lord, occupation.
This is not a question of trial. Only you have to satisfy the court on disclaimer. See.
28 of 19, my lord, is the disclaimer.
Then renumbered his number. CA7 দুটো application একসঙ্গে দেখাবো 78 of 2019 is an application for disclaimer on the ground that the petitioner is the owner of the property and the company is a lessee under the petitioner. First up, it is alleged by learned counsel for the petitioner that the company has granted sub leases to third parties, full stop, pursuant to previous orders of court, comma, the 5 out of the 6 occupants have filed affidavits and substantially agreed to payment of the rent stroke occupation charges to the petitioner. Full stop. It is contended that the application under that CA 11 of 2024 has been filed for interim reliefs to that effect, comma, affidavit data, seeking directions on the official liquidator to disclose any amount received from the occupiers and to pay occupation charges in respect of the occupied properties to the petitioner. Full stop, next para. Since it is required for the official receiver to place before the court the exact amounts which have been collected, comma, in order to effectively dispose of the two applications, comma, the official receiver, official liquidator is directed to file a report in the form of an affidavit, incorporating therein the accounts of all the incomes and expenditures with regard to the properties involved in the present applications. Full stop. Advance copies of the same shall be served on the applicant, on the petitioner. Full stop. The line in view of the right of the petitioner to have the reliefs as sought in CA 11 of 2024 being inextricably linked with the outcome of CA 3 of 2019, comma, that is the disclaimer application, comma, both the applications shall be heard together on the next returnable date. Full stop. The matter shall next be listed on November 7, 2024 for passing further orders.
My lord, in one line, I think so, official receiver,
liquidator.
it will be liquidator, my lord.
Yes.
Lord, one thing, my lord, there is only one property involved. That is, my lord, 2900.
There are several flats. There are several occupants.
Several persons, my lord, it's an office. So they have just
Space.
undivided partition.
Properties যেখানে বলেছি property হয়ে যাবে।
We also get a copy of the
If my lord directs to circulate, then I can
reports the একটা জায়গায় বলেছি copy of the report shall be circulated and served on the petitioner, একটা জায়গায় বলেছি সেখানে হবে on all the other parties, petitioners না।
I would really object to that, my lord, because they are all in hand in gloves.
Let them put the hand in the glove at least.
This is a
So they have a right because the
subleases, my lord.
so they have a right to respond to that. Whether the official liquidator is correct, they have a right to object to that as well as support that. That yes, we have paid these amounts. The official liquidator will say what amounts have been received by him. If they say we have paid more or less, they won't say less. But that has to be taken care of also. So everybody should have a copy. He's right.
My lord, I also have to file a supplementary. The 60,000 lease deed, my lord, by inadvertence, my lord, wasn't annexed.
The supplementary affidavit filed to be kept on record. Copies you have given. Copies thereof also be circulated to the unserved parties, whoever is unserved. Yes. Next. What?
Item number 132, Proyag Das Daga.
Yes.
Your Lordship, I'm appearing on behalf of the appellant over here.
Yes,
By
please.
withdrawal application, Your Lordship.
Withdrawal.
There's a 10F appeal that is pending from
You're
order.
wishing to withdraw the 10F.
Yes, Your Lordship. I've served already.
I appear for the respondent number 2.
You object to that?
No, my lord.
So serious.
Because I won't suffer, my lord, if this appeal is withdrawn. I have succeeded before the company law board.
Your Lordship, the appellants are quite sick and do not want to pursue it since it is pending for quite long time, Your Lordship.
The company is sick.
No, the company.
It's a company.
No, Your Lordship, the appellants.
Learned counsel for the petitioner, on instruction, submits that the appellant seeks to withdraw the appeal under section 10 capital F of the Companies Act 1956 full stop. Accordingly, what is the application? This application is ACO3.
ACO3 of
ACO3 of 20.
The other applications are connected with the appeal.
Yes, your lordship.
Accordingly, ACO3 of 2024 is allowed, comma, thereby dismissing APO 240 of 2016 and all the other connected applications as withdrawn. No orders to cost.
My lord,
Interim
there
order,
was
if any, interim order, if any, stands vacated.
Grateful, your lordship.
Same. 120, 132, these are different appeals. 133 is another similar application.
No, your lordship.
Call Kurun, both are appearing together probably.
Item number 133.
Both are together, your lordship.
So separate applications, separate appeals.
Yes, your lordship.
It's the same.
It's same, your lordship.
same appeal.
It's same appeal, your lordship. Two
application
connected
is-
Oh, yeah, two
applications. are here.
applications.
That other application is a prior
The connected application.
Yes, connected
sir.
application.
Duty action order pass. Wait, 134. Act order. হবে,
Item
act order.
number 1 Lakshmi Narayan Udyog Limited.
Yes, I am for the official liquidator. This matter only for my lord and the official liquidator. No other party is necessary.
I am for the disclaimer applicant.
Not this case.
In the
But
later.
Disclaimer.
Not in this case. In this case, only my lord and the official liquidator. Later for. But in this matter, company was winding up on 9th April 2015. Subsequent order has been passed by the Honorable Court. My lord appointed
Yes.
Mr. Gupta as an auditor from the panel of my lord to investigate in the matter of the company, whether the misprision has been occurred or not, whether due to reason of the ex-director or in usual course of business. Well, he did not do his duty. 2 letter was given to them. He was silent. Then second appointment has been made. He prepared an appointment and filed the same. Say recommend maybe. But meanwhile, problem is that time to file the misprisions has been over in terms of the section. So today I'm asking necessary nothing. If I filed, then but by limits may read out the section. Only this.
This is a 56 Act, obviously.
Yes, 56 my section my lord, 543.
Thank you.
543 my lord. No, got it 543.
Just give me half a minute.
Yes, yes. 543 got it.
543, yes.
I'll put 2 section 2 direct.
2, right.
An application under subsection 1 shall be made within 5 years from the date of the order of winding up or of the first appointment of the liquidator in the winding up or of the miscellaneous application, return and miscellaneous or breach of the as the case may be, whichever is longer. So 5 years is over. That is the situation. I cannot say not to file. I'm asking for the necessary order, only this.
Limitation Act is not applicable.
No, my lord, this 5 years barred. If you file, then they will come say barred. But I can't decide from our office not to proceed, except with the my lord order. So only necessary order, this is my prayer.
This was from counting limitation from which date? In your
Counting
case?
date of winding up. Date of winding up, my lord, is 9th April 2015. If my lord pass the order today, more than $47 lakhs. 43.
The order of the court was to inquire into it and initiate a
I'll-
proceeding under misprision.
Misprision.
For misprision.
Now, after completing the report, they'll file before the official legal official. Then place before lordship first.
When was that order passed?
9th April 2015. The order was passed for winding up. And report has been filed last report.
No, that winding up order itself contained that direction.
No.
When was that direction passed?
That direction passed. There's two directions. My lord. Have annex chair. Kindly come to my lord. First, my lord, annex chair D. Must annexure D page 19.
Yes.
Order of Justice Malar Ashish Kumar Chakravarti. The official legal place for appointment of a new auditor in state of place of appointment
This is
order.
the new auditor only.
This new order, Mr. Ghosh, before Gupta. Ghosh has been filed the report.
No, where is the parent order which directed this misfeasance to be looked into and all?
No, it is not a direction. It is the duty of the official legal to.
Achha, you have of your own you initiated.
No, it is the rules and act. After my company gone into liquidations, I will ask for the leave to appointment auditor from the panel of the official liquidator. He will looked into the matter, filed a report before the official liquidator.
Misfeasance allegation has to be first leveled. When was it leveled?
Level at the last page, kindly. At the last page, the opinion. Last auditor Gupta is filed. Page 50, my lord.
Yes.
By giving due consideration to the provision contained in 534 of the Companies Act and subject to the discretion of the Honorable High Court, we are of the opinion that as per the information explanation furnished to us to the best of our knowledge and belief, executive of the company may be held liable for misappropriation of the funds of the company, read together with our observations in that attached report. The total claim of the creditor claimants as per the statement over filed by the Pankaj Kumar ex-director.
This opinion was expressed when?
This filed on, my lord, date is here. 15 September 2021, at the end. Page 50 at the end, signed.
This report was itself filed after the limitation period.
Yes, but his appointment, second appointment. First director, auditor did not do any duty. Then we wrote a letter to the Malo then. Second letter silent, then we come for second appointment.
But then anybody can collude, the auditor can collude and...
I can't say, Malad. Our duty to appoint auditor from the panel of pilot. First auditor, Malad, did not do. Then second auditor has been appointed. He placed his report. In between this juncture, time as well.
Why didn't you approach the court asking for expeditious direction on the auditor to do it? Because on the ground...
We are upon asking for the second auditor. Second appointment has been made. Second auditor has been filed the report.
When did you ask for the second auditor?
Second matter, the order has been passed this year.
You were aware all along that this would, I mean, this limitation would...
Two letter was given to the first auditor. He did not do. Then the next order has been passed at the last C.
When?
And I placed the order. Well, page 19. The official legal pay for appointment of a new auditor. Page 19, my lord. Order date 24th January 2020. The official legal place for appointment of a new auditor in place and state of one appointed August 17, 2020. Accordingly, C. Gupta and Cook, Chartered Accountant, care of Chandu Ghosha, such and
this
such.
This was also barely within time. 3 months were left only.
3 months left.
So what is the prayer in this application?
Necessary order. I am not decided anything that we not to go ahead with the misfeasance. Then charge you level. I am my lord officer, my lord. I am asking for the necessary order.
Yes, do you have anything to say on this? I mean,
my lord, not only the issue relating misfeasance, the former directors are holding 48 lakhs of rupees in cash in hand, and despite my orders of my lord, they have not deposited the money in
that
with the official
list.
It is in the list.
I am allowed to that.
And
so regarding this misfeasance now being time barred, then there is no scope. I mean, appropriate orders means we'll observe that only, that it is become time barred.
And my learned friend, whatever stated, I have placed my last next matter. Matter is here.
It's something which is unfortunate, but then
I will assist in this matter. Matter is here before your lordship.
There are other glaring issues which will come before my lord when the applications which are being placed by my learned friend here will be placed, and I would...
No, CA 18 is for appropriate orders on the...
Yes.
So what is appropriate order?
My lord, how, on what basis these the money of the company in winding up have been withered away and have been wasted would be seen by my lord, that how they have tried to do it.
No, I have taken step against the ex-director.
Unfortunately,
I shall place. matter is here and I shall place.
Let me decide first, dispose of first CA 18. CA 18 of 2022 has been filed by the official liquidator seeking necessary directions for appointment of an advocate to initiate misfeasance proceedings against the ex-directors of the company. Full stop. However, it is pointed out by the counsel for the official liquidator that in the meantime, the statutory limitation period of 5 years from the date of order of winding up as stipulated in section 543 within bracket 2 of the Companies Act 1956 has expired. Full stop. Whereas the order of winding up was passed on April 9, 2015, it transpires from the record that the official liquidator had appointed a valuer, an auditor initially, who, having failed to discharge his duties in due time, despite at least 2 reminders by the official liquidator, was subsequently replaced on the prayer of the official liquidator, vide order dated January 24, 2020. Full stop. Some amount of disappointment has to be expressed by the court, since despite the lackadaisical attitude of the previous auditor, much time was wasted by the official liquidator in praying for and obtaining an order for appointment of a new auditor. Full stop. In fact, the order for appointment of a new auditor was passed only on January 24, 2020, at which point of time less than 3 months were left for exhaustion of the limitation period. Full stop. Hence, by the time the second auditor filed his report, which is also annexed in the present annexed to the present application, which prima facie indicates misfeasance on the part of the ex-directors, the hands of the court are tied, since the limitation period of 5 years has expired in the meantime within the contemplation of section 543 within bracket 2 of the 1956 Act. Full stop. Accordingly, there is the option of initiating a proceeding on the ground of misfeasance under section 543 within bracket 1 is no longer available in view of the bar of limitation. Full stop. Accordingly, CA 18 of 2022 is disposed of by keeping on record the report filed by the second auditor, which is annexed to the present application. However, without passing any further directions regarding initiation of misfeasance proceedings. Stop. Next step.
Item number 135.
In this matter,
আমি আগে বলে দিই স্যার
no, no.
CA 23 is, my lord, my application.
Yes.
My lord, I have sought for leave to file my claim. It is much delayed, my lord. The order, my lord, the publications, my lord, were made in the year 2016, calling for claims from the creditors. My lord, I had no idea about it, but my lord, the official liquidator has himself admitted that in the records of the registrar of companies, I am reflected as a secured creditor. My lord, there was a flat which, my lord, this company, my lord, my client, my lord, they had advanced certain loans to the company in liquidation,
Yes.
my lord, against which it was secured by mortgage of a flat. It was already recorded that if it fails to pay, my lord, I will foreclose. I foreclosed, my lord, and the property was transferred in my name. Thereafter, my lord, the company went into liquidation. My lord, I took no steps, my lord. I did not even file my claim. I did not come up ahead before this honorable court also. I come to know, my lord, from an order of 22 that this property is being put up for sale. So then I filed an application for disclaimer. It was set aside, my lord, because I come within the period 2 years before this transaction in my favor was 2 years before this winding up. So, my lord, I do not proceed with that application. That application stands dismissed for default. Thereafter, my lord, I have taken out this application for leave to file my claim before the official liquidator. My lord will kindly see, take the judge's summons, my lord. Second, my lord, prayer B. Is my lord what I had prayed. Now, my lord, they have filed their objection. If my lord will kindly take their objection.
Objection, Adab. Yes.
My lord will kindly take page 5.
Hmm.
PB.
Yes.
From the records of the ROC, it appears following our secured creditors, I am number 2.
Hmm.
Now, my lord, they go on to say what are the steps which have been taken. Then, my lord will kindly come to page number 10.
Hmm.
P. It is also pertinent to mention that in an application being so and so filed by one of the creditors was pleased to pass an order directing the respondent to invite claims by inserting advertisement in the papers. Accordingly, it was so done, indicating that the last date of submission of claim was 20th January. In response thereto, only petitioning creditor and an unsecured creditor had filed their claim. Neither my client nor the bank had filed any claim. Now, my lord, he goes on to say further, my lord, that at page 12, paragraph 7.
Yes. The properties have not yet been sold.
They've been sold. They've been sold.
But claim has been settled.
Claim. My claim, my lord, could be
It's a fruitless claim. If it has been sold, the
money I do not think has been fully disbursed. I'm not sure, but I do not think it has been fully disbursed. At least I can file my claim, my lord, and then if my lord, whatever is
if it's a claim infractuous ab initio, what is the use of the court directly?
One line.
I am not sure whether they've disbursed the
But that
entire.
is not a one line.
Let me
The application has been filed after a gap of 6 years from the last date of filing the claim. Now today is touching 8 years. If my lord allowed this application, it will, my lord, prevented the official to take further step in other cases concerned. The order not only.
So, doctor, the difficulties, I mean, the claim is not time barred as such.
No, to filing the claim.
Is there any time bar to that?
Yes, we have mentions in the newspaper. Last date is this, we have to file.
That's not a statutory time bar.
No, that has been asking from the letter for direction you to publication the same last date is this.
That would be irregular, but if the title has not yet passed, then why can't the claim be entertained?
The title has
Maybe
passed.
some costs, maybe.
No,
The title, the property has been sold. The title has passed to the
property. The sale has been confirmed and
completed. The transfer has.
Well, if that will be allowed, I am not taken. Please, I'm not allowed. But if another case will come similar in nature, then
open a floodgate.
that will come. They pass by the company court, not only the honorable judge of the High Court. So company judge, they binding upon us. All proceedings in the next case, other case will be my lord,
Yes,
my lord, first time, my lord, only this. That is not the question.
Connected matter, but I have a disclaimer application.
No, that will come. That will please.
Please, my lord, also
Please.
case my lord, take.
No, please, that matter will come, my lord. But
But
this is not his case. This is not his case. If he allowed, my lord, that
sold, my lord, but my lord,
all
they are
sold,
holding the
all
money.
sold.
Then, my lord,
Claim has
they
been
Your
settled.
disclaimer pertains to the property, not the money.
claim pertains
Your
to
claim is your claim pertains to the property.
this
You are
particular.
staking a claim to the property, which has been transferred in favor of third parties.
My claim is in respect of the money that was due and payable to me by this.
No, originally it was the money, Ms. Rao. Originally it was the money. Till you foreclose the, you foreclose the. Yes.
But
Yes.
now, my lord, it would be in the nature of a money claim.
It cannot revert back to a money claim once you foreclose the claim.
My lord,
And in any event, after 8 years,
my lord, orders have.
Then another case will come on this.
By this honorable court, my lord,
So
where,
the
my
8
lord,
years.
delay has been condoned. When
8 years.
My lord, once I can come back and show, my lord, those orders also. There have been cases, my lord, where it has been condoned. Of course, I should be honest.
The next case, this same order will come before us.
I should be honest.
Office of the official, allow this, why not this?
you should be honest.
In that other case where I had appeared, the property was not sold by them.
It is sold.
After sale, it will be very
Complete, my lord.
rights have accrued in favor of third parties.
already taken possession.
I will not be obviously asking for the property back, my lord, but my claim in respect of the value of the property. The money that was lent in advance, the money that had to be received back by me. I had received part payment. Thereafter, there was, my lord, default in payment. My lord, I have given the chart which shows how much I had received back from
That
them.
is not the question here, my lord.
Where is that?
My lord, it is there in my
No,
application.
you may have had that. After such a delay, the delay itself is a ground for rejection, Ms. Rao.
My lord, that
What prevented you from coming earlier? Have you explained?
disclaimer application, my lord, when I saw that I was not being able to keep them, my lord, that's what.
Disclaimer within the knowledge company liquidation. Disclaimer means with the knowledge of the company's liquidation. You have to pay.
I have made out the case. I have made out the case. I did not. Now, my lord.
Did not know disclaimer application fine.
Made a disclaimer application in connection with this?
Yes.
Particular property, but my lord.
Then
I
within
have
the
done
knowledge
this
company
every
liquidation.
2 years before, my lord, this application petition.
When was that rejected?
That was dismissed for default, my lord, last year.
When?
On the 8th of June 2020.
Anyway, that is neither here nor there.
Page 8, my lord. If my lord will kindly take page 8 of my affidavit, my lord. Is, my lord, the particulars which 35 lakhs, my lord, was due and payable by the company. My lord, the money lent and advanced.
Mr. Dotto, she is now restricting her claim to the money, to a claim on the money. Now, if she does not have a right to get back, why do she say that that should also be closed?
Closed means of only the period. My lord filed an application after a gap of 6 years from the last date. Now today is 8 years touching.
When did the sale take place?
Last year.
Last year. Therefore, if she claims the money, money claim would not be time but from the sale at least.
Not sale. He lodged his claim before the official.
Why should we preclude her from lodging a claim at all?
Lodging in the sense time. After 8 years, if he entitled to lodge his claim, this order will be binding upon us in all cases. By the order of the company court. Yes. No. Anybody will come in another company in liquidations. Anybody will come in another company, same case, will show the order before us. Office of the official. We're binding. Not only honorable court order.
It will remain open forever then. It will remain open forever.
Ever, right. But because company judge, not only other judge.
No, Ms. Rao. I'm not satisfied with the reasons. There is no reason at all offered by for the delay.
Then everybody will come. Everybody will come.
When I had come to know that the property was being put up for sale, my lord.
You have come up with this application after 8 years from the
6 years. Then
no, the present application has been filed for release of the property.
No, my lord. Only to file my claim.
That is your caption. This is CA 23.
Yes.
Yes. You have captioned it as for release of the property.
I have captioned, my lord, petition, my lord.
Yes.
My lord, if my lord will take the judge's summons, my lord, prayer B.
Well, file this application, captioned as one for release of the property belonging to a third party. However, the judges, however, in prayer small b of the judge's summons, the prayer has been restricted to leave to file claim before the official liquidator within 7 days or such time as directed by this court. Learned counsel for the petitioner submits that although there was some delay in filing the present application, the petitioner had a legitimate claim against the company in liquidation. Initially, the subject property was kept as a secured asset for a loan taken by the company in liquidation. Thereafter, the petitioner foreclosed the loan in view of non-payment of the dues by the company in liquidation. Thereafter, the petitioner had made a disclaimer application, but the same being filed within the statutory period, was not maintainable in any event. Full stop. Ultimately, the said application was dismissed for default. Full stop. Thereafter, the present application has been filed. Full stop. Learned counsel for the petitioner argues that although the subject property, comma, which was a secured asset of the foreclosed mortgage, has been sold, transferred in favor of third parties, comma, the petitioner has a legitimate claim to the consideration money which has been received by the official liquidator on such sale. Full stop. Next parallel, counsel for the official liquidator squarely opposes the application and submits that the same has been filed after 6 years from the claim being published, from claims being invited. Full stop. Next para. It is submitted that by now, comma, the subject property has already been sold conclusively in favor of third parties. Full stop. If the present application is entertained, comma, it is submitted that it would open an unnecessary floodgate, comma, thereby giving a premium to claimants who lack in diligence. Full stop. Upon a careful perusal of the application, comma, it transpires that no satisfactory explanation has been given by the claimant for coming up after 6 years from claims being invited. Full stop. In the event the present application is allowed, comma, after the conclusion of the sale regarding the subject matter, regarding the subject property, comma, it would undoubtedly open a floodgate. Full stop. Next para. In such event, comma, no proceeding would ever attain finality at any point of time. Full stop. In any event, comma, since the petitioner claims to have foreclosed the loan mortgage, comma, cannot now revert back and make a money claim at such a belated stage. Full stop. Accordingly, comma, more particularly in view of the inordinate delay in making the application, comma, CA 23 of 2023 is dismissed without an arrest to cost. Sorry.
Next case, may I first then? Next case, we have taken all the properties, sold it out, and money with us. Claim has been adjudicated. Only 2 claim is left. That is money claim. One from bank and one from the 2 ex-director of the company liquidation. In ex-director and company liquidation, my lord, please to pass an order to serve a notice to pay the dues along with interest with certain.
Mr. Sanjay is there.
So I'm for the petition. I'm for the petitioning credit.
Well, my lord.
Yes.
That I have served bank and the ex-director. Last occasion, my lord's order to file an affidavit, short affidavit to that. But I have, my lord.
Affidavit of service.
Affidavit of service served them.
They have been served properly.
Yes. In bank case is here, in director is concerned, directors as well as their advocate, both. They failed. Next option before us to come before you lordship letter for directions to appropriate order against the ex-director. Now bank is here, what a
bank is?
Bank is before your lordship. I'm ready to
Union
submit.
Bank of India in the instance case, my lord. What has happened, the SARFAESI action was initiated against the company before the winding up proceeding was initiated.
Yes.
And in 2012, the property was put up for sale. And my lord, the one company, my lord, the RISI Export Limited and RISI Art Limited, they made a bid, and they were successful bidder, and they have paid 25% amount to the bank, but subsequently they couldn't pay the balance amount, and that is the reason for which that 25% amount was, my lord, forfeited in pursuance of the Rule 9(4) of the SARFAESI rules, my lord.
Yes.
And that was done prior to the liquidation. So, my lord, there is nothing remains in respect of the liquidation in company.
The asset still remains. It has not been transferred to anybody.
My lord, the amount.
You say the claim is conclusively, I mean, the SARFAESI proceedings.
The amount which was, my lord, forfeited by the bank, that was done in the year of 2012, when the winding up application was not filed.
The amount was forfeited means the amount of earnest money deposited, not by the company but by a third party proposed purchaser.
Yes, the proposed
so how does that affect their rights? I mean, I don't understand this.
No, my lord, they are asking for that money, which was,
you took measures under 13(4).
Yes.
That measure has not attained finality. That has not culminated because the sale did not take place. One bidder came,
take place, but bid,
sale did not take place. This property is still not sold.
no,
The bidder could not pay the amount, therefore you forfeited. So the property still remains with you.
the subsequent thereto, my lord, the company went into liquidation and the property was under the custody of the liquidator.
Yes.
Not with the hands of the, my lord, so, my lord, the 25% amount which was deposited prior to the winding up proceedings, my lord, that was forfeited in part.
No, what have you claimed in this? What is the application for, Mr. Datta?
Asking for that amount.
25%.
25% amount as they have, my lord, get information from the director. And my lord, thereafter they filed a writ petition also. That writ petition was also rejected against the forfeiture. And
Under the Surface Act, what is the law? I mean, you are the creditor.
I am the secured creditor. My lord,
Yes.
I am entitled to put the secured.
You say that forfeiture, upon forfeiture, that amount that has attained finality.
After liquidation.
Prior to liquidation.
Then after liquidation.
Prior to or after?
Prior to.
Then after
My lord,
liquidation happened.
Entire incident was happened in the year of 2012 when there was no such winding up application even.
Application.
Yes, Mr. Datta, what do you say? This is a.
My lord, may I?
So, Bizarre, my lord, I can file an affidavit.
My lord,
Or
may
if you-
I think, my lord, what I understand correctly in this matter, that the money is that of Lakshmi Narayan Udyog, not of Rishi. And my learned friend is talking of Rishi Udyog, which is something which we are not able to understand.
And Lakshmi Narayan is the?
Company is the company in liquidation. And my learned friend is talking of Rishi Udyog.
He says that Rishi Udyog is a third party
Is
which
Rishi-
participated in the bid.
So if Rishi,
That money was
if
forfeited.
Rishi Udyog's money is being forfeited, how could Lakshmi Narayan Udyog's money get forfeited? Am I making myself
No,
clear?
no, no. Apparently, that 25% which was forfeited by them, that is the official liquidator is taking a claim to that.
And it has come to honor from the ex-director of company liquidation.
To that.
How am I making myself clear, my lord?
No, I am not being able to make myself clear. Probably here the bank claims that the bank is the creditor. Much prior to the liquidation proceeding, the winding up proceedings, the bank had taken measures on the 13th, and that sale had failed. They forfeited that amount.
They forfeited the money.
So they are entitled to, as creditors, they are entitled in that capacity.
But
Honest money, honest
the earnest money
1 crore.
of over 1 crore is purported to be forfeited. Now, but we are talking of Lakshmi Narayan Udyog Limited, whereas my learned friend is talking of Rishi Udyog.
Rishi Udyog was the purchaser, the proposed purchaser, the bidder.
Purchaser.
But as far as I understand, if Rishi Udyog was a proposed purchaser, then the money which has come to the...
That's not a consideration amount. That was an EMD which was forfeited by the creditor under Rule 9(4).
But we are right now we are talking of money which was deposited by Lakshmi Narayan Udyog with Corporation Bank for putting in some bid.
No.
My
Corporation
now this.
Mr. Datta, are you taking claim to that forfeited amount?
Yes, we have intimated from the ex-director of the company that 1 crore EMD is with them. You ask them, what is the details? We don't know. Now just the submission has come. Till later, no reply. Till date.
So then they have to file an opposition.
Very
That EMD is in respect of what we have to know.
4-6
But if what Mr. Chaudhary says is correct, then you don't have a claim to that.
File, I am ready to deal with it. What is there? I'm ready, my lord. First time this submission
Let
oral
them
has
have a copy of this, my lord, the report or whatever it may be. Because I
Report?
do not have any copy.
Ex-directors, that has not been annexed anywhere.
report.
The source of your knowledge.
The writ,
That is
the writ
130
which
to
was
130.
filed by the ex-directors in this honorable court. And thereafter, the official liquidator was directed to step in the shoes of the ex-director.
Statement of report one has only placed before lordship.
Those papers also have to come before the court, Mr. Datta.
Already I filed statement of affairs. In your last occasion, the
কোথায়
order
সেটা?
was passed against the ex-director.
বসে আছে তো না?
Another is me with me. One we have already filed.
Please throw a copy to my officer.
দেখুন এরকম একটা আছে। CA না, এটা
It
report.
was a writ petition number 150 of 2014.
No writ petition.
So you are aware or
Company
of this?
So we are confusing things. 2014, that direction was given. Pursuant to that, probably the directors they gave a report or the directors ex-directors gave a report. But the report reflected money which was forfeited by them prior to the winding up. That is what Mr. Chaudhary is saying. That was done in 2012. The direction was of 2014, but the money was forfeited long back. So therefore, the report date is irrelevant.
Maybe
Let them
may-
file
if-
affidavit,
let
ready to
them
take.
let them file a formal affidavit to that effect so that
Yes.
the
Learned counsel for the official liquidator submits that pursuant to an order passed in a writ petition, comma, the ex-directors of the company in liquidation filed a report from which it is evident that an amount of EMD to the tune of rupees 1 lakh, 1 lakh,
1 crore,
1 crore,
1.3 crores.
But it is
That
not
was the 25% amount.
1.3 crore.
1 minute, 1 minute. It is not reflected in the Mala statement affairs. We personally crossed rule 130. Then he disclosed before us, before the official record, 1 crore.
Who disclosed?
The ex-director of the company record. On that basis, we wrote a letter to them. But cash in hand and we disclose.
কি বললাম last? না, in amount of টা থেকে কেটে দাও। From which it is evident that some amount of money was lying with the respondent bank, full stop. Subsequently, it was disclosed that an amount of rupees 1.3 crore was lying with the respondent bank, full stop. Learned counsel, the company, the official liquidator stakes claim to such amount, since according to the official liquidator, comma, the same comes within the purview of the assets of the company in liquidation. Full stop. Next para. Learned counsel for the bank contends that much prior to the filing of the winding up petition, comma, the bank, comma, as a creditor of the company in liquidation, comma, had initiated proceedings under section 13 within bracket 4 of the SURFACE Act and had conducted an e-auction for transfer of a property which was the secured asset of the mortgage of the loan, full stop. However, comma, the sale did not come through as the successful bidder, comma, who had deposited an EMD to the tune of rupees 1.3 crore, comma, which was 25% of the price, comma, did not deposit the balance in time, full stop. Thus, comma, the bank forfeited the said amount of rupees 1.3 crore. It is contended by the bank that since the entire episode happened much prior to even the filing of the winding up petition, comma, the right of the bank stroke creditor has attained finality vis-a-vis the said amount of EMD to the tune of rupees 1.3 crore, full stop. As such, comma, the same cannot form a part of the liquidation assets, full stop. Next para. In order to bring a proper picture, comma, the respondent bank is directed to file an affidavit in opposition disclosing all relevant facts and annexing documents, full stop. Such opposition shall be filed within November 8th, 2024. Full stop. Reply, if any, shall be filed by the official liquidator within a week thereafter. The matter shall be listed on November 21, 2024 for passing further orders.
My lord, a
CA
copy
number
may be
26. I do not have any copy of the CA number 26, my lord. This matter, my lord.
এটা কি-
I do not know who has filed.
No, this is CA number 23. I was.
23 has
This is 26.
filed by my learned test.
No, this is 26.
for dispersal. I'll serve a copy to my learned friend. I'll serve a copy to my learned friend.
Copies of the affidavit in opposition and reply shall also be circulated among the other learned counsel appearing in the connected matters which are appearing together today.
subject to your lordship partner, I have made a mistake, my lord. The company in liquidation was the bidder. I am extremely sorry, my lord. Company in liquidation was the bidder.
He was absolutely right. Mr.
468,
Chaudhary, the entire conspectus of the order then changes.
Extremely sorry, I have just.
Then
extremely
468, then
How extreme is the sorrow?
No, my lord, because there are
The entire order then goes.
my lord, there are
You treat my officer to by air coat to a cup of tea.
Then my lord 468. Delivery of
No, then it's different.
468 has come to the picture. All handed over to L.
the company in liquidation was the bidder.
I
He
shall
became
make
the
my-
successful bidder. He deposited 25% prior to the winding up proceedings.
No,
Initially.
even then, Mr. Dotto, you are a debtor, he was a creditor. He took measures under 13.4.
Yes. And prior to the liquidation proceedings, there
No, I don't understand. Then what is the question of sale and how did you get that amount?
The Rishi Export Limited was
How again you are bringing in Rishi?
no Rishi because of the fact now Rishi Export Limited was the borrower. Was the borrower? His its account was
The company was a bidder.
Company was the bidder. Company was the bidder, and his company's bid was accepted by the bank. 25% was deposited by the company in liquidation, and they could not pay the 75% balance amount, and that is the reason.
Even then, Mr. Dotto, then that has attained finality. It's
Let them file, my lord. I have heard first time. I have heard from my ex-director 130 rule 130 personal. Then I wrote a letter. Nothing has been first time there.
My lord,
Let them file.
there was a proceedings, 13.2 proceedings, 13.5 proceedings. There was a stay by DRT. During that period, the winding up petition was initiated here. There was all those proceedings had initiated during.
I'll just record his submission. He's saying that prior to the winding up being filed, this happened.
And thereafter 468 got affected, and there
that will
and
raise-
during this period we
2012
This is prior to that.
Yes,
I-
2012 the entire proceedings was
my lord, I wouldn't. That is the precise reason. I would rather have Mr. Chaudhary's client file a short affidavit to that effect, and
Acha,
then we can have a.
CA26 is ছোট করো।
468 will come to the picture.
The petitioner, the official liquidator, stroke petitioner, stakes claim to an amount lying with the respondent bank, which, according to the official liquidator, is a part of the liquidation assets. Push up next para. Learned counsel for the bank submits that in a proceeding under section 13 within bracket 4 of the Surface Act initiated by the bank against a borrower, one Rishi Udyog,
Rishi Export Limited.
one Rishi Export Limited, comma, the company in liquidation had participated in an auction sale and had deposited an EMD to the tune of rupees 1.3 crore.
My lord, 1.03 crores.
Pardon?
1.03 crores. My lord,
1.03 crores on 11 June 2012.
1.03 crore, comma, which was 25% of the price. Full stop, next para. Subsequently, the company in liquidation having failed to pay the balance consideration, comma, the EMD to the tune of rupees 1.03 crore was forfeited by the bank in terms of the conditions stipulated in the auction notice. Full stop. The entire episode above took place in the year 2012, comma, which is much prior to the filing of the winding up petition. Full stop. Accordingly, the bank argues that the rights of the bank to the said amount has attained finality, and the said amount of money is not a part of the liquidation asset. Full stop. In view of factual disputes having arisen, comma, the respondent bank is directed to file an affidavit in opposition within November 8, 2024. Full stop. Reply thereto, if any, shall be filed by November 15, 2024. The matter shall next be listed on November 21, 2024 for hearing. Full stop. Copies of the opposition and reply shall be circulated among the learned advocates appearing for the parties in the other connected matter which are appearing today along with the present application. Thank you.
Let my lord send a copy of
my lord, CA 26 is my application, and my application also seeks.
Now, this was CA 26.
Yes, my lord. That is my application, and I am seeking some dispersal of the money. Which
No, no.
is
What did I dispose of right now then?
This is
Not dispose of. I mean,
It's not disposed of. It's still
Well,
pending.
cannot dispose like that way. Well, to come with a letter for directions. Other criteria, settlement of.
no, no. I passed the affidavit direction in CA 26.
It's 26.
One only bank. Two letter has been given from our
No,
part.
but unless the rights of regarding the that money are decided, how can you get any share in that?
এখন হবে না,
It does not belong to the company in liquidation, and you are asking for a.
And money is lying with them like director. I have come before a letter for direction, 85 lakhs. Then you come to our hand.
That's a different amount.
No, if asking money disbursement, disburse cannot
Today,
piecemeal.
as far as save and except for the petitioning creditor, there are no other creditors of the company in liquidation. Of the claims which my
Mr. Dotto, what is your defense to this? Their claim? They are the only secured creditor, they say.
You cannot.
there are only
No, whatever amount is lying.
But if the claim has been settled by us, secured creditor, unsecured creditor, stat, whatever may be, subsequently after getting all the money, we pro rata basis fix them. We filed a letter for direction.
No, you don't admit then that they are the only secured creditor.
No, no. Not only this creditor, other creditor also there, except from secured.
Secured creditor, acha, very well.
Cannot pay. So I come before your lord without the leave of the can't. A pro rata basis.
Should I record that? Your prayer and.
my learned friend.
Time like will entitle. I'm not saying some
No,
time.
no. What is the entitlement that has to be decided?
But it depend upon money. If more money will come, we'll get more money.
That is what I have been trying to assist my learned friend to get more money.
What is it? What is it?
That is my entire effort has been make sure that Mr. Dotto gets some more money so that I get more money. That's my effort which I have been doing.
Shall not record any refusal of that. Not. Any other application? Correct.
My lord, there is one more issue which was there. If the directors do not come over and make payment, there is an office of the director which is in the possession of the official liquidator.
Achha, what is the sanction, Mr. Sanjiti, if they don't come? Under the law, what can the court do? How far can the court go?
There will be the official liquidator has to apply for a letter for direction, and if they thereafter also they do not come over,
Then arrest.
Then
How far can we do? What can we do?
May I assist one letter? Letter for direction was passed. They did not turn up.
What can be done after that?
Yes. Justice Kapoor passed the order. That is there, and before this,
How far can we go? What can the court do? What is the utmost limit up to which the court can go? What directions can we pass on the day? That is what I'm asking you.
issued, then they will come before your lordship, and they.
Can I issue a warrant on that also?
Yes, ma'am.
Already passed.
Warrant issued?
Yes.
Once a warrant.
They release with a condition that they will file the statement of affair within such and type and disclose all the things before the official. They did. They assured after receiving the letter to the official.
Then a fresh warrant of arrest has to be issued.
Yes.
So should I pass that order now or?
No, I have come with the application.
Oh, that application is.
It's not that application separately.
File it.
Yes, yes. Last date come before your lordship.
Is CA 27, what is your?
It's two things.
My position is, my lord, I argued on the last date, my lord. It is, my lord, in a nutshell, the facts are, my lord, I purchased a flat, my lord, from one individual person, namely, my lord, the George. Now, my lord, after purchase of the flat, my lord, one fine morning, when I started living there, one fine morning, my lord, the police comes and, my lord, disposes. My lord, I make an inquiry. My lord, before purchase of the flat, I had done all the title searches. Nothing was revealed, no dispute.
It was a concluded sale in your favor.
It was a concluded sale, registered, everything. My lord, I was living there. I was dispossessed from that property at the, my lord, instance of the official liquidator. That was what was informed to my client. My lord, after inquiry, it transpired. My lord, the facts are like this. My lord, there was a previous sale deed, my lord, which was shown to me. I have annexed them in my application.
Yes.
My lord, the person who was selling me was the owner of the property. My lord, in the previous sale deed, my lord, and my lord, according to that, my lord, and after being satisfied with the title searches, I purchased the property. My lord, I conducted my due diligence. My lord, what transpired, my lord, this.
Have affidavits been directed in this application?
Not yet.
Then I'll direct affidavit. It has to. What is your defense basically, Mr.?
Page number 120.
If you have a solid defense, only then I'll direct affidavits. Others.
Audience.
Not point it out.
120.
120.
No, I'll direct affidavit. I'll not decide it finally. I mean,
I mean, 1-2 order has been passed on.
yes.
I've got it.
What does it say?
27 June 2019.
Yes.
And next page,
Mhm.
1-1.
Hmm.
Last page. As such, there will order in terms of A, B, which are reproduced below. The Honorable Court declared the conveyance as
This is their conveyance.
yes.
My lord,
No.
kindly, my lord, take the previous paragraph. He's skipping over.
Please, B. Oh, I'm come to the order, specific order. Leave may be granted to the officer to sell the flat in question as is where is order basis for the purpose of division. With publication made, creditors came, open court it has been sold and confirmed in favor on my lord on 26th June 2023. And position has been taken over, money has been received. Open court.
What remains in your
Sell paper. That opportunity could have come 19 to 2013. No, they have come. They did not challenge the order.
My lord, I was not a party to this proceeding. My lord, I only came.
No, he's right. In the absence of a challenge to this order, this has attained finality. And this has been given effect to also.
Argue on the point of my lord, actus curia nemenem grevevit. Lordship may or may not recall. My lord, on the last occasion.
Actus curia cannot be pleaded on law.
My lord, it can be pleaded. My lord, there was a misleading.
Actus curia nemenem grevevit, yes. Factually, yes, it can be.
Kindly takes, my lord, that paragraph, my lord, page 121. My lord,
Then no appeal would be filed. Everybody would come and say actus curia nemenem grevevit, and I'm reopening the order. This is attained finality.
My lord, desirous of my lord, rejected my lord, and filing of an notes of argument. Lordship, although it has not gone down, but I have entered, my lord, in a nutshell, the facts have been enumerated, and my lord, I have relied on certain judgments. My lord, on multiple points. But first point, my lord, kindly please, my lord, he has reviewed the lordship, the order starts from page 120, kindly take 121. My lord,
Yes.
second paragraph, he refers to disclosure.
He means your counsel.
My lord, it is, my lord, the official liquid.
Achha.
It refers to a disclosure later dated 19th March 2015 issued by the company prior to its direction of winding up, whereby wife of a director, my lord, the name person I, my lord, named right now, wife of a director of the company was nominated to be purchaser of the unit on categorical statement, kindly notes, categorical statements made that the company has paid consideration of 21,50,610 in full. My lord notes the words in full. It is on this nomination that the said indenture dated 22nd March 2015 was executed, conveying the unit to the said person, consideration for which was paid by the company in liquidation. The facts and circumstances appear to satisfy provisions of 531. This court declares the nomination and conveyance pursuant thereto invalid. Only 2 pages. Kindly takes page 35 of my application. Lordship will file, that particular nomination which has been referred to.
Mr. Dottu, would you like to use any further document?
Yes, 1 to 4.
Otherwise, no affidavit is required again.
Page 1 to 4. Page 1 to 4, order 3rd February
21 lakhs. But the flat was costing.
Yes, but in the absence of anything to challenge this order, this has attained finality. That is the difficulty.
Only 1 to 5.
Incorrect statement of fact made in the court.
That is an argument which has to be decided on merit. That we cannot reopen this like this. No. There is no appeal against this. You could have filed a belated appeal. Third party can file an appeal with a leave of court.
Take to correction, my lord. I do not need to go to the appeal, my lord. This court has inherent power. My lord, this is my lord one, my lord. This is my lord inherent power, my lord, under the principle of my lord restitution. My lord, from which my lord flows the principle of actus curia. And my lord, second, my lord, this is my lord, irrespective of the determination or the jurisdiction, my lord, this is the High Court. My lord, Article 215 is attracted. My lord, this is a court of record. My lord, the court will not, my lord, perpetuate a my lord wrong or my lord illegality or
the wrong is if the wrong in an adjudication, then which has attained finality, then there has to be a proper appeal. Then there will be no finality to any order. Court would assume power jurisdiction under citing Article 215.
If it is a byproduct,
why didn't you file an appeal against this?
I can file an appeal. My lord, this court has inherent jurisdiction. My lord, I am supported by Supreme Court's authority.
Page 1 to 4.
I will show my lord the judgment.
Then no affidavit is necessary. I'll hear this on merits. On the next day, I'll start with this application because every day he's coming up when you are not getting time to move your matter.
I can submit the notes of argument today itself. I'm ready with it. Lord, it will assist your lordship. My lord, I'll assist my lordship again.
Well, page 1 to 4.
I'm coming ready for a lordship. Observe.
Oh, Mr. Dotto,
yes.
Before going to 1 to 4, if you don't, please listen to me. If you don't wish to disclose any further document, I'll hear this application on whatever is there. I'll say that you are controverting the, you are not admitting any of the allegations. So he's ready with his written notes. Should I take his written notes and hear you on the next date? You also bring your written notes. I'll keep it on.
Lordship,
This official liquidator has taken the paisa in
You are
2000
represented, sir, by counsel.
Well, that is page 125, 124, 125, order.
My lord.
3rd February 2023.
Yes, I'll hear you, not like this.
Next, 125, next, pursuant to an order, dated 14th May 2015, the official had visited the aforesaid flat on 14th May 2015 and had taken actual physical for the same. However, since the flat was situated at a building complex, had chosen not to engage in a security guard. Therefore, in order date 2022, this court had directed the official to sell the asset.
So you have completed the sale.
Yes, my lord. Property is handover, deed of conveyance made.
Where do I get that?
Where the subsequent 26 June 2030, next page 1.
It's there in these annexes only.
After this order, my learned friend has taken.
I'll put it at the top on the 3rd of October. I'll decide this. Next Thursday. Yes. It is CA 27 of 2024. Since oh yes, absolutely. I'll direct. He'll definitely give. In view of the relevant documents being substantially annexed to the present application itself, comma, no affidavits are required to be directed. Full stop. It is as such deemed that none of the allegations made in the application are admitted by the respondent. Full stop. The brief notes of arguments filed on behalf of the applicants be kept on record. Full stop. The matter shall be placed in the list, placed at the top of the company matters list on October 3, 2024 for hearing of parties. Full stop. The official liquidator shall file his written notes of arguments as well on the said returnable date. I'll take this matter up. Copies of the written notes of arguments have been handed over to the official liquidator. Full stop. The official liquidator shall also serve copy of the proposed written notes of arguments in advance to the learned advocate for the applicants.
Yes. I shall also file a short.
But he is the
You don't have any locus.
My lord, I will assist my lord.
He is the affected party.
I'll assist my lord to
affected party.
Well, then take copies from the official liquidator.
I have given.
There will the petitioning creditor shall also be entitled to advance arguments and file written notes of arguments on this application on the next day. Yes.
Successful purchase.
To item number 138, it's the ex gratia matter. The High Court liquidator kindly grant leave so that they can disburse money.
You are the employees.
I'm for the employees. I'm for the liquidator. High Court liquidator.
You want to disburse to whom?
The employees.
Yes.
Leave may be granted so that we can. As per
Item number 138.
Because of the pujas.
as per judges summon A and B, prayer A.
We will view the nature of the application, comma. The matter, the same is taken.
I have annexed the previous year order also, my lord. It's at page 10, my lord.
The present application has been filed seeking leave for ex gratia payments being made to the ex-employees of the company in liquidation.
For the employees, my lord, not ex-employees.
For the employees, ex-employees.
They are casual.
For the casual employees of the company in liquidation. Full stop. The said application has been made keeping in view the upcoming festive season. Full stop. Being satisfied with the grounds, comma, CA 53 of 2024 is allowed, comma, granting leave to the assistant court liquidator, to make payment of ex gratia 2 months basic and GP plus rupees 9,000 within bracket subject to maximum of rupees 27,000 bracket closed to Sri Amit Chandra Sinha and Sri Ashim Kumar Das, comma, LDCs, comma, Sri Keshav Rajvangshi and Sri Deepak Kumar Das, comma, caretaker. Eta set out. Next para, leave is also granted to the assistant court liquidator to withdraw a sum of rupees 1,26,000 from separate impressed cash account lying with the State Bank of India for such purpose. First step. It A and beta. I've just dictated the substance of this because A and B would not mean anything after say 5 years because the records will not say anything. It A and beta good kore. Thank you. Yes.
Item number 75 in today's list, examination of judgment debtor on the original side. Your lordship has issued a warrant of arrest against the judgment debtor for personal appearance. He is present today in court. So kindly
Is the other side notified?
I just received it like 15-20 minutes back. His
No,
warrant-
other similar matters I've taken up at 2 and past orders, but now I cannot do anything. You have
the
to give
warrant
notice.
may be recalled and
No.
direction can be given for his presence on each and every.
No, you should have come earlier. Now, after 4:30. No, you have to give a notice to the other side.
Item number 81.
You come back tomorrow. Give a notice to the other side. Come back tomorrow. I'll record you that you are present, and I'll do that.
I'm not asking for any preliminary.
He was there before you. Yes.
81. One of the personal appearances, dispense with my officer is appearing.
Without hearing it, no.
My learned friend is other side.
You are appearing in this matter.
Orunduti man.
Oh, no, I don't have. Yes, I am.
No, not like this. Yes. What do you say?
Item 146 is also for disbursal. I'm not asking today, but next day.
No. On third mention when I sit. Yes.
He's coming from Gurgaon.
What can be done? Why didn't he come on the first occasion? Why did I have to issue warrant of arrest in the first place?
No, the warrant of arrest has not issued. Only personal appearance.
Personal appearance was directed in contempt, in connection with contempt.
No, execution proceeding.
Why was personal presence? For being examined?
Yes.
I cannot pass an order like this.
I am appearing for other side.
Then I can pass an order.
But the only thing is, I don't have any instructions today, but they said they are talking about a settlement.
Yes.
If we bring the money tomorrow, let them pay, and
No, not tomorrow. I'll keep it on 3rd of October. The matter is which item?
81.
81 non-commercial.
Non-commercial.
81 non-commercial.
And it is only after
একবার দেখিয়ে দিন।
your lordship's order, my lord, they are today willing to pay. So, my lord, this order has made some effect. It should be
The
paid.
matter is mentioned out of turn. So it is submitted by learned counsel for the award debtors that his award debtor number
Only one outdated.
that the award debtor is personally present in court, comma, full stop. Since the award debtor is coming from Gurgaon and the matter could not be taken up today for examination of the award debtor, comma, learned counsel seeks dispensation of personal appearance of the award debtor for the time being. Full stop. It is also submitted that the award debtor is willing to settle the matter. Full stop. The matter be listed on
After vacation, with your lordship.
November 14, 2024 to enable the parties to explore the options of mutual settlement. Full stop. In the event a settlement is arrived at, comma, leave is granted to the parties to mention the matter for earlier inclusion in the list. Full stop. However, comma, in the event settlement fails, comma, the award debtor shall be personally present in court on November 14, 2024 for being examined by the award holder.
Lordship 141, I was carrying the pay order in my hand. If next Thursday we can appear at the top, my lord, the liquidator is here, 141.
You want to pay to whom?
To the liquidator to settle all the claim of the company in winding up for permanent stay. In next Thursday and not today.
Not like this, Mr. Sharma.
No, the next
Thursday, I
third-
fixed the matter at the top. The other
After
matter.
that, it will not this after that.
Next Thursday, it is second matter.
Second item 141 of the non-commercial.
This will be the second matter. Yes.
Lordship, item 78, Lordship, I am for the award holder, Lordship. Award holder is a 82 years old lady, Lordship.
This will be the third matter.
Good.
Grateful, Lordship.
কত নম্বর?
My lord, 140. my lord.
নাম প্লিজ ওয়েট, নাম্বার গুলো নিচ্ছেন তো আপনি?
হ্যাঁ,
সেকেন্ড যেটা বললাম, এখন থার্ড যেটা বললাম ওনারটা আপনি একটা কাগজে নোট আর ওরটা নিয়ে নিন, ওনারটা নিয়ে নিন। থার্ড
fourth madam,
Kindly add 140, 140.
থ্যাংক ইউ।
Grateful, Lordship.